get started, I'll just make a quick note. These doors behind us are going to remain closed and locked during the proceedings. The doors just behind you all are open. If you need to get up, use the restroom, go have a conversation, make phone calls, that's the direction you want to head. With that, we'll go ahead and get started. I call to order the Indiana Election Commission meeting, public session. Today's date, Tuesday, February 27th, 2024 at 10 a.m. Conference room B here at Government Center South. The following members of the commission are present: myself, Chairman Paul Okeson, Vice Chair Susanna Wilson Overholt, Member Karen Celestino Horseman, and to my right, Member Litany Pyle. I also recognize the Indiana Election Division staff, Co-Director Brad King, Co-Director Amy Nussmeyer, Co-Counsels Matthew Kochever and Valerie Warcha to my right. And again, our good friend, court reporter Maria Collier from Stewart Richardson Deposition Services is joining us once again. And before we go on, I'd like to remind everyone, for purposes of getting the record straight, if you are providing any testimony or interaction with the commission today, please speak clearly, state your name, and then spell it for the court record. With that, we'll move on. You have documentation of the open door law. I request co-directors have given proper notice. Mr. King.
Mr. Chairman, members of the commission, on behalf of myself and co-director Nussmeyer, we certify that notice of this meeting was given in compliance with the Indiana open door law.
Thank you. Next, we have approval of our September 22nd, 2023 commission meeting minutes. I recognize the co-directors to present the minutes.
Mr. Chairman, on behalf of myself and co-director Nussmeyer, we present to you the September 22nd, 2023 Indiana Election Commission minutes and recommend them to you for your approval.
So moved. Thank you. Is there a second?
Second.
Any discussion? Hearing none on the minutes, all those in favor signify by saying aye. Aye. The ayes have it. Minutes are approved. I need to my binder. Okay, sorry. Thank you. Anyone planning to testify today or provide any information to the commission, I would like you to take administration of the oath by Matthew Kochever. So please stand, Mr. Kochever.
Thank you, Mr. Chair. If you plan on testifying before the Indiana Election Commission, please rise, raise your right hand, and say "I do" after recitation of the oath. Do you solemnly swear or affirm, under the penalties of perjury, the testimony you're about to give to the Indiana Election Commission is the truth, the whole truth, and nothing but the truth? Please say "I do."
I do. Thank you, Mr. Kochever. So we have a pretty heavy schedule today with some campaign candidate challenge hearings that we will get to in a moment. Before we're heading into that, we'll take care of a couple of housekeeping items. Campaign finance matters. The commission will consider approval of campaign finance orders from previous meetings, any ratification of settlement agreements regarding campaign finance violations. I recognize Ms. Taylor and Ms. Thompson from the Election Commission campaign finance staff to present these matters.
Mr. Chairman, members of the commission, behind your campaign finance tab in your binders, there's a list of committees that are ready to ratify, that have agreed to pay the settlement agreement and waive a hearing.
Was there a motion to ratify the campaign finance settlements as presented?
So moved.
Second.
Having a motion and a second, is there any discussion on these matters? Any questions? Hearing none, all those in favor signify by saying aye. Aye, the ayes have it. Matters are settled. Thank you. Next, we'll establish the, what's that?
Adoption.
Oh, we have adoption of the orders?
Yes, Mr. Chairman.
Yes, sorry.
members of the
Thank you,
commission,
Brad.
Orders 2023-422 through 2023-431 have been prepared from the actions taken at the September 22nd, 2023 meeting, and these orders are ready for adoption.
Is there any documentation on this? No. Okay. Is there a motion to approve?
So moved.
Second?
Second.
Any discussion? Any questions? All those in favor signify by saying aye. Aye. The ayes have it. Thank you. Appreciate it. Now we'll move on to candidate challenge hearing procedures. We will now begin consideration of candidate challenge based on the order in which the challenges were filed with the election division, subject to consolidating some challenges which present essentially identical issues to the commission. I remind everyone to identify yourself again when you begin speaking and spell your name for the court reporter.
Mr. Chair,
yes.
before we begin,
Yes.
can we go ahead and get consensus on using the hand stamp for signatures?
Valerie, any concern?
No.
There's a motion to consent. Second. Any discussion? Hearing none, all's in favor? Aye.
Aye.
So we'll do it by consent. And I will say, as I read off these procedures, we intend to keep them. We will run it fairly and efficiently, try and get through the entire list and agenda of cases. So please abide by them, if you will. In the past, the commission has followed certain procedures for conducting candidate challenge hearings, and I move that the commission use the following procedures for today. When each candidate challenge is called, the hearing will begin by recognizing election division staff to provide information about documents provided to the commission members, including candidate challenge forms and the notice given to the candidate and the challenger. Unless there is objection, the documents provided to the commission by the election division will be entered into the record of this meeting. After the election division staff completes its presentation, the challenger will be recognized first. The challenger or challenger's authorized representative, if written authorization was given for said representative and filed with the election division, may present their case for no more than 5 minutes, unless the commission votes to allow additional time for the presenter. Commission members may ask questions during a presentation, but the time spent answering these questions will not be counted against the presenter's time. The election division may signal the chair when the presenter's time is up. If the presenter offers additional documents or other physical evidence not previously received by the division or the commission, the original must be provided to the election division, and I would direct you to Valerie Warcha to my right to hand such documents to preserve the record. The candidate or candidate's representative will be recognized following the last presentation by a challenger. The candidate may present their case for no more than 5 minutes as well, unless the commission votes to allow additional time for that presenter. Following presentation by a challenger, the candidate may cross-examine the challenger. Following the presentation by a candidate, the challenger may cross-examine the candidate. The cross-examination in all cases will be limited to 2 minutes, unless the commission votes to allow additional time. The cross-examination must be limited to the questions regarding the statements made by the presenter during their opening 5 minutes. Following presentation by a candidate, the challenger may present a rebuttal for no more than 2 minutes. The commission may dismiss the cause of any challenger who has failed to appear to testify before the commission. If more than one challenge has been filed against an individual candidate, the commission may consolidate the challenges, but will provide the same amount of time for each individual challenger and equal time to the candidate. Is there a second to my motion for the commission to adopt these procedures for today's hearings?
Second.
Any discussion? Any questions? Hearing none, all those in favor signify by saying aye. Aye. The ayes have it, and those are the procedures. Moving right into the agenda then, we have the Bartlett v. Carter Challenge, 2024-01. The matter of the challenge to Autumn Carter, a candidate for Democratic Party nomination for state representative of District 95. After filing the challenge in this matter, the challenger, the Honorable John Bartlett, filed a request to withdraw the challenge. The election division has provided copies of the candidate filing challenge form, a copy of notice given in this matter, and a copy of the motion to withdraw in your binders. I therefore move that the commission dismiss this cause based on the challenger's withdrawal of the challenge. Is there a second?
Second.
Having a second, any discussion, any questions? Hearing none, all those in favor signify by saying aye. Aye. The ayes have it. Motion is adopted and this case is dismissed. The election division will be directed to include the name of Ms. Carter on the certified list of primary candidates sent to county election boards. Next on the agenda in filing order, we have Kester versus Trump Challenge 2024-02. In the matter of the challenge to Donald J. Trump, candidate for the Republican Party nomination for President of the United States. The election division has provided copies of the candidate filing challenge in form with attachments and a copy of notice given in this matter in your binders. I now recognize Mr. Kester, the challenger, for presentation, unless
Yes, Mr. Chairman, sorry if I might. Before we start on this, I just wanted to disclose the fact that I believe it's the Trump campaign that is represented by the same firm where my husband is employed.
Okay.
And he is an owner, but I do not believe that Kreitz is having any impact on my judgment, but I guess
I presume there's
Mr.
been
Wheeler,
no-
Mr. Wheeler might disagree.
Oh, not at all.
Okay.
But I left the firm at the end of the year. So I'm now with the firm opposing.
I knew that and I forgot.
So,
Well, there never would have been a conflict. No, definitely. Mr. Wheeler knows my background. Okay,
I
never
presume-
mind. I forgot that part. Okay.
Presume for the record, all has been appropriately dealt with.
Yes.
Anything from the code division before we start on this matter?
I don't know how both co-directors want to go, if we want to ping back and forth on presenting the record, or if we want to handle them based on the candidate and which primary they're running in. I forget how we usually do this. It's been 2 years.
Brad, Valerie?
But
That's it.
I defer to both co-directors on how they want to.
We don't do this on a daily basis, thank
No.
goodness. So.
Mr. Chairman, my recollection is that Mr. Co-Cheever is correct, that in terms of staff presentations, depending upon the party affiliation of the candidate involved, the election division for that staff will make an initial presentation of the record.
I think that's how we listed it in the proceedings.
Sure.
Valerie?
Do you need me to spell and say my name? I think you're good. Okay. So this one is filed by Benjamin Kester. He is challenging the candidacy of Donald J. Trump for U.S. president. And the claim is the candidate is disqualified from holding public office under Section 3 of the 14th Amendment of the U.S. Constitution. And I believe this is Mr. Kester that is here to make his presentation.
Just before you go on, Mr. Coach, you have anything to add to that?
Nothing to add to that.
Okay, I'll start the 5 minutes then.
Okay.
All right.
Mr. Chairman, we have a preliminary objection.
Can you take that first? State your name and you know the game.
Our preliminary objection is a jurisdictional objection.
State your name for the
I'm
record.
sorry. Thomas Wheeler with the law firm of Bozeman, Kinney and Evans. Ali Bartlett, one of my partners, is here, as is Carlin Yoder, who is chairman of the Trump campaign in the state of Indiana. What we filed with them, with the commission members just now, is a preliminary jurisdictional objection to the filing. There's 2 motions there. The first motion is based on Indiana law.
Before,
So, yeah.
sorry to interrupt, but have you provided copies of this to?
We have not yet.
Can we give those to you?
Oh, yeah,
now,
absolutely.
please?
I'm sorry, I thought we had.
And before you go on, Mr. Wheeler, are we following proper procedure here?
Mr. Chairman, I'll defer to council, but the proceedings of the commission today are governed by the Administrative Orders and Procedures Act and Indiana Code 4-21.5. And so
does it permit such a filing at the time of commission?
I believe it does, yes,
Okay.
sir.
Thank you. Sorry. proceed.
And I'll just summarize it briefly. There's 2 motions there. The first motion is a preliminary jurisdictional motion based on IC 3816A. As was noted, Mr. Kieser's challenge is based on Section 3 of the 14th Amendment of the Constitution. IC 3616A, and this is noted in the motion you have in front of you. That statute specifically excludes sections like a Section 3 14th Amendment challenge. It limits candidate challenges to, and I quote, "A candidate for the office of President or Vice President of the United States must have the qualifications provided in Article 2, Section 1, Clause 4.
Can you please give us the citation that you have?
Sure,
identified?
and it's set out fully in the motion as well. IC 38616. It's 4 sections behind the base candidate challenge statute.
Sorry, we're getting your documents
No,
distributed.
I
here.
understand, and I apologize.
No, you're fine. So right now, we're talking about motion, the first motion.
Motion 1, the second motion is the federal argument, and it's the argument that we made in front of the Supreme Court. on the fact that Section 3 doesn't apply to the president.
And I'm sorry, you said 3866, but it looks like it's all 3816.
3816, did I misspeak? I apologize. 3816.
Okay.
So the statute under which the challenge has been made is the general statute. Okay, it is the statute that says applies to all candidates, state or federal, that want to be on the ballot. The specific statute that deals with the president makes it clear that you cannot bring just any challenge under the Constitution. You may bring challenges under Article 2, Section 1. That's it, which is the basic qualifications for the president, not under Section 314 or anywhere else. And if you look at the second paragraph, Part B, the General Assembly in this statute considered Section 314 challenges and limited those to presidential electors. As you know, there's 5 constitutional officers in the U.S. Constitution. It's the president, the vice president, Senate, House, and then presidential electors. So they made it clear, the legislatures made it clear in this statute, which is the more specific statute. I know we're all you guys are all attorneys here. The Indiana Supreme Court has made it absolutely clear that a specific statute controls over a general statute. This is a specific statute that says that the only challenge to a president can be made in Indiana under the qualifications under Article 2, Section 1, Clause 4 of the Constitution. It limits Section 1, which is the basis for the candidate's challenge. Therefore, our position that we've taken in the motion is that the commission lacks the jurisdiction to even hear this, which is a preliminary thing that the commission has, sitting as an administrative law judges, has to deal with before hearing the challenge.
Mr. Wheeler, how do you reach that conclusion? I mean, it just states that you have to have the qualifications of one particular clause of the Constitution, but it does not state that this is the only basis upon which you can be challenged. It's just simply stating Indiana says you have to meet these qualifications.
Do we have to take
I'm
a
sorry.
motion and second it before we have any engagement here? Or we free to ask?
We can ask questions.
Yeah, you can ask questions.
Okay,
Yeah.
sure.
No, sure it does. It's the statute, the general statute, or the layout of the statute, and all of our statutes, we have general provisions and then we have specific provisions. The general provision says which applies to all the candidates, all right, which is the first part upon which he's brought this. And it says the Constitution, it says the Indiana Constitution, it says statute and IEC rules. With respect to this statute, this is a specific statute passed to deal with the president and the vice president. And then under it is one to deal with presidential electors, which makes it clear that the Indiana General Assembly, when it enacted that, it tended to limit in that specific circumstance the challenge to a president only to Article 2, Section 1 challenges and does not contemplate Section 3 because Part B does add that for presidential electors.
Well, that's presidential electors. We're not having presidential electors here. And in fact, the fact that they didn't say the only qualification you must meet is this for president or vice president also says something. Now, my question is, and since we just got your brief, do you have any legislative history, any case law, anything that supports your interpretation?
Sure,
of
if
this?
you look in there, the statute was amended in 1993. Before that, both the presidential section, Part A and Part B, just had the qualification section. In 1993, the legislator looked at those two and they amended Part B to add Section 3 in there. They did not amend it to Section A. Now, as I'm sure you know, Indiana doesn't have a legislative history, but we can presume, and the Indiana Supreme Court has done that. That's why you read the statutes to harmonize with each other. We can presume when they amended the presidential election statute to add presidential electors section Part B, to add in 1993 Section 3 of the 14th Amendment, they chose not to make that same amendment in Part A dealing with the president, which is basically a recognition of the arguments that have been made to the Supreme Court, which is that it doesn't apply to the president or the vice president. Section 3.
I'm sorry, but I just cannot agree with that interpretation because for an elector, what you're saying is that you cannot be an insurrectionist to help to serve, to cast electoral votes for the president of the United States. It's not saying there that as a candidate for president of the United States, it didn't say that you can or can't be an insurrectionist. So, I mean, I would be much more comfortable with this. We tend to, here at the commission, to be inclusive and, you know, to hear a challenge like this. And I am personally not comfortable with adding a brand new interpretation to this law that has not been interpreted by Indiana court. And true, while we don't have legislative history, what I should have said was, did this appear in our histories regarding the adoption of the Indiana constitutions or any amendments and such? So I apologize for my mislabeling, but since we are now traversing a brand new area of law, I am not comfortable giving this provision such a narrow reading and would prefer just to proceed to hear the challenge. So I would move that we deny the motion and proceed to the challenge.
Sorry. Yes. First motion. Is there a second?
Second.
Having a second, a motion and a second. Any questions, Whitney? Any discussion? This is, unless I'm mistaken, the first time I've dealt with such a motion on either side of it. So I appreciate you giving me a couple minutes, but certainly applaud your attempts and the legal gymnastics to get to this point. So, but we have a motion to, how did you state that?
To
Deny the
motion to dismiss.
motion to deny the motion and proceed with the
Yeah.
challenge. And we have a second. Okay, all those in favor signify by saying aye. Aye. The ayes have it. We'll proceed with the challenge.
And Mr. Wheeler, I also applaud your creativity. You're an excellent lawyer. We all know that.
Well, I think Mr. Wheeler, I think if I understood correctly, your second motion was more for background and not,
The second
To be
motion
provided
is
to
a
the-
follow-on and it's probably as appropriately dealt with after, because it is the section 3, Article 14 actual argument. And it's our Supreme Court argument for all
I understand.
intents and purposes.
so this is.
So it's more appropriately addressed after the
Right.
challenges.
Clarify that. I'm sorry.
Right now, motion has been made, but the commission is not taking a vote. Second.
Oh, because by filing this, it's a motion. Okay, so this constitutes a motion, and I guess we need to vote on it?
Are you talking about the motion that?
For the second, so he has a second filing
Okay. So
that he
Mr.
made to the state
But
election
Mr.
commission.
Wheeler, you were just saying that you think that this will be addressed when we get into the challenge itself?
It's essentially a merits argument. So think of 12, I made a 12B1, okay? And this is essentially a 12B6 motion. Right.
Okay.
Is this a motion, would you be willing to withdraw it for the purposes of this proceeding?
We'll withdraw it. I want to keep it on based upon but we're willing to hold an abeyance until the challenger makes
Yeah.
his argument.
The way I understand it, Mr. Chairman, is what he's saying is that we'll go ahead, go through the challenge, and at the end, he can then, using the evidence and what has been presented and discussed, he can then make a motion before we
So he wants to
decide.
provide that. So to clarify, this is not jurisdictional, using Brad's.
It is jurisdictional, yes. And
It's
if
not-
you
well,
would
it's
like
not-
to.
It goes to the merits. you said.
But it is also jurisdictional because the point of the argument is that under any like jurisdiction, because Section 3, Article 14, in my position, the General Assembly has made it clear that that does not apply. One. This argument says, look, under federal law, the federal law makes it very clear that Section 3, Article 14 does not apply to the president, which is again jurisdictional because if it doesn't apply to the president, there's been no violation of the Constitution, and therefore you wouldn't have jurisdiction here.
Mr. Chairman,
Yeah.
when Ms. Bartlett handed me the motion, she handed me both, I think, out of convenience, but I really only heard her say something about the first. So I do think that we could move forward with the challenge and then they could use the
And-
second motion, even though we technically already have it in our
And alternatively,
possession.
If we need to, couldn't we have a motion to table the second motion, and then we can.
I think that would
back
work,
up later.
yes.
If we need to clarify things. decide.
And I thought that's what the commissioner and I had been, sort of, if
Yes,
we're
I
okay
think-
with
I think
that.
we're-
yeah.
yeah.
Yeah,
Okay,
we're
thank
on
Thank
same
you.
page.
So motion
I'll
to
change
table,
the language.
Yeah.
Yes, I move to table the second motion to dismiss.
second. All those in favor signify by saying aye.
Aye.
Motion is tabled. Thank you for your help.
Sorry.
Okay, back on track. Where were we? Mr. Kester?
I have a few documents.
Will you please say your name and spell it for the court record?
My name is Benjamin Kester, BenjaminKester.
Thank you.
And
Mr. Kester, has the other side been given copies of this document?
no, one of those copies is for them. I'm sorry.
We can share. Sorry,
Okay.
go ahead.
All right. Thank you for agreeing to hear this challenge today. So I'll try to stick to the facts here. He already referenced the challenge under Indiana Code 3812 that the Election Commission shall deny a filing if you determine that the candidate has not complied with the applicable requirements for the candidate set forth in the Constitution. So few facts here. I believe that Mr. Trump has failed to meet the qualifications to serve under the Constitution of the United States, Section 3 of the 14th Amendment, that no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may vote by a 2/3 of each house, remove such disability. Congress has in fact done a vote. So on January 13th, the House of Representatives voted on House Resolution 24, which you have in front of you, on the 117th Congress. That in a bipartisan majority, in a vote of 232 to 197, found that President Trump incited an insurrection against the government of the United States. This went to the Senate February 13th, after Mr. Trump was out of office. And again, a majority, 57, found him guilty, 43 did not. I recognize that this failed to meet the bar for impeachment. Mr. Trump was out of office at this time. So those are the facts. I want to go on and read something from the January 6th report that was referenced in the Government Accountability Report. You have statements in here showing the statements that Mr. Trump made to the crowd that was gathered, but I want to speak about what that insurrection detailed. So over the course of about 7 hours, more than 2,000 protesters entered the U.S. Capitol on January 6th, disrupting the peaceful transfer of power and threatening the safety of the Vice President and members of Congress. The attack resulted in assaults on at least 174 police officers, including 114 Capitol Police and 60 D.C. Metropolitan Police Department officers. These events led to at least 7 deaths and caused about $2.7 billion in estimated costs. During this insurrection, Mr. Trump gave aid by withholding federal law enforcement and the National Guard, which is detailed in the January 6th report. The full title of that is Final Report of the Select Committee to Investigate the January 6th Attack on the United States Capitol. That's on pages 6 and 7 that I've provided. He also gave comfort to the insurrectionists by public statement, validating their chants as they assaulted the Capitol. He posted this on Twitter saying, Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving states a chance to certify a correct set of facts, not the fraudulent or inaccurate ones which they were asked to previously certify. USA demands the truth. That's also quoted in the papers I've given you. He has continued after the insurrection to advocate for those people who assaulted police officers and entered the Capitol illegally. Famously, right after these events, he said, "These are the things and events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from the great patriots who have been badly and unfairly treated for so long. Go home with love and in peace. Remember this day forever." And more recently, on his True Social account, has advocated to free all J6 political prisoners, is how he refers to them. So with that, I will take your questions or move to the candidate.
Just went 5.
It just went 5. Okay, thank you. Any, we have right to question, correct? Yeah, Mr. Wheeler, do you have any questions? Okay, thank you. You're up.
Thank you, Mr. Chairman and members of the commission. My name is Allie Bartlett, ALIBARTLETT, and I'm also with Bose, McKinney, and Evans. While we feel that the merits of the challenge were not directly addressed by the challenger, before we address the merits of our argument, we do have one additional procedural motion that we'd like to proceed with. This motion is a motion to disqualify. And we'd like to proceed with this ahead of our substantive argument. Under Indiana Code Section 4-21.5-3-9D, we have a right to disqualify a commissioner who's expressed personal bias, prejudice, or other prejudice toward anyone as a member of these proceedings. And so under the law, the members of the commission, when hearing these challenges, function as administrative law judges and therefore cannot specifically express prejudice against any of the parties. As you'll see, we've provided an Exhibit A, which we believe does illustrate prejudice by one of the members of the commission, and therefore we would move to disqualify Commissioner Celestino Horseman prior to proceeding with the substantive argument.
This is being Exhibit A.
Yes, this is the Exhibit A. I'll give you a second to review the motion. We would like to note, under the same statute and with all due respect, there was an opportunity for Commissioner Celestino Horseman to recuse herself at the outset because the recusal did not take place. Therefore, we're moving forward with this motion to disqualify as we feel there is a level of impartiality that's been publicized ahead of this hearing. And while we, hoped for a recusal, we didn't have it. And so we'd like to proceed with the motion.
Mr. Chair, may I respond to this motion? Thank you. Since it does involve me, they've attached one article for clarification for those in the audience who aren't familiar with it. I do a monthly column for the Indianapolis Business Journal. And in one of my columns, I did an article that was titled "Candidates Should Be Judged by the Company They Keep," and brought up the question about certain of our candidates running for state offices and their endorsement of Donald Trump. Now, we are political appointees to this commission, Ms. Bartlett, so you may not be aware of this. But what
I'm
happens
aware.
is that our names are put forward by the Democratic Party chairman,
Sure.
and their names, please let me finish, don't respond while I'm talking. And their names are put forward by the Republican Party chairman. The overriding thing that we have going on here, and we work well together for the most part, I'd say 99% of the time we work well together. But the overriding thing that we all have to do is we take an oath to protect and support the constitutions of Indiana and the United States, and protecting the voters and voter integrity and all of that. So, you know, I'm not quite sure what your point is. In actuality, can I be looking at the law? I'm a lawyer, I do it all the time. And you're a lawyer, and you know that we have many personal opinions regarding the facts of our cases, but we go forward and we follow the law because that's what we're required to do. And that is the same situation here. So I would respectfully ask my fellow commissioners to deny this motion for me to recuse myself, because I don't intend to. And secondly, I find it very peculiar that if they wait till this point in the process, after I have spoken up about not granting their motion dismiss, and just raise this now, letting the other side go forward and just raising this now, because it leads me to conclude that they just didn't like what I said or how I voted. So I would not encourage that kind of behavior either. Thank you.
This is new water for me.
Yeah, this
Valerie?
is the first time I've seen it come up as well. So I'm reading here on the fly, but I do have some concerns for you, Mr. Chairman. As I'm looking at 421.536, I'm going to paraphrase here, but an individual as a person presiding in a proceeding under, and it's referencing AOPA 28 through 31 of this chapter, and knowingly or intentionally violates section 11, 12, or 13 of this chapter, commits a Class A misdemeanor. And let me tell you why I bring that up for you. Bear with me as I kind of flip around here too. Indiana Code 4-21.5312, administrative law judge, prohibited acts and disqualifications. This is where it talks about an administrative law judge who comments publicly, except in a hearing scheduled or proceeding about pending or impending proceedings, which I haven't read the article. I'm just going off of what
It doesn't
was just
have
said a
any-
second ago. I just want to bring that up so that you're aware that it looks like if a judge moves forward who would be violating 12, you could have some issues under 36 for letting that go on. I don't
And that
see a
applies to
mechanism for,
me as the chair.
as the
presiding over
chair.
the proceeding.
as I'm looking at 36, an individual presiding in a proceeding who knowingly and intentionally, and I wouldn't say that you violated 12, but if, depending on what the article says, I do have some concerns.
Well, if
about
I
number
guess I would
12.
point out, just for clarity, so this article is dated December 8th, 2023, so it was before any challenge. I guess I understand what you're saying. I think that all of us, well, I guess I'm presuming that all of us engage in a certain level of political activity on behalf of our parties, or we would not be sitting in these chairs.
Mhm.
Number one, right? I mean, that's just,
No,
we're affiliated
yeah.
with our parties. I mean, that's the way it is. But the other reason we're here is because we've demonstrated that despite our affiliations, we can rule on these matters. But anyway, to address your point, I just want to point out this article is dated September 28th, 2023, before this challenge was ever, well, I guess I don't know the date. I'm assuming that Mr. Kester didn't file it yet.
When
February 13th,
was it?
24 was when he filed the challenge.
Okay.
So in terms of this article, there was no challenge pending at the time. And this is not commenting on the challenge. It's not commenting on the proceeding.
I'm just
before
gonna-
the commission.
I apologize, I want to let you finish. I'm reading this as we're going here, but if you keep going, an administrative law judge who engages in financial or business dealings, and I don't know if you're paid for that column or any of those details, but it reflects on the judge's administrative and impartialities. I would just encourage everybody to read section 12 before we go forward of Indiana Code 4-21.5312, because that's given That's, I think, what everybody needs to review here with this challenge. And then, like I said, Mr. Chairman, I have some concerns under 36 for you.
I will clarify, I don't get paid any money, as much as I might like to, for doing this, but I do get a 1-year subscription to the IBJ.
Is that in trade for you writing the columns?
They give that to me as my compensation, so I can read my own publication.
Co-counsel, Co-Cheever, just out of appropriateness, would you like to weigh in on your?
Yes. Again, we're not administrative. We don't practice administrative law except we're at a commission meeting, so these are all relatively new. But first and foremost, looking at 4-11-21.5, 3-36, and looking at how it is set out, it reads, an individual who, one, serving alone or with others and as an administrative law judge, or as a person presiding in a proceeding under sections 28 through 31 of this chapter, and 2, knowingly or intentionally violates sections 11, 12, or 13 of this chapter, commits a Class A misdemeanor. So that's 2 subdivisions separated by an and clause, which under statutory construction, as I understand it, means you have to meet those 2 items. So while the second item, which my co-counsel has referred to into sections 11, 12, and 13 may touch on these things, we are not, I don't believe that this particular administrative law hearing touches sections 28 through 31. Only to say that because we explicitly excluded from our election code. We put in parts of the Administrative Orders and Procedures Act. We, as a matter of practice, even before I started at the commission 10 years ago, or started at the division 10 years ago, have explicitly removed those sections. I think those sections have to do with specific agencies, but unfortunately, since I don't have those sections in this book, I don't remember what they are. So I feel that for section 38, I don't feel that we do need to be worried about that, since I don't believe we're meeting that subdivision 1. We are not dealing with anything that is covered under sections 28 through 31 of this particular chapter. Nonetheless, as for the other matters about disqualification, ex parte communications, all those things, the code is plain. I recognize that this motion is something that is covered in 4-21.5-3-9. It has been brought forward, and it's up to the administrative law judges, all of you, to determine its merits and vote as you see
So
fit.
what you're saying is the motion filed to dismiss does follow those guidelines? Is that what you're saying?
Motion filed to, yes, it would be, yes, a motion has been brought forward that someone, that an administrative law judge, a member of this commission is disqualified. Your action, you have to decide it, either you uphold the motion and disqualify
And I do that
the commission member or not.
I don't think so. I think
Chair, or is it a vote?
I think that would be a vote.
Okay.
And just to comment on what 28, 29, and 30 is, those are final orders and authority to issue for the ultimate authority, which in this matter, you all would be the ultimate authority here at the agency level. So Matthew, just so you know, I do think 28, and that would apply. It's all about issuing orders. I think we just don't have it in our code book because we don't issue a lot of final orders. I don't,
I'd have to study a little bit more. I would just say, nonetheless, I think the next step is clear, is to handle this motion as you would handle any other ones, like the first motion to dismiss, and that we go from there. I'll just say this, there's any disagreement here, there is an ability to appeal these matters into Marion County Court. And that's all I have to say. Just I have to look at the sections myself when I can get into my laptop.
Mr. Chairman,
I have a question, because I'm looking at 421.5-3-12, and what they're arguing has to do with financial or business dealings. I guess I read that provision now, and I'm wondering, so it doesn't define what financial or business dealings are. I'm wondering if, for example, campaign contributions that we make fall into that.
May I
I mean,
clarify,
no,
Commissioner?
no,
Our-
we're just
okay,
just
sorry.
discussing.
Well,
I mean, that's
Does anyone
a
have an
question.
opinion?
I don't know. So I'm asking the attorney, because this is, I mean, I'm thinking, well, because we don't recuse ourselves because of like the fact that, we've made campaign contributions. I mean, to candidates, and our campaign records are public.
Public.
I'm just,
Mhm.
yeah, I mean, I just,
Mr. Chairman, I think at
Yes.
this point, I agree with Council Co-Cheever that it would be proper for the 4 commissioners to take a vote on if they want to.
remind me,
Want to handle this motion to disqualify Commissioner Celestino Horstman.
there are certain things that require a majority, there are certain things that require unanimity. Where does this fall?
If this was to go 2-2, you would deadlock, you would need a majority of 3 to make a change.
Okay,
so it fails. So if it's,
Mhm.
so it needs a majority to pass,
Yeah.
otherwise.
okay. So moving back, that did not count against your
No.
5 minutes.
Yeah.
We have a motion from you. Is there anything you'd like to add before we consider that motion?
Yes, and just to be clear, the basis for the motion does not have anything to do with financial compensation or anything of that nature. And this motion is made with all due respect. Under the law, it brings about, the question of a judge's personal bias or prejudice. And the details in the article that struck us were related to the comments on January 6th, the insurrection, et cetera. Again, brought with all due respect, and not related to the financial or business interest. And so, the motion is made on the basis of the personal bias or prejudice. That's why we brought about the motion. Obviously yield to the commission's discretion, just bringing it forth as part of the procedure.
And just another clarification. If the motion were upheld, what happens next?
I believe you would go forward with the
With 3
challenge.
members?
Yes, if that was the way, if it was upheld, yeah, you would move forward with the 3 members and still have the hearing.
So we don't have to have 4 to proceed.
Which always struck me as odd because doesn't the challenge require a unanimous vote? of
No.
4? No, it does not.
You have to
Okay.
have 3.
Okay. All right.
Yes, to provide context here, the
Sure.
statutory requirement for action by this commission is 3. It's not a majority. So if you were to uphold,
Okay.
and Ms. Celestino Horstman had to step out, you still need 3 votes on whatever motions you're taking.
All right.
Just one point of clarification. I apologize. I believe when I was sitting in that chair, wouldn't they be able to appoint a proxy if she recused?
Yes.
They would be able to appoint a proxy, so you would have 4 members. You would simply, and I assume you've got proxies in the back ready to go where people do. All right, maybe not. But typically in situations like this where someone would recuse, we would pick a proxy. So I assume that would keep with you with 4 people
Well,
on that.
Running the risk of looking too far down the road, why don't we just tackle this motion to disqualify member Karen Celestino Horstman? We'll vote on that and we'll kind of go from there if that's all the same. Do we need a second? So is there a motion to accept the respondent's motion to disqualify? So moved. I'm sorry. Okay, so is there a motion to deny the request to disqualify?
So moved.
So we have a motion. Is there a second?
Second.
We have a motion and a second. So that motion is to deny your petition to dismiss,
Not to disqualify.
to disqualify, sorry. Motion upon motion. So we have a motion to deny the request. We have a second. All those in favor of that motion signify by saying aye.
Aye.
Those not in favor signify by saying no. No. So the motion to deny does not pass. So where does that leave us?
We would go back to the,
So, okay.
I'll start the clock. Are you ready, Mr. Chairman?
I'm sorry, I didn't hear where did
We
he say-
proceed.
Okay.
Are you ready for me to start the clock?
Yes.
Okay.
Thank you, Mr. Chairman and members of the commission, and I appreciate your consideration of our procedural motions. While we don't feel that Mr. Kester's presentation of the challenge hits on the substantive basis of his argument, we will respond with 5 points that largely mirror the initial motion to dismiss and is centered around a jurisdictional argument at its core. First and foremost, the petitioner's challenge is legally defective on its face. Presidential qualification disputes are non-justiciable political questions under the Constitution of the United States. Under the United States Constitution, political questions are, quote, beyond the court's jurisdiction and likewise beyond the jurisdiction of state election boards. In other states, when we've heard similar challenges and otherwise, courts have observed that, quote, the vast weight of authority has held that the Constitution commits to Congress and the electors the responsibility of determining matters of presidential candidates' qualifications. Similar decisions involving presidential candidate John McCain, Barack Obama, Ted Cruz, and Kamala Harris, quote, the Constitution assigns to Congress and not to the courts the responsibility of determining whether a person is qualified to serve as president. So whether a candidate may legitimately run for office is a political question that the court may not answer. Further, the constitutional authority of the Electoral College and Congress is specifically highlighted as it comes to the qualifications for the office of President of the United States. The political question doctrine instructs the court to refrain from superseding the judgments of the nation's voters and those federal government entities the Constitution designates as the proper forums to determine the eligibility of presidential candidates. That's a quote from a case out of the New York Supreme Court. As these courts have continually observed, the Constitution contains a host of provisions specifying how electors for president are appointed, how the electoral votes are cast and counted, what happens if the results is an unqualified presidential candidate, and how Congress may respond if the voters choose someone who may be disqualified under Section 3 of the 14th Amendment. So the Constitution specifically addresses what happens, but specifically refrains from granting jurisdiction over presidential qualifications to the Election Commission here before you today, or judicial proceedings in general. On top of that, presidential qualification disputes are not properly decided in state and local proceedings because of, quote, the potentiality of embarrassment from multifarious pronouncements by various departments on one question. Basically, we do not have the jurisdiction to make this type of determination at the Election Commission level here today.
Any questions?
Sorry, I have
still
a
going.
couple additional points here.
Sorry.
The petitioner is asking the commission to revisit a decision that's already expressly made by the United States Senate. The articles of impeachment that were brought against President Trump by the House of Representatives specifically and prominently invoked Section 3 of the 14th Amendment. President Trump's alleged incitement of insurrection on January 6th were brought about before the Senate, and the House trial managers specifically asked the Senate to disqualify President Trump from future federal office holding. They did not, and they acquitted President Trump. The petitioner asked the commission to second guess and undo that decision that was made by the United States Senate already. This cannot be done without expressing lack of the respect due to coordinate branches of government. Presidential qualification disputes are political questions and they belong in Congress. Number two, Section 3 of the 14th Amendment can easily be enforced only as prescribed by Congress. The petitioner before you today asked the commission to determine that someone, the president, is disqualified from holding office under Section 3 of the 14th Amendment by virtue of having engaged in insurrection against the United States. But just months after the 14th Amendment itself was enacted, the Chief Justice of the Supreme Court of the United States at that time himself held that this determination can only be made in proceedings prescribed by Congress. The intention of, and I quote, the intention of the people of the United States in adopting the 14th Amendment was to create a disability to be made operative by the legislation of Congress in the ordinary course. For 150 years after Section 3's enactment, That's exactly how it was enforced, only as prescribed by Congress. Now, after January 6th,
Is there a motion to grant any further time? How much do you have left?
I can summarize the last few points quickly if you'd like.
I would move to allow that.
Second. Any
Thank you.
discussion? Hearing none, all those in favor? Aye.
Aye.
Sure. Thank you.
You have a
So
minute.
generally, Congress has not said anything to authorize this board before us today to investigate whether anyone is disqualified under Section 3. Finally, Section 3 does not apply to the president, which is largely reflective of the argument that my colleague previously set forth. But reading the phrases in harmony with the rest of the Constitution makes it quite clear that that this does not apply to the president. And again, my colleague previously made that argument. So again, does not bar anyone from the presidency. Section 3 does not specifically bar anyone from the presidency. Again, it's reflective of the arguments previously made by my colleague, and it actually does not bar running for office in general. By its plain language, a disqualification under Section 3 of the 14th Amendment prohibits an individual only from holding office, quote unquote, not from appearing on a ballot or being elected. So for all of the foregoing reasons, we hold that not only does the commission before us today not have jurisdiction over the matter, but the matter itself is not specifically addressed under Section 3 of the 14th Amendment.
Thank you. 2-minute cross-examination. And please keep it only to the questions, your questions raised to the material that she provided. They provided, sorry.
Yeah, I don't have much here. But did I understand right that your first claim is that only presidents can be insurrectionists, but any other office insurrectionists are barred from serving?
No, I said that Section 3 of the 14th Amendment does not apply to the office of the President of the United States specifically.
Okay. See, and then that, I think that might be the only question that I had for you. Do I get 2 more minutes at the end?
I don't
Right,
believe so.
you-
I believe it was 2 minutes for cross-examination. To go back to my
Yeah, I need to look at the procedure.
procedures. I don't think there was afforded any closing argument. No, I think you have your 2 minutes for cross-examination on each side and that rest your
I think
case.
that's right,
Yeah.
yeah.
Okay.
So unless you
Can I
have,
address the commission real quick?
unfortunately, your time to do that was prior to this.
Thank you.
Unless you have any further questions for the challenge.
No, I
I would move that, since we extended the time for the other side, and he got up and thought he had to do cross-examination rather than do his response to this, I would move that we give him, how much time you need? 2 minutes?
1 minute.
1 minute. Take 2, it's easier.
Okay.
I would move that we give him 2 minutes to be able to allow him to make his statement.
Okay, there's a motion.
Second.
Second. Any questions? All those in favor signify by saying aye. All those in favor?
I said aye.
Oh, you said aye, okay.
Very quiet, I'm
Okay,
sorry.
thank you very much. My
Sorry, I
kids,
didn't hear you.
my kids asked me last night how I got selected to do this. And I thought about it while I was sitting here today. The framers of our Constitution put it in the hands of the people to bring challenges. Indiana's Constitution has graciously allowed this mechanism for any voter to bring these challenges. So I appreciate the opportunity. And I believe today you have the opportunity to affirm what Congress affirmed and that many Hoosiers observed on live television on January 6, 2021. That Mr. Trump incited an insurrection against the United States government and is constitutionally ineligible to serve. So Thank you for your time.
I'd like to ask you a question along those lines. I
Sure.
think you just said it in a way that resonated with me, but it should be in the hands of the voters. So why would you want to deny the voters a chance to vote on the presidency with Donald J. Trump on the ballot?
Well, we're here today to hear challenges to the ballot. There's a lot of voters that may feel disenfranchised, if that's the right word to use it, that their chosen politician isn't going to be on the ballot. Some people aren't going to qualify for various reasons. So this is the rule.
Yeah, I was just echoing your statement in
Yeah.
the form of a question. Okay. So where are we? Have,
If you're ready to make a motion to vote on the matter, or you
So-
can have more discussion.
sure, absolutely. You can do whatever you want.
Okay, Ms. Bartlett, quick question. You were saying that the 14th Amendment, that it was about holding office and not being on the ballot. So was the argument there that this isn't right?
Sure.
Okay.
Yes, yes.
I just wanted to clarify.
Yes, that section 3 of Article 14 is not, or sorry, the 14th Amendment is not specifically applied to being on the ballot as a candidate, or rather holding office, and technically not the office of president.
Okay, thank you.
Anyone else? So is there any motions that want to be offered? So we have a challenge to Trump being on the ballot. Anyone want to offer a motion?
I would move to deny the challenge.
We have a motion to deny. Is there a second? I'll second it. Any discussion?
Mr. Chairman?
Yes.
Thank you.
Mhm.
Contrary to what's been presented today regarding my position, I take this very seriously. I have practiced election law for years. I've practiced constitutional law. And I take my responsibilities in that regard very, very seriously. And contrary to what was represented previously, I didn't label Donald Trump an insurrectionist in my article. I questioned his actions on the day of January 6th, but I did not attach that label. Now, I find myself today having to sit here and actually decide the issue. And I'm going to tell you, as a lawyer looking at it with my head, as an American looking at it with my heart, this is a terrible decision to have to make. When I accepted this appointment, I did, as I stated earlier, I did take an oath to protect and uphold the Indiana and U.S. constitutions, and I take that very, very seriously. The Constitution says that someone who is an insurrectionist cannot serve as president. But no courts, and Ms. Bartlett capably outlined the law, of which I have read so much on all of this now. But as she outlined, those are the positions that the Trump campaign has taken. But there has been no uniform decision made by our courts of all the various points that she raised. And that is what is ultimately resting with the United States Supreme Court. And as we are sitting here today, we do not have that direction. So again, I am left to make my own decision. So here are my conclusions. Immediately after the November 2020 election, Donald Trump began making claims of fraud. He began to deliberately and intentionally undermine the people's faith in our electoral process. As we know, he was never able to secure proof of such fraud, and he knew at the time when he was making those misrepresentations that they were untrue. We've heard this from his own staff attorneys and his staff members. Now, Donald Trump was also well aware of the impact this information was having upon his supporters. He watched daily as the anger grew and ultimately issued a call to action. His call was come to Washington, D.C. on January 6th, where like-minded people are going to gather and we're going to let our leaders know that we didn't like this election result. Once they gathered at the Capitol, Donald J. Trump told them, let's march on down there and let Congress know how you feel. I will be there with you. He stood up there and said that. We all watched it on TV. He dangled himself as the proverbial carrot from the stick to get those folks down there to the Capitol. Now, for several hours after, and he told them he would be there, but as we know, he did not show up. And for several hours afterwards, no one heard anything from Donald Trump. We know he was sitting in the White House, watching the violence, watching what was happening, and took no action, despite pleas from his own daughter. He took no action to try and stop this. He didn't ask them to stop. He didn't do anything in that regard. Instead, what he was hoping, what he intended when he started all of this, was to somehow stop the transfer of power. And that constitutes insurrection as far as I am concerned. Now, while Donald Trump didn't storm the steps of the Capitol, he is the one who aimed and pulled the trigger on the violence that occurred on January 6th. He is the one who delayed and stopped the transition of power. And the only reason he spoke out later was because he saw that it was not going to succeed. So now, I am left to decide what to do. My vote today will likely not make a difference, and my life will probably be much easier if I just kept my mouth shut. But those who know me know that I am not one who keeps my mouth shut when I think something needs to be said. So, in support of our U.S. Constitution, in support of America, and as an American who loves her country and the law, I vote to grant the challenge. I'm going to vote to grant the challenge.
So the motion is to deny the challenge. And I appreciate your opinion and your comments offered. For the record, I would want to ensure that those are not the comments of this body, but those of member Karen Celestino Horseman alone. And whether I agree or disagree with much or all of it is probably not relevant. But as I stated before, I think it's up to the people of Indiana to decide how Indiana elects its next president. And I find nothing sufficient in what's been offered today or at any other time to deny Donald Trump access to the ballot. But we have a motion and a second.
I'd like to comment. as well.
Please.
I'll be more brief, but sorry.
Go right ahead.
I would just say, I wanted to comment because while I in no way approve of the actions of Donald Trump on January 6th, the thing that I find odd about our situation here is, in reading very carefully Indiana's laws regarding what it takes to be a candidate for president on the ballot, because before I was looking at the constitutional provision that's referenced in 3-8-1-6 with respect to presidents, all it has to do is electors. So it seems really odd to me that Indiana law says, well, as long as you can get enough electors, you can be on the ballot in the general election, which seems to be missing a whole lot of steps. So I guess, but I'm not going to go to the General Assembly and ask them to make it changes. But anyway, I wish I thought that'd be a reasonable or a productive thing to do. But anyway, so looking at that, it's just strange to me that Indiana law doesn't incorporate even the very basic provisions about what it should take to be a president. And I also, I know that this issue is currently pending before the United States Supreme Court. And much as I wish, I felt like we could do something about it here, I don't. I think there are issues out there that need to be resolved by entities other than us.
Got to follow what the law says here in Indiana. Whitney?
Our duty here is to defend Indiana law, and I don't think that we've had any judicial rulings or anything else that have showed us that Indiana law has been violated here. So I would call for the vote, Mr. Chairman.
So we have a motion and a second to deny the challenge. All those in favor signify by saying aye. Aye.
Aye.
Those opposed?
Nay.
Nay, we have one nay. Majority carries. The motion to deny disqualification of Donald Trump prevails. And I would direct the election division to include the name of Mr. Donald J. Trump on the certified list of primary candidates sent to all the county election boards. Matters closed. Thank you.
Mr. Chair,
Yes.
just so we exhaust administrative remedies, in case somebody does want to go to court, we need to have a motion made the other way so we can show we exhausted.
Oh,
Actually, technically, I think
yeah,
Karen
You don't
did
think we
make
need
that
to?
motion, didn't she?
Okay.
At the end of her,
Okay,
and
perfect.
I apologize. That was my miss. Well, technically, at the end of your conveyance of thoughts there, you did move.
I said, I correct myself, said I would vote to grant the challenge.
Okay, well, so what I hear
That
you
wasn't what
saying
was
for AOPA purposes, we need to have a motion to uphold.
I didn't make a
Oh,
motion.
You didn't? Okay.
may I? Okay.
Sure.
Yeah.
Usually during candidate challenge hearings, the usual one, and I'm recalling back to 2016 with the challenge to Todd Young when he was running for U.S. Senate. The two motions that have been most common have been motion to uphold the challenge, motion to dismiss the challenge. But since the motion that was made was the motion to deny the challenge, that is final action by this commission, I would advise that there's no other motion to be made. This matter is now concluded, at least at this level.
Would you agree?
I
with that?
agree with Matthew. Yes, thank you. I just wanted to make sure we were fully exhausted. Appreciate that.
Okay. All right. Decision stands. Moving on. Thank you. Next case I have is Whitley v. Biden challenge, cause number 2024-03. In the matter of the challenge to Joseph Robinette Biden Jr., candidate for the Democratic Party, nomination for President of the United States. The election division has provided copies of the candidate filing challenge form with attachments and a copy of the notice given in this matter in your binders. Anything from the co-directors before we proceed?
All right, just to give an. this would be for
Oh,
Matthew,
Valerie?
the overview. Yeah, Matthew. go
Yeah,
ahead.
this is against a Democratic one, so I'll.
Yep.
So, members of the commission, what are in your binders are as follows. It is a copy of the challenge filed by the challenger, Gabriel M. Whitley, including his statement in paragraph number 6 of the matter of his challenge. Also before you is an appearance form filed by David Zimba here, representing Joseph Biden in this matter. As well as a copy of the CAN 7 request for presidential primary ballot placement in 2024, filed by candidate Biden, as well as a copy of the hearing and information that we did send the hearing out timely to both parties.
Thank you. Valerie, anything from you?
I don't have anything to add. Thank you.
I recognize Mr. Whitley, the challenger, for your presentation. Going once, Mr. Whitley. Going twice, no, Mr. Whitley. Okay. I guess if you want to proceed. The challenger isn't here.
Don't the rules provide that if the challenger doesn't
We
show?
can, but someone would want to make
I
a
would-
motion to that effect.
Based
Okay.
on the challenger's failure to appear, I would move that we dismiss the challenge or deny the challenge or whatever. Dismiss. Deny.
Would it be dismiss or deny?
Dismiss.
Either.
Dismiss. I'm hearing
Dismiss.
dismiss from this side. Dismiss.
So we have a motion to dismiss the challenge based on a lack of presence from the challenger. Is there a second?
Second.
Any questions, comments, concerns? Take the matter to a vote. All those in favor signify by saying aye.
I
The ayes have it. The matter is closed. The challenge is dismissed. Thank you.
Thank you very much.
I am going to call for about a 5-minute recess. I need to use a bathroom. Is there?
Just say whenever we're going to come back. That's the key under AOPA. So if you want a 5-minute recess, we'll be back at 11:20.
11:20. at the same location.
You're good. You're
Which way is the best way to do it?
I will stand up there.
Okay, folks, we are taking a quick recess here, and they're going to be gone for just a few moments. Yeah, listen, Gabe, I don't know what to say about Gabe Whitley. I am not a fan of Gabe. I think that Mr. Whitley saw politics as a way that he could jump in, and to me, Gabe Whitley is someone that is very similar to someone that is a quote unquote First Amendment auditor but doesn't care about being a First Amendment auditor. They're not doing it for the process. They're doing it solely to get a YouTube channel, to make money, and to try to, he's a grifter. I look at Gabe Whitley as a grifter. I don't look at him as someone who is serious about activism. I don't look at him as someone who is serious about being a conservative or a politico. There are people here in Delaware County that remind me of Gabe a lot, or that they remind me of Gabe, or Gabe reminds me of them. And they're people that just want to rise to the top and to be a part of something, and to be in, I know something, I'm special, I'm important. And it's really sad that it's that way. I think it's really funky how they do things like that. I don't like that they do stuff that way, and I just think that kind of thing is wrong. I don't think that those people I don't think that those people help in any real way. So, when I saw about 2.5 weeks ago that Whitley, what's his name? Is it Gabe Whitley? Whiteley? I don't know how it really is. When I saw that he had challenged Biden, I just think this is something that he thought, oh, wow, look at me. I'm going to get my name in the papers. It's the same thing he does when he runs for mayor of Evansville, and he's now running for United States Congress. He's right now, and he's picked this really bizarre fight with Rob Kendall and Abdul Hakim Shabazz. And, it's just, Whitley is somebody that needs to go away. The faster that he goes away, the better everyone around him will be. I hope that he realizes that politics is not his forte sooner rather than later. We are waiting for them to get kicked back into something here. It's really strange because they ended the video. They didn't just keep the video going. They actually ended it. So I don't know why they would have done that. That's really strange. They didn't keep it going. So they're going to literally have their videos from here chopped up every time they take a recess. So I'm just waiting for their recess to pick up. How long did they say? Did they say it was going to be a 5-minute recess? Being rough on him, aren't you? Not me. Let me show you real quick. I will show you what the challenges are. That way you guys can see what the deal is. Give me a second here. I'll put this. So here are the challenges that are we've been through all of this. Bartlett versus Carter's done. What we just heard was Kester v. Trump, and Whitley v. Biden is done. So this is going to be interesting. Whitman versus Dixon is where we start when they come back. That's where we will start. And then we have the rest of this to get through. And then we have all of this to go through. And then at 1:30 today, the government will be meeting in committee for J.D. Prescott's 1338. So that's going to be very, very concerning, and we'll have to follow what goes on there. I'm definitely going to be very concerned with what happens, and we're going to have to follow what goes on there. There was also a Delaware County Council meeting this morning, which I have not been able to watch yet. And it was supposed to be a very important meeting. It was going to, Councilor Ryan Webb was going to be voting or making a motion rather to, I guess, pull the tax abatement on the solar project. So that's big. And in other news, the Randolph County election challenge happened today at 9 a.m. And there is a person, Karen Wilkins, who has polled 2 Republican ballots in the most recent. She voted Republican primary in 2022, and she voted Republican primary in 2023, and she was going to run as a Republican commissioner, and the election board kicked her off the ballot. They kicked her off the ballot because the Republican Party chairman over there, Ben Wells, is a loser and does not follow the law, because the Democrat Party chairman over there, Fred Davis, is a loser and does not follow the law. And so we'll break all that down tonight. You'll want to tune in tonight at 9 p.m. 9 p.m. tonight, you'll want to tune in because there will be a lot of important information that you'll want to follow tonight that we will talk about. And so it will be important to follow that. Let me see where they are here. We should be ready to get on the ball here. It does not look like they have started this feedback yet. As soon as they start the feedback up, we will connect back to them. Break is over, so we should be ready to go. I don't know if they realize they cut the feed. They should not have done that. They should have just kept that going, similar to what the city of Muncie does. I have no idea why they would have killed the feed. That is so ludicrous. I'm convinced that no one in government has a brain. No one in government has a brain. Yeah, Joe Black, if they start the feedback up, who the hell knows? They're like, we're going to get through 2 of 30 challenges and then kill the feed. Okay, here we go, folks. Here we go. It is starting back. Give me 1 second here, and we will get this ready to go.
It includes an attachment titled Candidate Filing Challenge. Also in there is an appearance form for counsel for the challenger, a copy of their
Cool. I think they made the volume lower.
Statement of economic interest required by law to be filed by the candidate when they file their Can 2. The notice of hearing, documentation that notice of hearing was sent to both parties. In addition, I will note that a council appearance notice was filed for the challenge candidate. There wasn't time to have it 3-hole punch and add to your binder, but it was distributed before the meeting. So that is also now part of this record.
Thank you, Mr. Kochever. With that, I recognize Ms. Whitman, the challenger for presentation.
Thank you very much, Mr. Chairman and Commissioners. My name is David Ziemba. I'm representing Ms. Whitman. I entered my appearance in last week.
That was filed appropriately.
That's correct. The spelling is D-A-V-I-D. Last name is Z as in zebra, I-E, M as in Mary, B as in boy, A as in apple. Again, I'm representing Ms. Whitman.
Did you get that? Could you please spell that again?
Absolutely. I'm
Yeah.
sorry. It's Z as in zebra, I-E, M as in Mary, B as in boy, A as in apple.
Thank you.
Again, I'm representing Ms. Whitman in this matter, and it's just a point of personal privilege. It's an honor to be in front of Ms. Celestina Horstman. She inspired me to enter the law 15 years ago when I saw her take a case in the United States Supreme Court, and it was an election matter. So it's an honor to be in front of you.
And here you are.
And here I am. All right. So this was timely filed. Ms. Whitman is challenging the candidacy of Ms. Dixon Tatum, primarily on Indiana Code 3828, that she has failed to obtain and submit the necessary 4,500 signatures and 500 in each congressional district. To summarize, before I call Ms. Whitman as a witness, Ms. Dixon Tatum has received the following in each of the 9 districts that have been certified by county clerks as well as accepted by the Secretary of State's office. In the first district, she has 0 certified signatures. In the second, she has 1. In the third, she has 356. In the fourth, she has 25. In the fifth, she has 749. In the sixth, she has 187. In the seventh, she has 463. In the eighth, she has 27. And in the ninth, she has 88. Collectively put together, that is 1,896 signatures, which falls well below the 4,500 requirement. Again, the only congressional district that the county clerks have certified and the Secretary's office has accepted is the 5th district, which is 749 signatures. At this time, we would call Ms. Whitman up to the stand to testify.
This all goes under the 5-minute presentation, I assume. So just to make you aware.
3 minutes.
We're at 3 minutes.
I'll move that over. Ms. Whitman, can you please state your name and spell it for us?
Before I do that, thank you very much for hearing this challenge. I appreciate your time and your efforts to maintain election integrity in the state of Indiana. My name is Kelly B. Whitman, Kelly B. Whitman, Wittman.
Ms. Whitman, are you a registered voter here in Indiana?
Yes, sir, I am.
Where are you registered to vote?
I am registered in precinct WY045, which is in the township of Wayne in Speedway.
Did you file a challenge against Ms. Dixon Tatum?
Yes, sir, I did. I filed the challenge on February 14th.
Okay, and that falls within the statutory period beforehand?
Yes, sir.
Okay. Why did you file the challenge?
I filed the challenge because in Indiana, as I have worked on a campaign, the requirement to get 3 things to be on the ballot is in statute. Those 3 things are: you have to file your declaration of candidacy, you have to file your financial affidavit, and you are required to get petitions from registered voters to the tune of 4,500, 500 in each of the congressional districts. As I tracked petitions on all the candidates throughout that time period, and that time period is prior to January 10th. Once you get to that point, you should have your signatures submitted. You have an open window to start submitting your signatures to each of the 92 clerk's offices. As I monitored petitions that were being turned in through a report that is sent out to party leaders, it's the Indiana petition signature count by congressional district. I tracked that Miss Dixon Tatum did not have the required 4,500. I believe election integrity matters. I believe that the rules are the rules, and you have to work hard whether you disagree with the rules or not. And it's incumbent upon us to make sure we follow the law if we're going to be an elected official.
Now, Ms. Whitman, did you request the signatures, the complete file from the Secretary of State's office for Ms. Dixon Tatum?
Yes, on Monday, February 12th, I filed a request for records with the Election Commission office, reviewed that digitally, and then came in on the 13th and went through every one of the petitions that were submitted by Miss Dixon Tatum. Came back in on the next day and completed a second count. I did bring a copy of the digital record that was provided as a records request for you. So in that box are the petitions that were submitted by Miss Tammy Dixon Tatum.
And based on your personal review, did you confirm the counts from the Secretary of State's office?
Yes.
And were they short except for Congressional District 5 of the 500 requirement?
Yes.
There was no further questions from Ms. Whitman for me.
Yeah, if you have any evidence that you referred to and you want to introduce it to the record, please give it to Valerie.
Not the, yeah, it's just the box. It's not- Thank you very much for that. We would submit that as Exhibit 1.
And
Now,
does
no, just,
council- Does opposing council need to take a look at that? Yeah. I'll take over. Yeah. Okay, go ahead.
thank you, Ms. Whitman. There is one caveat, obviously.
Wait a minute.
Yes,
Your time is up.
Yes.
can I have an additional 30 seconds?
Sure. I move that he have an additional minute.
Second. Is there a second?
Oh, second. Sorry, I thought you were second again. Second.
Any concerns, questions? All those in favor signify by saying aye. Aye.
Thank you. One caveat to the box, because it's a record, there is a portion of the box, the signatures, that is actually separated. If you see it, it's vertical instead of horizontal in the box. Ms. Whitman, if you could tell us why that's vertical?
Upon examining all of the petitions that were in the secretary or the election clerk's office, I noticed 394 blank forms. They had no signature, and they also therefore had no certification by the county clerk's office. So 394 pages I counted twice, actually 3 times because I wanted to make sure. And then those are flipped up because they would not be considered valid petitions for the purpose of.
I have a quick question. So
Sure.
when you say blank pages, you mean there was absolutely nothing written on them?
Correct. If you look at the affidavit that I submitted, you'll see a screenshot. Most of them had her name, Tammy Dixon Tatum for governor, at the top part that you're required to fill out with the office that you're running for. But then there are no sections in lines 1 through 10. Therefore, those weren't submitted to the county clerk's offices to be verified because there were no signatures on them. So blank forms were submitted as part of her record. And again, when you fill out your Can 2, you certify that you've met the requirements. So 394 pages were submitted knowingly that they were blank.
Any other questions?
What's at the bottom of that can too when you sign it?
The affidavit.
Yeah. Is there, you sign knowingly what?
That the information is accurate.
Cross-examination for 2 minutes. And again, please keep it to the material that was offered in the presentation.
Yeah.
I just have a couple of quick questions.
Please,
So,
will you state your name and?
oh, I'm sorry.
Yes.
Michelle Harder, Michelle, and then Harder is Harter. And I represent Tammy Council. Just one quick question I want to follow up on. During your testimony, you testified that, you know, you believe in election integrity and that candidates need to work hard. And I just want to ask you, is that some sort of assertion of fact that Tammy did not work hard to secure signatures? Okay, just wanted to clear that up. I didn't think that that's what you were implying, but I wanted to get that on the record. Thank you.
I will say that the other candidate for governor whom I supervised those petitions and signature collections did work hard, so I can speak to that.
Okay.
All right, so
Anything further under cross-examination?
no,
Okay.
I'm going to have Tammy testify in a minute. Just want to make sort of a threshold statement here. So Tammy gathered many more signatures than what were certified, and we're going to talk about some of the irregularities that she experienced with submitting her petitions and then having them totally rejected for reasons that are she doesn't really have a lot of recourse with the counties on that. And then generally, Indiana is 50 out of 50 for voter turnout, which is an embarrassing statistic. It came out through our Indiana Bar Foundation just a few weeks ago. One of the reasons is we have a lot of candidates in Indiana who run unopposed. And so if Tammy is not on the ballot, we will have a single candidate for Democratic governor. So here, Tammy submitted signatures in all of the districts. Each page has about 10 lines. She submitted approximately 3,700 signatures, but there was some extra in Marion County, about a few over. So over 3,200 towards the 4,500 or 71%. Previously, a prior version of this commission let Todd Young on the ballot. He was just a few signatures short. It was a split vote. Todd Young had significant resources. He had party leadership backing. It was surprising and embarrassing that he was not compliant with the signature requirement. And at the time when his challenge was in motion, we had our lawmakers saying, hey, we need to do something about this signature requirement. We're one of the most restrictive states. It's time to change it. But then he was let on the ballot and all of a sudden that quieted down really quick. Hasn't been mentioned since. I know that this commission is not inclined to hear constitutional or equitable arguments here, but I'm going to make one because I think it's important. It's important to note that Tammy substantially complied with the signature requirement to the best of her ability. She is not independently wealthy. She has to work a job. She can't quit her job to collect signatures. She does not have the party leadership backing, whereas her opponent had the party leadership gathering signatures for her. Tammy did not have that luxury. It is very expensive and it's very cost for time to get these signatures. We all know this. Tammy will tell you about the irregularities where her signatures were submitted and they sat in an office and weren't certified, which is completely out of her control, very demoralizing. Without Tammy on the ballot, we have McCormick, who recently switched parties. So she was a Republican, now she's a Democrat. She's the party leadership's choice. Tammy is a consistent, lifelong Democrat. If we're looking at what voters want someone who is consistent, right, with the party. And they should at least have a choice, right? McCormick can change her mind about her party, but maybe some voters want someone who's been consistent about their party. If McCormick runs unopposed, like I said, Democratic voters have no choices. And then we know that in 2022, we had 2 African-American candidates who were removed from the ballot because they could not comply with the signature requirement. And I know this commission said that didn't matter about race or gender or personal circumstances, but I don't want to get to 2026 and again be standing here representing another African-American woman who's being told you have no recourse, you can't appear, when it's clear we have historical evidence that this requirement disparately treats certain groups of people. And it's not a solution to say legislature can fix it. They have no incentive to do so. This system helps the incumbents keep their seats. It's also not a solution to tell Tammy, who can't afford to hire signature gatherers, that she can entertain an expensive lawsuit to fight this. I'm asking that this commission we stop kicking the can down the road and pushing the burden onto someone else, and we solve the problem now. And that concludes what I need to say. I don't know if you want to hear Tammy's testimony about what happened with her signatures. We know she didn't get exactly 4,500. We also know that to get 4,500 right, you really need to collect like 7,000. They reject so many. They reject them for strange things, like not putting 4-year dates. So instead of putting 1982, you put 82. They'll reject it. They'll reject it if someone didn't sign a signature with handwriting. But students aren't even being taught handwriting anymore. So some younger folks, they don't even know how to sign their name. So
There's so many different irregularities. There's really no way to go back to the county and contest these things. When this happens, as it did to Tammy, and she got all of her signatures rejected after they sat in office for 10 days, she has no control. So I guess that concludes my time.
Could we let Ms. Dixon Hughes know how much time she has? Because it was, her council
The
took,
5 minutes expired, so if you want to extend it.
oh, the 5 minutes
Yeah,
expired?
it did, yeah.
Oh,
If you'd like to
Can I just have
offer a motion to extend.
Yeah, just give her,
Okay.
please.
all right. I'll give you a motion. I'll make a motion to extend for 2 minutes.
Thank you.
Second.
All those in favor signify by saying aye. Aye. Give you 2 more minutes.
Tammy, would you just tell us about what happened in District 1 with your signatures?
Yes, what happened in District 1, I was called by someone out of the voter registration office, and I was told that the postage stamp mark was January the 30th, but she was calling me on February, I want to say the 11th, and she was saying, your signatures, they're not going to be counted because they didn't get in on time. And so I asked her, I said, well, what does the envelope say? And she said, it says January the 30th. And I said, now what's today? And she told me the 11th. And so I said, well, what happened? She said, I don't know, but I can't count them. So that happened in District 1, where there was 45 pages. It also happened in District 2, which is like the South Bend area. Again, the state should have those because when I last spoke with South Bend, they said they mailed those petitions to all of you. But again, it was postmarked on one day, but then 10 days later, those signatures couldn't be counted and then eventually were sent back to the state. So there's a few other instances where things like that were happening. And again, those were out of my control. And one person said, well, why didn't you just drive them in like other people? And I said, well, I thought that the mail still works. It only takes 3 days to mail anything across the state, anything across the US. So I don't understand why it would take 10 days for something to go from Anderson, Indiana to South Bend or to Crown Point, Indiana. So again, those are two of the major instances, but there were other incidents across the state that happened in the same fashion. So I just wanted that to make that point and be clear on that.
I just have a couple of questions.
Sure.
So, so with respect to District 1, did you submit 500 signatures?
No, ma'am, I don't believe that all 500 were there. It was close, but not 500.
That's all I have.
And that was also because some were obviously thrown out. About 28-30% of signatures are thrown out for the various reasons that were spoken of, be it that someone didn't.
My question was, I guess to clarify, so did you submit 500 signatures for District 1?
I submitted the 45 pages to
It's not pages. What's the number of signatures that you submitted?
about 450.
Okay. Nothing further.
Question.
Yes, ma'am.
So you never called the clerk's office in District 1 there to verify that they had received your signatures?
Well, I had other people, volunteers, because I didn't have a paid staff. So I had volunteers who were helping me and they were doing follow-up calls. I'm not sure what happened there.
Okay, so you didn't check to see if anyone had called to verify that the
Yes.
signatures had been received?
Yes, I was working with my volunteers to
No, that wasn't
follow
my
up.
question. My question was, you didn't know your signatures, let's make it easier. You didn't know your signatures had not been received until they called you
Yes,
to
ma'am,
tell you.
that is correct.
Okay, and there is nothing that prohibits you from making calls to these clerk's office to check. Are you aware of that?
I am aware of that.
And
I
are you
did-
also aware that you can call the clerk's office and ask them what the status is on the review of your signatures? And they will tell you, okay, well, it looks like you've got this number was knocked out or these were knocked out. And you can go in and you can say, oh, wait a minute, you shouldn't have knocked that out because, and show them why it shouldn't have been knocked out. Were you aware of any of that?
Yes, ma'am. And also, I'm also aware that I'm not wealthy and I had to work. And so I do have volunteers and we did the best that we could under the circumstances that we were. Again, if I would have paid staff,
then that would set the tone a little bit different. But I had to work 40 hours plus a week. And so as much as I am qualified in wanting to run for governor of Indiana, I was faced with a number of challenges that many people do not have to face because, again, I'm not wealthy. I'm not the party favorite. So I had to do triple, quadruple time work that most people in this position would not have to do. Again, if they're wealthy, Mr. Russ paid over $300 and something thousand just to help him collect signatures, and he failed to get that done, and he had to quit his full-time job. And he is also a wealthy person. So this whole signature piece is unfair and unconstitutional because that it really knocks out good candidates who are wanting to represent Indiana for the people and serve the people. So yes, ma'am, I did my best, and I am aware of all of those things, but please consider the position that I'm also in.
Well, I'll wait till we have our discussion.
So
Yes,
I have a
ma'am.
quick question. Certainly, in our long history as a state with elections, not every candidate that gets on the ballot is considered wealthy or privileged in some way. And so what would you say to a candidate who, under similar circumstances and similar disadvantages or hurdles as you're espousing, who does meet the signature requirement and does successfully get on the ballot? How would you create
So,
equity there?
If you're speaking of Miss Jamie,
I'm
Well,
speaking generally.
Okay, well, in general, or with regards to Miss Jamie, she was able to raise $17,000. She did have one paid staff. And so, and it also appears that she has some sort of party support because, again, kudos to her, she made it. So again, when you have that type of party support, when you have that type of money, you can do those things. But when you work a full job, and then I am an African-American person, and so there's some special hurdles that come along with this signature gathering piece as well. And so I'm asking you to consider all of those elements as well.
I guess my problem here is you keep saying that you didn't have these resources.
Yes, ma'am.
I don't think it's too much for the state to say, okay, you don't have a lot of money, but at least you've got to get these signatures to show us that you have some support amongst the people. And to get those signatures, as our chair was asking, you have to have volunteers who support you and are willing to go out and do that. And all these candidates still also use volunteers to do that. And the Republican candidate that you're talking about, as far as I know, she had no party support, but she had a heck of a network of people that supported her, and she was able to do it. So it's not a matter of discrimination or anything else. It's a matter of when you file to represent the entire state of Indiana and all its people, what the state is essentially, that's the way I interpret the signature requirement, is essentially saying, look, we just want to know that you have some kind of base of support, some kind of groundswell that will support your candidacy. Because if everybody could run for governor, then our elections would, such chaos, and it would cost us so much to do an election. So
I want to jump in and address this. So it's not that Tammy didn't have support. She had, substantial compliance with it if her signatures would have been accepted and certified. And she's not saying that there's discrimination on the face of this signature requirement. We can't ignore the disparate treatment in the way that it actually plays out. We know she's not the first. It seems that very consistently that we're excluding African-American candidates. And in terms of election integrity, the system, I believe it's 31210 or some, I'm sorry if I'm misstating it, but there's a statute that says that the Republican and the Democratic parties shall hold a primary election. And if you have one candidate, it's a very hollow it doesn't really fulfill that, right? So one candidate isn't really an election, okay? So they're going to win no matter what. So it's not like we have this ballot overcrowding issue in Indiana, right? And we just, we need to get rid of frivolous candidacies. That may be true in other places, but it's not true in Indiana. We can barely find people who are willing to run. So it's not that we're, flooded with candidates who have no support, and it's not that Tammy didn't have support, and it's not that we're saying that the actual requirement on its face is discriminatory because we know it applies to everyone. It's just we have to look at what we know, the actual evidence of who is being excluded by these things. And there seems to be a race and a socioeconomic piece here. Sure, there's people who are able to achieve it anyway, but those are the exception. Those are the rare cases. It's
Sorry
not,
sorry to interrupt, but
Yes.
the bottom line to all this is that you said that Ms. Whitman acknowledged that she only got about 3,700 signatures, which is
3,200. I think.
3,200, which is far less than what was required. Even if you go back and look at the Todd Young, which I was not on the election commission, I think that was a matter of what, 3 or 4 votes? So it was very minimal. Now, in this case, it is much bigger than that. And I also have to address something else that you said, which I really kind of found offensive. You stood up there and said something to the effect that we were only applying this law as to it's only being applied to African-American candidates. And that is not true. That is not true in any sense of the word. We have many African-American candidates who are going to be on the ballot this year who have not been challenged. It's a very simple requirement to get the signatures. And so but I do want to make that clarification. I mean, I did find that rather offensive.
I would echo that. I think we've been pretty consistent in the application of this, and right, wrong, or indifferent, we're not lawmakers here.
I understand. I want to just address it real quick. I was not saying that this commission did anything untoward. I'm just saying that the practical reality is that the folks that are subject to challenges and end up being excluded do tend to be African-American women. I'm not saying you did anything wrong. I'm not saying that you did that purposefully. I'm just saying if we look at what actually happens, not what you're doing, but the statutory requirement itself works to disparately treat people. So I'm not saying that this commission, I think this commission works overtime to do what is fair within the confines of what you do. I'm not criticizing this commission. I want to be really clear about that.
If I could say, I mean, so I was on the commission for the Todd Young issue, and I was on the commission dealing with the 2 female African-American candidates. I think it was 2 years ago or 4 years ago. And I will say that with the Todd Young issue, it was not a matter that he had submitted sufficient signatures. There were, the discussion was questioning some of those signatures. So number one, he had met the threshold requirement of at least submitting the minimum number of signatures. And it became a question of whether any of those signatures were not going to be counted. The unfortunate circumstance with the other 2 African-American female candidates you've been discussing is that unfortunately they, just as with your client, did not even meet. That's why I asked my very pointed question about, did you submit at least the 500 signatures? And the answer was no for District 1. Because that's, it is a different story, a different situation, I think, if we at least get the minimum number of signatures submitted, because again, that is the statutory requirement that we apply across the board. The very unfortunate circumstance that has occurred now in these past 2 election cycles is that we have had 3 female African-American candidates disqualified because they didn't meet that threshold requirement, along with other individuals who did not meet that threshold requirement. They're not the only ones who have not been granted to have their names appear on the ballot. There are other individuals too who haven't met the requirement.
There were several in that last round.
Yeah. So we are applying the law that has been determined. It is not up to us to change the law. And I don't see any basis for any claim that it is, that it has a discriminatory impact. The impact it has, I think, is across the board, because if you don't have the support to get the signatures, you don't meet the requirements.
But I think you were afforded a 2-minute cross-examination in light of the time that we've afforded. I think we should move towards that if you'd like to do so.
We would forego cross-examination. I think the questions by the commission covered what I would ask. We just reserve time for rebuttal.
There's no rebuttal time. So,
Well, then never mind.
okay.
Fine by me.
Okay.
And Mr. Chair, I would like
Yes.
to note that Valerie McCrae, who was one of the African-American candidates you were talking about that did not meet the signature requirement the last time, met it successfully this time and exceeded the requirement.
And she
So-
had 2 years to do so.
No, she did not.
From
She
the
did
last
not.
time
She
she
learned, she took from this session and she went and she put together an organization and she had a group of people who supported her and she learned from it. I would strongly encourage you then to do the same should you wish to run for office again like this.
Thank you.
Thank you.
So we have a challenge to Tammy Dixon Tatum being a valid candidate for the Democratic Party nomination for governor. We need a motion.
I would move to dismiss the challenge. Or no, grant, no, grant.
Grant the challenge, yeah, grant the
Sorry,
challenge.
grant the challenge.
Thank you. And the challenge.
Grant the challenge. Grant the
So
And I'll second.
we have a second. So we have a motion to grant the challenge to ballot access for Tammy Dixon Tatum. We have a second. Any discussion, any questions? All those in favor signify by saying aye. Aye. The ayes have it. That being said, the challenge is upheld. The election division is directed to not include Tammy Dixon Tatum in the certified list of primary candidates sent to the county election boards and to indicate that that name of this candidate is not to be printed on the ballot. Thank you.
Thank you very much.
Next, we have Martin V. Nicholson, cause 2024-05, in the matter of the challenge to David L. Nicholson, candidate for Democratic Party nomination for State Senate District 32.
Mr. Chairman, member of the commission, in your binders, you will find under this cause the copy of the candidate challenge that was filed by the challenger, along with an attachment to that challenge. In addition, you'll find a copy of the candidate's declaration of candidacy, their Can 2, along with a receipt showing that a statement of economic interest has been filed, a copy of the notice hearing, and copy showing that that notice hearing was sent to both the challenger and the challenge candidates.
With that, I'll recognize Ms. Martin, challenger, for your presentation.
Good morning.
Morning.
What? I think so. Yes. My name is Myrna Martin.
You got a couple minutes of
MY.
morning left.
You're right. MYRNA, Martin, MARTIN. Okay, this is a simple challenge. The statute states that a candidate must file the proper paperwork for a Senate or House seat. Therefore, the issue here is that after scanning all new candidates and names on the ballots for the primary election slated for May 7th, 2024, in comparison to statements of economic interest, statements did not see that Mr. Nicholson listed under the Chamber of Senate and year 2024. On primary ballot listing for Senate has defendant's name, Mr. Nicholson, name listed on Senate side District 32. However, on the Indiana General Assembly site for statements of economic interest, his statement is not there. On the chamber side of the House of Representatives, and it appears that Mr. Nicholson submitted this document instead. So I'm questioning how a person running for a seat with the House of Representatives documentation submitted. This is concerning who would be serving in office to represent and uphold public policy who does not choose the correct paperwork. Each candidate listed on both the members and candidate side under Senate submitted a statement of economic interest for Senate. As a voter myself, I thought that this person was listed in a previous election. So knowing that he could not submit the proper paperwork as he has done before in a previous election, that's my challenge.
cross-examine? And please limit it to questions related to the testimony given. Well, you'll get that chance in a moment. This is your opportunity to cross-examine Ms. Martin.
Should I be seated?
Yeah, does anyone have any questions?
Let me just give a brief chronology. Pardon?
Your name?
Oh, my name's Dave Nicholson, DAVID-NICHOLSON. Just a brief chronology of the situation. On February the 8th, I showed up at the Secretary of State's office to file for State Senate. And I knew I had to file an economic interest statement. And the gentleman who was waiting on me at that point in time directed me to the House Secretary's office. I went to the House Secretary's office, filed my economic interest statement, got my receipt, brought it back down. A young lady waited on me, checked the documents, filed me, and I assumed everything was okay until I received the notice in the mail of this challenge. At that point in time, that was on Saturday, February 17th. February 20th, Tuesday, I came in, I went to the Secretary of State's office to see what I could do to rectify this situation. They directed me to go to the Election Division office. I went to the Election Division office, and they directed me to go to the Secretary of State's office. And from there, I went to the Secretary of the Senate's office and told her the situation. And she wasn't sure what she could do, but she did allow me to go ahead and file the economic interest statement with the Secretary of State's, or with the Secretary of the Senate's office, which I have both my original and a copy.
Yeah, please give it back.
What was it, Dial?
So at this point, I know nothing else I could do to rectify the situation, and I see no reason why I should not be allowed to continue being a state Senate candidate.
Go back and explain to me again, how the Secretary of State's office, what did you say happened there?
I went in to file for state Senate, and I knew I had to file an economic interest statement. And I asked the gentleman who was waiting on me at that point in time where I needed to go to do that. And he sent me to the Secretary of the House. And I assumed that's the way the procedure was at this point in time.
Did you read the forms that you were filling out?
Yes.
And were you at all surprised that it said House of Representatives instead of Senate?
Like I said, I assumed I was being directed appropriately.
I guess, I mean, it's unfortunate that it happened, but part of the reason why you're required to file these is so that people can see them, to see what your economic interests are and everything, since you want to be an elected office holder. And by filing in the wrong office, I mean, as far as you know, did the House of Representatives forward it over to the state Senate, say, oh, this was mistakenly filed with us?
They accepted my form. They gave me my form that I had to take down to the Secretary of State's office, which it clearly said the House. And people in the Secretary of State's office looked at it, said okay, and filed me.
And so, but you get instructions when you file for office, correct? Written instructions that tell you what's needed, and the Secretary of State, the website page for the election division and everything. There's a whole great big handbook, and it sets forth all the things you have to do to be a candidate. Did you take a look at that before you filed?
Not in detail, no.
Well, in the future, no matter what happens here today, I strongly suggest that you take a look at that candidate handbook before you do anything. It becomes, when you're running for office, it becomes your Bible, so to speak. So.
Yes, I understand that.
I have a question for our council when we're ready about the statute. So, the statutes regarding statement of economic interests say, so I'm looking at 2-2.2-2-1. Wait, now I'm looking at 2-2.2-2-2, that says the, subsection B in that says that you have to the candidate has to file with the principal administrative officer. Doesn't say, and then there's 2-2.2-2-7 that talks about the duties of the principal administrative officer. Is the principal administrative officer defined anywhere? So it's, no, go ahead.
Yes.
Go ahead.
Yes, I anticipated this particular question. So I believe that in the Title II chapter that is being referred to, the principal administrative officer is defined in Indiana Code 2-2.2-1-16, and that essentially means that in the House chamber, that is the clerk of the Indiana House of Representatives. In the state Senate chamber, that is the secretary of the state Senate.
So you would interpret that that was filed with the inappropriate administrative.
There are various sections on here for Title II, which created the Statement of Economic Interest. There is a section of law which provides that when you are not an incumbent member, but you wish to become a candidate, under law, you must file the Statement of Economic Interest form that was created by the General Assembly with the principal administrative officer, which means that, as I read that particular statute, when you want to become a candidate for state Senate, you must file that Statement of Economic Interest with the secretary of the state Senate. That's how, at least how I read Title II.
So
I will defer to others
what I hear you saying is, in this case, they have not accurately filed or legitimately filed the Statement of Economic Interest.
Based on the record before us and the filing that we have a receipt showing that a Statement of Economic Interest was filed with the House, not with the Senate. So that would be the case that we have the wrong receipt.
I would agree with Mr. Co-Cheever and would add, in addition to the statute, Commissioner Karen Celestina Horstman is correct that we put together candidate guides. And in those candidate guides, it specifically, we do not use the term principal administrative officer. I believe we say the House of the clerk or the House, principal clerk of the House, and we principal secretary of the Senate. So that is spelled out in the guides as well.
So I guess my question is filing your Statement of Economic Interest in the wrong place the equivalent of not filing it at all?
Oh,
I would say it's not compliant with the law.
yes, that is correct. I'll refer you over to Indiana Code 3-8-1-33 and Indiana Code 3-8-2-11. These both speak to Statement of Economic Interest in regards to state legislative candidates. The requirement placed on both candidates and upon our office and the Secretary of State's office is clear that we must have the proper documentation showing that the proper Statement of Economic Interest, as required under that section in Title II, must be filed. We must have evidence of that. That is that receipt. I will also tell you, as you've seen, and now it's been entered to the record, the receipts that's used by the House and the Senate are distinctly different. The House uses a quarter sheet as their receipt showing that it's been filed and it's signed by a representative of the House Clerk's office. The state Senate uses a very small slip of paper that can be very hard to scan sometimes and is signed by a representative of the Secretary of the State Senate.
And there's nothing statutorily or by rule or policy that allows for some erroneous filings to be corrected?
No, I would say the statute is quite clear that after the deadline for declaration of candidacies, we cannot amend. And so based on the filings that came before us today, that date says February 20th, that it was filed with the Senate. That's after the filing deadline for a declaration of candidacy. And we, being the election division or the Secretary of State, would be prohibited from taking it after that deadline.
Can I see, do you have the
You agree with
language?
that?
Yes, just as so much to say, and is that, yes, as long before we hit the candidate deadline, there's an error, the candidate and his candidate knows about it, is informed, otherwise learns it. We do accept amendments to the filing. So there are a chance to correct it, but up to the deadline for filing as candidate. After that deadline, our office does not accept any more filings as required by law.
Sorry, well, do we have, it's not a 2- unless I'm blind to it, I don't know, but I don't see 2-2.2-1-16 in our book.
It's not, but I can give it to you right
Yeah,
here.
because
Hang
I'm
on a
really
second.
curious, because I don't, the statutes aren't saying what you guys are saying. Oh, so there it does say that, okay. Okay.
Our code books are selective on what statutes they have. We can only print so much.
We're on a need to know basis only.
I have not been paying attention on time. Have we concluded?
We are done. I stopped the time once we started
Okay.
asking questions.
You have a
Yes.
2-minute opportunity to cross-examine. Mr. Nicholson, would you like to do so?
The commission asked the questions that I wanted to ask.
Okay, thank you. Go ahead and have a seat.
Okay, may I ask one question? Since my candidacy was accepted by the Secretary of State's office, does that mean that the Secretary of State's office violated the law?
That's not a matter before this board to consider, I don't believe.
Agreed.
Yeah. Okay, so we have a challenge presented. Is there any motions?
Okay, it's with great reluctance, but the law is the law, that I make a motion that we grant the challenge.
Is there a second?
Second.
So we have a motion to uphold the challenge, and we have a second. Any further discussion? Contemplation?
I will say that it's unfortunate, but we can't, because we have our election code. This is the election code. And as she said, this is just the selective provisions. So if we say, well, you were just a little bit out of whack on that, we'll let you slide by. Then we open up a whole other can of worms. So we try as best we can to follow. So next time you want to run, get that candidate handbook. It'll tell you everything that you need to do, and you don't need to rely on anybody else. These folks have put it in writing for you, and you got it right in front of you. So
I think I tend to lean in that. I mean, we just got done hearing a matter where application of the standards needs to apply, and I feel like we're kind of faced with a similar question in a slightly different manner, but I don't know.
Well, and I
Clear as mud.
Yeah, sorry, and I'm sorry. And
Yeah, no, go ahead.
See, I think to me this is a little bit different because, you know, the last one I was asking, well, did you at least submit the 500 signature? And this, so we've got a candidate who followed, I mean, he was directed to someone's office to file to get the economic interest form. It was the wrong office, but that's what is kind of giving me pause, is that he did file a statement of economic interest. It was the wrong office in the right building.
yeah, that's true. I mean,
And that's what concerns me, because I'm thinking, well, and he's saying he was told to go to the House clerk or whatever. And he went there and no one there said you're in the wrong place. And so he fills it out, takes it back to the Secretary of State's office. No one there catches it. Now, granted, yeah, I guess if it were me, I guess I would have looked at and said, well, why am I filling out a statement for the House representatives if I'm running for Senate?
Well, and I go to Valerie's comment about the adequate materials that are provided by the election division for candidate
And
filings.
And if I could, I'll just read out of Indiana Code 3-8-2-7. This would be subsection, I think, A7. The following statement is required with the declaration of candidacy. A statement that the candidate has attached either of the following to the declaration. A copy of the statement of economic interest filed, stamped by the office required to receive the statement of economic interest. A receipt of the photocopy is also acceptable. So just wanted to give that statute to you as well for consideration.
So Valerie, if,
Obviously, if you run the other foot, I see both sides.
so,
Yeah.
he did raise a question that I kind of wondered about. Should the Secretary of State accepted his filing since he didn't have?
Well, I would say the Secretary of State's office is ministerial in their responsibility, meaning that they accept what they get on face value. It's kind of like the two primary rule. If they get one that someone didn't mark or they did mark, they are instructed to accept it, and they are ministerial, and it's up to a voter of the district to challenge it. So that is the guidance given to staff.
The Secretary of State accepted a qualified form filed with the House, irrespective of whether.
Yeah.
To provide a response, I would just add, in a perfect world, yes. I mean, we're all experts here. We speaking for the election division, the staff.
Right.
We've created the forms. We've been doing this for a long time. But again, in a perfect world, yes, this would have been caught. Say, candidate, no, this is the wrong receipt. You may want to fix this before accepting for filing. Or even if when it came to our office, we want to catch it on the back end. But speaking for myself, we are not perfect. If you look at our candidate list, I mean, we have hundreds of candidates who filed with us alone that we certified down to the counties. But I will say this: it is not out of the question that a filing it gets accepted, gets file stamped, it's received in our office, and gets processed. Though something statutorily, maybe missing.
And that is not for the Secretary of State to make that determination at the time of accepting the filing.
That would, ministerial is the legal term for they accept the filing.
Okay.
Yes, they get it.
One last question for me, Mr. Co-Chief or Valerie. Has anything like this come up before? Do we have any past precedent on a erroneous filing of an economic interest statement for a candidate that's been dealt with before?
Not in my time here. I would defer to Brad. He's our historian.
Yeah.
Mr. Chairman, no, I don't recall a situation exactly paralleling the facts that you have before you.
Okay, well, we have a motion and a second to uphold the challenge.
Yes.
Yeah.
Let's do it by roll call. Those in favor, Karen Celestino Horseman will go from left to right. How do you vote?
And so the motion is to uphold the challenge.
To uphold the challenge.
Because of the way the law is written, I feel like I have to follow that. So I'm going to say grant the challenge.
So you vote for the
Yes.
motion. Susanna Wilson Overholt.
This is very difficult, but I feel like I need to vote to uphold the challenge based on law.
Okay. I too will vote in support of the motion. Brittany?
I would vote to uphold the challenge as well. I think the law is pretty clear, although unfortunate.
That being said, the challenge is upheld. The election division is directed not to include David L. Nicholson in the certified list of primary candidates sent to county election boards and to indicate that the name of this candidate is not to be printed on the ballot. Thank you. Next on the list, I have Crooks v. Moore, cause 2024-06. in the matter of the challenge to Kelly Moore, candidate for the Democratic Party nomination for the United States Representative, District 8. Mr. Koji.
Thank you, Mr. Chairman. Members of the commission, in your binders, you will find a copy of the Can One Candidate Challenge has been filed by the challenger, along with the candidates filed Can Two Declaration of Candidacy, a notice of hearing that was sent to both the challenger and challenge candidate, as well as documentation showing that that notice of hearing was sent to both parties.
With that, I recognize Mr. Crooks, the challenger, for your 5 minutes presentation.
Help speed up your meeting. Rules are rules. That's all I've got to say.
Will you at least state your name and spell it? You had the drop the mic moment, but yeah.
David Crooks. And rules are rules, and I hope you'll accept my motion. Crooks. Thank you. It's been a while since I've been up here.
Is Ms. Moore present? Would Ms. Moore like to? We want to proceed, or does anyone want to make a motion based on the absence of Ms. Moore?
Well, I guess I would like to acknowledge for the record that it appears that she did, her Can Two is indeed not notarized. At least the one we've got here on the file is not notarized.
Would you affirm that, Valerie?
Yes.
Matthew, is that correct?
Yes, and I will also tell you that I was the one who put the file stamp on this.
Okay, so, based on that, I would move that we uphold the challenge.
Okay.
Second.
Having a second, any questions, comments? So we have a motion to uphold the challenge presented by Mr. Crooks in a second. All those in favor signify by saying aye. Aye. The ayes have it. The motion carries. The challenge upheld. The election division is directed not to include Kelly Moore in the certified list of primary candidates sent to county election boards and indicate this name of the candidate not to be printed on the ballot.
Thank you for your brevity, Mr. Crooks.
Yes. We appreciate it. I hope I'm pronouncing this right. Bohm versus Schrader, cause number 2024-07, in the matter of the challenge to Thomas A. Schrader, candidate for the Democratic Party nomination for United States Representative, District 3. Mr. Koji.
Yes, Mr. Chairman, members of the commission, in your meeting binder is a copy of the Can One Candidate Challenge filed by the challenger, as well as attached documents that came along with that challenge. And also in here, once I get through everything, though it was part of the documentation that was filed by the challenger, there is another copy of the candidate's Can Two Declaration of Candidacy form. There is the notice of hearing that was sent to both parties, as well as documentation showing that that notice was sent to both parties by the election division.
Thank you. Ms. Bohm.
Good morning, Christine Bohm, Christine, Bohm, BOHM. I am here for the second time in 2022. I came through with the exact same challenge against Mr. Schrader. Basically, he has run 7 times and has never filed a single financial form. He has run for the federal office, I believe this will be his 5th term, and he has run for local office twice. You have copies of where we are trying to prove the negative, which, as you know, is difficult to do. You have printouts from the Allen County election board that shows in 2015 and 2019 where his name should have been had he filed his financial paperwork. And then you also have copies from the FEC website that show no records found for Mr. Schrader. There are some other minor issues on the can, one of them being that he is not actually a registered Democrat under that name. I know under federal office, you only have to be a resident of that district, but he is signing as a registered voter. In 2022, he used an alias as his, to file his Can Two forms. So I am asking that he be removed from the ballot simply because in the last approximately 20 years, he has not upheld any federal nor state finance records.
Mr. Schrader present? Mr. Schrader, anyone representing Mr. Schrader?
I would move that the challenge be upheld.
Okay. So we have a motion. Is there a second?
Second.
So we have a second to uphold the challenge and a second. Any discussion, any questions? Whitney?
Mr.
Valerie?
Chairman, I agree that Mr. Schrader, based off his evidence, it looks like hasn't filed any campaign finance reports under 3.9. And I'll defer to Matthew if he has. I'm struggling here to find a way that we can disqualify someone simply off of the campaign finance filing.
I don't, yes, as co-director Nussmeyer reminds me, and as I remember in the record, and as testimony as revealed, this exact same challenge on numbers, if not all these grounds, was brought before this commission in 2022. This commission upheld that challenge, and this person was not a candidate in the Democratic primary for a federal office. So our own precedents says that we have this. Another thing that you can, just to answer also substantively what my co-counsel has brought up, is that parts of challenges, they all have to do with qualifications, but they also have to do with statutorily completing, in this case, the candidate form as required by law. These have been brought up in the candidate challenge and everything that's before you. So there are a number of other grounds that are in the record right now. They're in your meeting.
So this is a qualified challenge in your.
I believe this is a qualified challenge, mostly, and for me, I would side on the precedents, but there is enough here in the written record also on other grounds that I believe this commission can also rely on when they vote.
Okay.
Okay. Thank you, Matthew, Mr. Co-Chief, that's helpful. So would you say the grounds then for the challenge would be perjury of the name or the information?
I will not go so,
Okay.
I'm just speaking for myself.
Yeah.
I will not go so far as for perjury. I'm not a criminal attorney or whatnot. But I think there's also, putting perjury aside, we also can take the statement that is above the person's signature on the back of this can too that was notarized. We also can take into effect of whether or not that, by signing this form and it not being completed as provided by law, that is something that I'm trying to find the words. Essentially, that this commission can be taken up. That I think basically that it was not completed as required by law.
You're referring to the statement, I certify the information, this declaration of candidacy is true and complete,
Mhm.
and that I meet specific requirements of the office.
Yes. Now, yes, it could be taken two ways. Perjury, but that's for the other side. That's putting that aside. But that's also by saying that if you find anything in this that's in the record that makes this not, I'm going to say factual, then that definitely is something that you can take into consideration. And that's by matter of just referring you over to 327, which is the statutory provision that requires, one, what needs to be in this declaration of candidacy, this can too, as well as instructions to the candidates on how they need to complete this.
And you have to complete this can accurately and factually true. And so he was asked specifically if he had filed his prior campaign finance reports. And he said, yes, but we know that's not true. So we're not actually using his campaign finance stuff to say that's a basis. What we're saying is that his misrepresentations about filing his campaign finance reports is what's gotten him in trouble here.
Well, the campaign finance for all previous candidacies, never mind. Okay, sorry.
Well, the fact that Mr. Schrader's not here to respond to any of this is problematic, but we do have a motion and a second to uphold the challenge. Any other comments or input?
I was curious from Ms. Baum, what does it mean when it says under the number 6 on the Can One challenge, you put off the sought invalid.
Check the spelling. It's minor, it's a typo, but it matters. Representative.
Oh, okay.
That's right.
Mhm.
Well, I guess we'll call the vote here. We have a motion and a second to uphold the challenge, excluding Mr. Schrader from the ballot. All those in favor signify by saying aye. Aye. The ayes have it. The motion carries. Challenge is upheld. The election division is directed not to include Thomas A. Schrader in the certified list of primary candidates sent to county election boards and indicate that the name of this candidate not to be printed on the ballots.
Thank you.
Next, we have Burrick versus Shidale, cause 2024-08. Also, Eldridge versus Shidale, cause 2024-30. In the matter of the challenge to Sarah Shidale, I hope I'm pronouncing that correctly, candidate for the Democratic Party nomination for Indiana State Representative District 97. And also 2024-30 is the challenge to Sarah Shidale, candidate for Democratic Party in District 70, is identical matter. Are the representatives of the both present? Are we taking these together? Yeah, do we want to take these sort of concurrently? Do we have to make a motion to that effect? Yeah, can we move to
I would
consolidate?
move, yeah, I'd move that we consolidate these two challenges.
We have a motion and a second to consolidate 2024-08 with 2024-30. Any discussion, questions? Hearing none, all those in favor signify by saying aye.
Aye.
The ayes have it. The matter is consolidated. Mr. Koji?
Yes, Mr. Chairman, members of the commission, looking at your tab for cause number 2024-08, you will find a copy of the Can One Candidate Challenge filed by the challenger along with attached documents, a copy of the candidate's declaration of candidacy and attached statement of economic interest receipt that was filed with the state, as well as a notice of hearing and documentation showing that that notice of hearing was sent to both parties by the election division. And then if you look in tab 30, I can get to it. Same thing, Can One Candidate Challenge, along with an attachment, copy of the candidate's Can Two, and attached statement of economic interest receipt that was filed with the state, a notice of hearing, documentation that the notice of hearing was sent by the division to the parties. There was also at earlier to closer to the commission hearing today, there was an appearance notice filed on behalf of the challenger Mila Eldridge, that she would be represented by counsel. That's in cause number 2024-30. So that is also part of the record. I don't know there was time to get it into your binders, but
No, it's here.
it was. Okay,
Yeah,
great.
thank you.
Thank you.
With that,
Mr.
yes.
Chair, I'm sorry to interrupt you, but Mr. Hahn has appeared on behalf of Ms. Eldridge, correct? But you have not appeared on behalf of Mr. Urick, right?
No.
One's nodding head yes, one saying no. Okay, okay, just for Mila. Okay, so is Mr. Urick here?
I don't, Mr. Urick?
So if he's not here, he can't present the challenge, correct?
Right.
That's correct.
So
We should have figured that out before consolidated.
He can't present, he can't present on cause 2024-08.
So should we just dismiss that challenge?
We consolidated.
I know, but if he's not here to present anything on it, and he's not they're not representing him,
I would move that we now bifurcate the challenges.
I'll second that.
Is that permissible? All right. We're going to separate these matters by vote here. We have a motion to do so in a second. Any questions? Comments, concerns? All those in favor signify by saying aye. Aye. The ayes have it. The matters are now separated.
Now I
bifurcated.
move to dismiss the URIC challenge.
So it would be a motion to dismiss cause 2024-08.
Second that.
We have a motion and a second. Any discussion? Hearing none. All those in favor signify by saying aye.
Aye.
Aye, the ayes have it. That matter. I mean, all right,
I
now,
guess I would move to take this one out of order as we've already discussed it. The Shidale matter.
I'd second that.
so we have a motion to consider cause 2024-30 out of order. In a second, any questions? Comments, concerns? Hearing none. All those in favor signify by saying aye. Aye, the ayes have it. Motion carries. We will consider the cause.
Mr. Chair, aren't you
Yes.
glad you're sitting with 3 attorneys?
It helps a lot. So with that, we'll recognize Eldridge.
Thank you.
Challenger.
He's the challenger.
My name is Greg Hahn. I'm with Bose McKinney and Evans Law Firm here in Indianapolis.
Would you spell that for us, please, real quick?
Which part? The Hahn?
That part.
Yeah, H-A-H-N. With Bose, B-O-S-C, McKinney, M-C-K-I-N-N-E-Y, and Evans, E-V-A-N-S.
Thank you, sir.
You are welcome. And we're here and I'm here with my partner, Alexandria Bartlett, who's also with Bose. And thank you for this opportunity, Mr. Chairman and members of the commission, to be here and present to present our challenge. First and foremost, you'll note that the facts we present here today have been updated since the time of the filing of the original challenge, as additional information was gathered. However, the outcome remains the same based upon all available information that we have and have reviewed. Ms. Shidale did not reside in House District 97, and that's the seat that she is seeking to run.
Counselor, you said that information has been updated. Is there something we should be looking at or?
I think no. It's the same. It doesn't make any difference. Thank you. And she did not live in the district prior to the date of the election for this office. And then Ms. Bartlett's going to go through the legal aspects of this and answer any questions as far as that goes.
Thank you.
Okay, thank you.
Thank you, Mr. Chairman, members of the commission. Obviously here to show my bipartisanism today, I guess. Like Greg said, my name is Allie Bartlett, B-A-R-T-L-E-T-T, with Bose McKinney and Evans. As Greg mentioned, after reviewing all available information, under Indiana Code 3-8-1-14-2, that code requires that in order to be eligible for election as a representative to the Indiana General Assembly, a candidate must reside within the House district they seek to represent for at least 1 year prior to the election for such an office. Ms. Shidale filed a provisional ballot and request to change her voter registration to her current registration address, which is within House District 97. But she filed that change on November 7th, 2023. That date is more than 1 year prior to the 2024 general election. And as a result, we request that Ms. Shidale be deemed ineligible for placement on the primary ballot. And we're happy to answer any questions.
So you're saying that on November 7th, 2023, she went to the polling place and changed her address.
That's our understanding yet, based on the materials we have.
And she changed her address to the address that she filed for her candidacy on.
Correct.
And you're saying then that it falls is not a year till this election?
Right. So this election is November 5th, 2024.
Short by 2 days.
Right.
But you're basing this on the date that she went to voter reg and asked to change
Right. So
her
that was the
address.
first date that her voter registration was updated, that her address was changed.
Okay, so do you know what date she actually moved
No, the only information that's publicly available on the address change is the voter registration. So obviously that's all we have access to.
And she, when she cast a provisional, she went to her old precinct?
I don't know. I don't have
You
it.
are entitled to vote at your old precinct. once
Sure.
you move for a
Mhm.
year.
Yes, sure.
past, so-
Yeah, I don't know. I don't have that information. Apologies.
All right, and welcome to the light side now. This part.
I like to help all of my law partners, so.
Is it pronounced Shadale? Shidale? You have 2 minutes to cross-examine if you'd like them. Okay. You have 5 minutes to present.
Ms. Shiloh, can I just make this real easy? When did you move to this address?
I have my
Oh,
lease
thank you.
I have my lease right here and I signed the lease in September and I moved in October.
Okay. Could you give your full name and spell it, please?
Sarah Shidale, that's SARAHSHYDALE.
And could you show that lease to council over here?
I'm sorry.
And then Ms. Wardship, please.
Who we realized did not have the benefit of having this before we got here.
Also, I'm sorry, I only printed out one copy.
While they're looking that over, did you want to make a presentation or?
You have 5 minutes.
Of course. I was going to point out, as the challenger did, that in 38114(2), that I have to reside within the district for 1 year prior to the election. According to Indiana Code 381.1.7, I'm sorry, as used in this chapter, before the election refers to a general, municipal, or special election. And as per Indiana Code 35510, subject to section 6 of this chapter, if a person is physically present within another precinct in Indiana with the intention of making that precinct the person's residence, the person loses residency in the precinct that the person left. And as I moved in October, I believe I should be valid to run in this election.
A question for you.
Mhm.
Did you update your driver's license?
I haven't done that in several years. I just keep forgetting to. I'm waiting for it to expire.
And you know that Indiana statute gives you a time limit to do that, right?
No.
Okay. Is there anything else that shows that you actually moved or intend to move a year before this election besides just this lease?
Intended to?
Yep. Yes, the law says intended.
It depends on what you consider intended, I suppose.
Anything that you can tell us that you had the intention to live inside district?
Prior to a year before the election?
Yes.
Aside from just seeking a new place to live before my current lease, or at least the previous lease ran out, communications with the leasing office. I don't have much in that regard, but I fully intended to before September, as I was talking to the leasing agency, the apartment agency for months prior to when I actually signed the lease.
When did all of your belongings get into this property?
October 15th, I want to say, at the latest.
All right, thank you.
So this lease took effect October 1st? You signed it September 22nd.
And then I believe it took effect October 11th.
Oh.
That was when I first paid rent.
Okay. And that, at that point in time, you became obligated to pay money, correct?
Yes.
That's a pretty good manifestation of intent to me.
Oh,
Oh, sorry.
And do you reside in that apartment now?
I have since the move-in date specified on the lease.
You didn't bring any utility bills or any other supporting documentation to that effect?
I have some letters at my desk upstairs. I work here, so, but I didn't think to bring them. Also, of course, I do get my utilities through AES, and they send me electronic bills that do have my address on them and such.
Do you find that needs to be combined?
Yeah. Do you all have any evidence that would rebut the fact that he moved into this address in October?
I guess my only question would be that the lease was signed in September. Is there a reason that you didn't then update your voter registration or driver's license? Because there's typically a 30-day requirement. So obviously the only evidence that we had access to was the voter registration update, which occurred when you
It was a very hectic time for me, and with the insanity of moving, I didn't have time or the opportunity to update my voter registration until we got to the polls, unfortunately.
Well, it's not applicable under state law. There is a rule in Marion County that you update your voter registration within 30 days if you have the option.
Well, but let me ask you this, if she took residence on October 11th and the election was November 7th, and she went into the polling place and updated her voter registration, then she did it within the 30 days, correct? Okay. I just want to make sure I understood.
Okay.
So to that point, clearly the standard here is the intent to reside. Is there agreement there?
Yes.
Okay. Would anyone like to make a motion?
Oh, yeah. Yeah. Okay, so when you changed your voter address at the polling place, you had to sign a form for them, correct?
Yes,
And that was under penalties of perjury?
I believe so, yes.
So I would note that IC 3-5-5-6 states an individual makes a statement regarding the residence of the individual under the penalties for perjury is presumed to reside at the location specified by the individual. So as at a bare minimum, she is presumed to have lived there for as of November 7th. And so, and she is saying that she moved in October 11th. So although it's not determinative, totally determinative, I think it all ties in. Yeah.
Well, I would move to deny the challenge. I mean, we've had challenges like this before, based on different residency things, and it's the intent to reside. And I think this is a electronically signed lease in this day and age. To me, that's sufficient. I think we've accepted evidence equivalent to that in the past, and I think it's sufficient, and it predates the 1-year cutoff that's required. So I would move to deny the challenge.
Have a motion. Is there a second?
Second.
Any discussion, questions?
While I agree, I don't think the presumption gets us there, because that's November 7th and we're looking at the 5th. But I agree as far as the intent goes, so.
Yeah. Again, affirming that that's sort of where the element of the law is, that there's a proven intent to reside there a year prior. I would agree with my colleagues, my counterparts. So with that, we have a motion to deny the challenge in a second. Calling to the vote, all those in favor signify by saying aye. Aye. Those opposed, the ayes have it. The challenge is denied. Therefore, I direct the co-division, the election division is directed to include the name of Sarah Scheidale in the certified list of candidates to be printed on the ballot. Thank you.
Ms. Shadow? Could you come here? Just stand and say what you're gonna do.
And I hate to do this, but I am going to take another 5-minute recess.
Okay.
So we will be back at 12:55 in this same location.
Can we eat? Can we eat?
Well, we could.
All right. Well, Mr. Smallbladder has to hit the restroom again, so we are now taking another 5-minute break. It would be awesome if they didn't kill the feed this time. It would make much better sense if they just kept it rolling. We'll see what they're going to do here. I find it interesting that one of the people on the board, her name is Litany, Litany, Litany. Litany is a noun that is a series of petitions for use in church service or processions, usually recited by the clergy and responded into in a reoccurring formula by the people. It is also, and this is what I think is interesting, it is also used, the word is used to mean a tedious recital or repetitive series of anything. So I think that's kind of interesting, a tedious or repetitive recital of nonsense. So I think that's quite interesting. Oh, look, they did actually do the right thing this time. They just kept this up and they said that they're on a short break. Please stand by. Somebody finally decided to do the right thing here.
Oh, it's 5 minutes.
I do want to say a couple things. You know, I really wish that the county election boards throughout all of Indiana's 92 counties, I believe that they would watch this. I wish they would be made to watch this. I almost wish that for these meetings, they would have to, I don't know, be called into order and have to watch these as a unit, because I think there's a lot to be gained, both good and bad, from here. I think it's rather interesting. It's interesting on this short break. We'll see if they say anything down here, because they've got their their closed captioning is on. So while they're on break, anything that gets picked up, anything they say, we'll have to see if we get any really interesting hot mic issues, because there's a couple people standing over there by the mics. Let me get rid of the logo here. You'll be able to see it. That's comical. You know, doing, redoing conference help people. You know, doing, redoing conference. Come on, let's say it. Say something good. Give us a hot mic moment. Yeah, oh, is that right? That's like that. And now we got a dog out there. I wonder if it's picking up like that. That's wild. So let's see.
I believe we as school board members face challenges to.
Oh, of course, yeah, you're really picking up.
I don't know what you're saying, but I just ran back.
Here.
I didn't say anything I'd be ashamed to say in front of other things.
Oh, they just learned to draw a hot mic.
Would you like
Where are you?
All right, wait. Let me back this volume back down here. Nicole, what are you referencing? Nicole says, but it took an FBI investigation and a 7-year residency to get this behavior. I don't feel like they are acting this way because they want to. What are you referring to? Are you talking about Delaware County? Where? Tell me what you're referring to. No, they are upholding the law, it seems, here and strictly by the books. They're upholding the law, it seems. I mean, are you talking about during this in this election board meeting? Oh yes, Delaware County. Now Delaware County is all over the place, and I'm going to tell you, the FBI investigation was basically only into city government. City government. They didn't really investigate Delaware County government, and the mess that we're in Delaware County is now crazy. Now the Delaware County Election Board meeting part 2 will pick up tomorrow, and I'm not convinced that they're going to do the right thing. They need to do the right thing. They need to do the right thing, but I'm not convinced that they will. Quite the opposite. I think I have them over a barrel. I think that there's 2 choices. They can do the right thing, or they can be they can do the right thing, or they can show themselves to be hypocritical. So we'll have to see. That meeting will start at 1 p.m. tomorrow, and it will be live streamed here at 1 p.m. The Election Commission is a reality TV show, such a mess. Absolutely they are. FBI acting, or those in Indiana, FBI's pattern and practice speaks for itself. Karen O, that's exactly true. Why wouldn't they do the whole county? They only investigated a small sector. Yeah, so here's the thing. That's a good question. Because so basically what happened is, when they got called into Muncie, they were called in for just a very small specific issue. And basically what happened was, when they got to Muncie and they started investigating, they very quickly started kicking over the rocks. And every rock that they would pick up, they then became aware of, oh, now we've got all of this other crap we've got to look at. And oh my God, now we've got all of this other crap we've got to look at. So that's the reason it took so long. And then, like right smack dab in the middle of it, bam, the Department of Justice got another situation out of Muncie with the police brutality. So essentially, during that 7.5 year investigation, there were 2 separate investigations going on with the federal government. So you had the federal government investigation called Operation Public Trust, which was into the Mayor Dennis Tyler's administration and the Democrat Party and businessmen and politicos in and around city government and the Delaware County political party known as 214, the Democrat Party. And that's all that was really looked into. Now, you had that, and then you had the police brutality situation. So they didn't really look into Delaware County. They needed to. I still think they need to be looking into the city of Muncie. I think that we need a total reworking. I think the State Board of Accounts needs to come in. I think the Department of Department of Local Government Finance needs to come into it. It's been crazy, absolutely crazy. Hey, look! Kate Thornburg is here. Producer Kate. She says, "Oh, Kristopher, that's asking a lot." That's when I was saying Delaware County could do the right thing. Yeah, I do want to remind everybody. Number one, we will have commentary this evening. There will be commentary this evening at 9 p.m. So tune in here for commentary this evening at 9 p.m. Eastern, right here on the Political Spotlight. At 1:30, I'm also going to be monitoring the conference on JD's 1338. I'm also going to be monitoring that. And if we need to break in the middle of these challenges to show you something there, we will do that. So tonight at 9 p.m. we'll be going live for commentary, and then tomorrow, Wednesday, February 28th, candidate challenge, the Delaware County Election Board will meet for part 2. And tonight we will also be discussing what happened with the Delaware County council meeting today, because while we were in session just a few moments ago, I clicked over to watch it, and it was still going on by at 12:20. The meeting started at 9 o'clock today, so 9, 10, 11, 12. It was like a 3.5 hour long meeting. So okay, we're gonna get ready to kick back here into the rest of this meeting here, and we'll be with you in just a moment. Ladies and gentlemen, they are getting ready. They're starting to take their seats. You can kind of see up there in the right-hand corner. They are getting ready to take their seats, and we will be getting started. And Nicole brought up a good point. I don't know what she meant. She said it looks like everybody is on Facebook for this. LOL. I just want to let you guys know, for those of you that watch and comment from Facebook, Facebook has been giving me a problem here in the last couple days. I've had a couple people say that they were unable to find the video on Facebook. And I'm going to let you know that Facebook, over the last about a week, as soon as I've been going live, they've been sending the feed out, and then Facebook has been blocking it. So if you want to follow me and you do not want to miss contact, you don't want to miss the videos, the content every Sunday through Thursday and other stuff, you would probably do well to get on YouTube and just go through the process. Make you a quick name. You can make a fake name. You can make your real name, whatever you want to do, and then go to the Political Spotlight on YouTube, subscribe, and hit the bell. That way you get notifications and you'll be able to comment. You can watch me without creating an account. You could just type in www.youtube.com and you could go to the Political Spotlight. However, if you do that, you can watch it, but you will not be able to comment. In order to comment, you do have to make an account, and you do have to, do that. Now, it's absolutely free. It does not cost you anything, but just keep that in mind. We'll be on tonight at 9 p.m. for the commentary, and it looks like this meeting is getting ready to start, so I'm going to shut up and let this get back to it.
What I documented in an email to the four of us.
Okay.
Perfect. Thank you.
(2024-13). In a second, any questions? Hearing none, all those in favor signify by saying aye. Aye. The ayes have it. The matters are now. Mr. King?
I'll take this
Yeah.
one. Yeah, so this matter in the challenge of the candidate Jonathan D. Brown, the challenge is that Mr. Brown does not have two consecutive same party affiliation primary votes as required by Indiana Code 3-8-2-7 4-8B. In this record, in your binder, you have the Can 1 challenge. You have the candidates Can 2 as well as documentation that notice was served. In addition to the record that Ms. Nussfire spoke of earlier, that Mr. Brown had called the office to say he would not be present today.
Okay, thank you. With that, I'll recognize Mr. Willis. Please state your name and spell it for the record.
Good morning. Russell Willis, RUSSELL, very quickly, as outlined, Mr. Brown does not have the 2 primaries required to run in the Republican primary as required by the IC code as she listed. I included in my filing a printout of his SVRS showing only a general election ballot cast in 2020. He has 0 primaries.
What's the other, a letter from the chairman? Is that the other?
Yes, there is the opportunity to have a letter from the chairman as your other
And that's
for
not been
Indiana
provided?
code. No, we do not.
Okay.
With your declaration of candidacy, you could provide that if you did not have the 2 primary vote history.
And I am the county chairman of Madison County, and I did not provide a letter.
Okay, thank you. Well, given that Mr. Brown is not present to cross-examine, do we need to hear from Hewer too, if they're consolidated, or does it?
I believe that would be accurate to give Ms. Hewer the opportunity to make her case as well.
I'm sorry, Ms. Hewer, is she present?
Good afternoon. My name is Kelly Hewer, Kelli, last name Heuer, and I am here challenging Mr. Jonathan D. Brown on the fact that he does not have the 2 primaries for this office.
Same challenge, okay. Thank you.
I actually have a question about the law. I'm reading our statutes more carefully. Well, I always read them carefully, but so the interesting thing about and I'm just asking for how we interpret this because I don't know. Something that I noticed is that, I mean, we know that there's the 2 primary rule, but the statute doesn't say, so this is a situation where the candidate hasn't voted in a primary period. So do we interpret the law to mean that if they haven't voted and want to be on one of the major party nominees, that then are we reading the statute to mean that your only avenue then is to get the certification from the party chair? Is that?
Yes, that is how I would read it. As Indiana Code 3-8-2-7A4, it says a statement of the candidate's party affiliation. For purposes of this subdivision, a candidate is considered to be affiliated with a political party only if any of the following applies, and that being the 2 most recent primaries or the certification of the chair. So that is how I interpret it.
Okay.
But I guess it doesn't say that if they didn't vote, but I'll be quiet about that. I mean, I guess that's what I noticed. It doesn't say what, it talks about the 2 most recent primaries where they voted. So I think by default, then it's the assumption they have to have the party chair certification. But again, a point where it's not abundantly
Clear. Yeah. But in this case, we have neither.
Right.
Anyone want to make a motion?
I would move to uphold the challenges.
Okay. Is there a second? I'll seconded. Any further discussion, questions? Hearing none, all those in favor signify by saying aye. Aye. The ayes have it. The motion to uphold the challenge is affirmed. The election division is directed not to include Jonathan D. Brown in the certified list of primary candidates sent to county election boards and indicate the name of this candidate not be printed on the ballot. Thank you. Appreciate it. Welcome back.
Thank you.
Next is Willis v. King, cause 2024-10, in the matter of the challenge to Scott A. King, candidate for Republican Party nomination for United States Representative, District 5.
Mr. Chairman, this is
Are there are there two in this one as
Yes,
well?
there are. Mr. Willis and Ms. Hewer have both challenged this candidate as well. So wanted to
So,
bring that up in case. you
Yeah,
wanted to
I'll
know.
note the other cause number is 2024-14. And that's Hewer v. King again, correct? Okay. Is there a motion to consolidate those as well?
So moved.
Is there a second?
Second.
Second. Any discussion? Hearing none. All those in favor signify by saying aye.
Aye.
The ayes have it. The causes are now consolidated. Valerie?
Yes. Mr. Willis and Ms. Hewer brought a challenge against candidate Scott A. King for U.S. Representative District 5. Can 1 challenge is in your binder. The challenge is because the candidate does not have 2 consecutive same party. Yes, does not have the most recent primary votes as far as the 2 votes or the county chair sign off. And that was in your binder on both of them, as well as notice to the candidates.
Okay. And by the way, is Mr. King present? Okay. Mr. Willis?
Russell Willis, RUSSELL, WILLIS. And as outlined, he does not have the 2 primary votes. I've included in my documents that I turned in for Mr. King. He has 1 primary in 2022, and that is all.
Ms. Hewer, would you like to make any statements?
Again, my name for the record, Kelly Hewer, Kelli, last name Heuer. And to just reiterate, Mr. Scott King, I filed this challenge because he only has the 1 primary and not the 2.
Okay. So exact same circumstances as the prior cases. Mr. King not present. Is there any motions?
I would move to uphold the challenges.
Is there a second?
Second.
Having a motion and a second to uphold the challenges in causes 2024-10 and consolidated with 2024-14. Any discussion, questions? Hearing none, all those in favor signify by saying aye.
Aye.
The ayes have it. The motion's carry. The election division is instructed to direct not to include Scott A. King in the certified list of primary candidates sent to the county election boards and indicate that the name of this candidate not to be printed on the ballot. Thank you. Moving along.
Mr. Chairman, if I might, Mr. Willis and Ms. Hewer had also challenged, and I apologize, I'm not sure I'm going to say his name correctly, Mr.
Fenninger.
Fenninger, thank you.
Mhm.
Mr. Willis has asked to have that challenge withdrawn. I do not have that same notice for Ms. Hewer.
Okay, so we have,
If I may, Mr. Chairman, in the binder, it actually does have the withdrawal or the dismissal from Ms. Hewer. It's in the very back of the book.
Thank
Okay.
you.
She actually sent the email, I think, before Mr. Willis did.
well, so we have Willis v. Fenninger, cause 2024-11, Hewer v. Fenninger, cause 2024-25. So one, can we consolidate these?
I'd move to consolidate.
Second.
Having a motion to consolidate in a second, all those in favor signify by saying aye.
Aye.
The ayes have it, the motions are consolidated. Or, sorry, the causes are consolidated. And in each case, we have, you both agreed to withdraw your contest. So can we just take a motion on to dismiss?
So I move to dismiss the challenges or accept their motions to this. Seems odd.
Yes.
Move to dismiss. Yeah. Move to dismiss.
The challenges.
Second.
So we have a motion to dismiss causes 2024-11 and 2024-25 and a second. Any discussion, questions? Hearing none, all those in favor signify by saying aye.
Aye.
The ayes have it. The matter is dismissed. Thank you.
Thank you.
Next, we have Dixon Tatum versus McCormick, cause 2024-12. The matter of the challenge to Jennifer McCormick, candidate for the Democratic Party nomination for governor.
Oh, yes.
You're
Excuse me,
good.
Mr. Chairman. Yes, Mr. Chairman, members of the commission, you'll find in your binder for this cause a copy of the Can One Candidate Challenge filed by the challenger, as well as an appearance form for counsel for the challenge candidate, Jennifer G. McCormick, a copy of candidate McCormick's declaration of candidacy, their Can 2 that was filed with the states, along with an attachment of their required statement of economic interest filing, a copy of the notice of hearing that was sent to both parties, as well as documentation that the division sent that notice of hearing to both parties.
Is Ms. Dixon Tatum still present? Okay.
I would move to dismiss the challenge since the challenger is not present.
Is there a second?
Second.
Okay, we have a motion to dismiss the cause 2024-12. And we have a second. Any conversation, concerns, questions? All those in favor signify by saying aye.
Aye.
The ayes have it. The matter is dismissed. Thank you.
Thank you.
Okay, looks like we have several causes here for the Rust matter. I'll go ahead and read them off individually. We have Neal v. Rust, cause 2024-15, Schickles v. Rust, cause 2024-16, Williams v. Rust, cause 2024-17, Shields v. Rust, cause 2024-18, Stafford v. Rust, cause 2024-19, and Babcock v. Rust, cause 2024-26. And I-
Mr. Russ just ran to the restroom because we thought we were gonna have that one challenge buffer, so we'll be right back.
Sure.
I'll summarize if you're ready, Mr. Chairman.
Yeah, please do.
Okay.
Or do we need to consolidate first? or
Well,
can we-
I was gonna say that we have 6
Okay,
challenges in
yeah.
the case to Mr. Russ.
Go ahead,
That would be my
yep.
recommendation if you would like to consider consolidation.
Yeah, they all sort of are along the same lines.
Yes. Yes, the challenge is under that Indiana Code 3827A4, that Mr. Russ does not have the primary vote history as required by statute or a letter from the chairman. And then under each of these filings, you will find exhibits from the attorneys as well as appearances for each party. Exhibits include, let's see here, we've got depositions, vote history. That pretty well covers it, I believe, as well as notice that was served on both parties.
Okay. So I guess first up, we have Mr. Neal. Oh, sorry. Is there a motion to consolidate these 6 causes?
So moved.
Is there a second?
Second.
So we have a motion to consolidate the 6 causes and a second. All those in favor signify by saying aye. Aye. The ayes have it. These causes are now consolidated. Sorry, Mr. Neal.
Mr. Chairman and members of the commission, my name is Ryan Schaus, attorney on behalf of Mr. Neal and others. That's RYANSHOUSE. Myself and Paul Mullen, MULLIN, and Will Young, YOUNG, represent Michael Neal from Hamilton County, Larry Schickles from Harrison County, Cameron Williams from Marion County, Danny Shields from Monroe County, and Damian Stafford from Whitley County. I will note for the commission, we do not represent Kyle Babcock, but all the individuals who I represent are here today in the crowd.
Excuse me, one moment.
Yes.
Is Mr. Babcock here today?
Yes, I'm here. Yeah, he approached us earlier.
Okay.
Yeah, he's there.
Okay, this is a straightforward application of the affiliation statute. We just saw 2 individuals struck under this same statute. Mr. Russ is not eligible under the affiliation statute to run as a Republican for United States Senate in the 2024 primary. Mr. Russ did not vote as a Republican in the two most recent primaries in which he voted. He voted Republican. The time before that, he voted in Democratic primary. For the last 5 he's voted in were Democratic primaries. And then on subsection B, Mr. Russ did not receive certification that he's a member of the Republican Party from the Jackson County Republican chairperson. We have included Mr. Russ' voting history as an exhibit to the challenge and exhibit to our memorandum. And I'll refer, I won't belabor the memorandum, but I will note that we did draft a full memorandum on these issues for you guys along with exhibits. Mr. Russ filed a declaration of candidacy and both boxes, both boxes are unchecked. The affiliation statute applies to Mr. Russ, just like it applies to all other candidates in the state. And we ask the commission to uphold the challenges to Mr. Russ and direct the court not to include him on the certified list of primary candidates sent to the county election boards and indicate the name Mr. Russ not be printed on the ballot. Thank you.
Thank you. Would you like to cross-examine?
Should Mr. Babcock present, or does he want to?
Mr. Babcock, would you like to make any comments?
Or do you want to adopt and incorporate what was just said?
Would you want me to make my presentation now or not?
I believe that would be right, since you
Yeah.
consolidated.
Do it now.
First of all, thank you, everybody, for being here and a part of the process.
Spell and say your name.
Kyle, K-Y-L-E, Babcock, B as a boy, A as an apple, B as a boy, C-O-C-K. And thank you. I know you're not here for the high pay, so thank you. I'm going to start here. I've got some documents. I made copies. Do I give them to you? Okay. To Valerie, yeah. There are 4 here plus 1 for council. Yeah, I made a copy for you.
Mr. Babcock, I just have a question.
Yes, ma'am.
Do you have, I mean, one of the things that you can do is adopt and incorporate what these gentlemen just presented. Is there something further that you want to add, or?
I appreciate your advice, but I think my 3 or 4 minutes may be a little bit different than theirs.
Okay.
So I appreciate your advice. Thank you for that. Please proceed. So one of the reasons I'm here is I've read in the press, and that was my complaint, that Mr. Rust has not met the requirements. My understanding is from press reports, I looked at the Indianapolis Star, I looked at the Capital Chronicle and the AP, 3 trusted publications. I've not done any other research on his voting record or anything like that. But as a longtime Republican Party person, elected, non-elected, I take offense, and I'm challenging Mr. Rust for his constant challenging of he's involved in the process and he wants to challenge the establishment. I have been on the state platform committee since 2008. I've attended hearings all over the state. Mr. Rust had plenty of opportunities to come and express his concern about any process in the Republican Party. I've traveled around the state. I've been at every convention since 2008 as an elected delegate. I've never seen him there. So when he says he wants to shake up the process, I just have one thing. The rules are the rules. And so I look at this and look back, and even looking at his 2018 voting record, the primary that he was running in right now for United States Senate, he failed to vote in the 2018 primary, one of the most hotly contested Republican primaries in the history. Mike Braun, Todd Rokita, Luke Messer. If he can't even vote in that primary, that's a problem to me. We have rules. The legislature established these statutes. That is my point. I see him talking frequently that he is a Republican. Well, I'm an optimist. I've been an optimist my whole life, just like maybe he's a Republican his whole life. But that doesn't mean I can go to the Optimist Club and file and run. They have rules too. The Republican Party has rules. Thank you for your time. Would you like to cross-examine on anything Mr. Babcock had to offer?
No.
Okay. Thank you. Do you have 5 minutes?
I don't get 10 because he had 5 and he had 5 just because he didn't use it. Please.
Sure.
Oh, thank you.
Since there were two presentations, we don't have to vote on it. Should be afforded 10 minutes.
Are these all one document together for the commissioners?
They're separate documents. Yeah, but those are documents I'll reference and. We ready? Okay, so as this commission knows, there's currently pending before the Indiana Supreme Court a case challenging the constitutionality of Indiana Code 3827A4. The Indiana Supreme Court has not yet issued an opinion on the matter yet. And in any case, win or lose, we hope the Indiana Supreme Court gets it right, but Russ will seek intervention from SCOTUS if we do not prevail. Yes.
So as an attorney, we realized that you had a very, and I thought it was extremely well written, actually. Judge Dietrich had written an opinion that granted you the injunction that would have put Mr. Russ on the ballot. The Indiana Supreme Court had the issue before it of whether it should stay that decision or whether it should go ahead and uphold it. What they did was to stay it and said that they would be issuing an opinion shortly to explain that. Now, as a practitioner, when a court does something like that, they knew that it was going to make us go back and revert to the law as it stood before Judge Dietrich's opinion. So how do you get around the fact that the Supreme Court, albeit indirectly, has spoken and says that we are to apply the law as it currently stands until they tell us otherwise?
That's a great question, and I'm going to explain that as part of my presentation. So first, I want to point to a case that is in the record. It's a week before, or actually, so January 18th, you might be familiar with the Richard Allen case with the Delphi murders, okay? So there was oral argument on that case, and that same day, the court issued a motion or an order, not a full opinion, saying, this is what we're going to do in the case, and here's our order in the interim. And they said very specifically how they were going to rule and what their order was. In the Rust case, they didn't say anything about their ultimate order. They said they were going to grant the stay. They didn't say their ultimate order was in favor of either party. And that's important because the Indiana Supreme Court will tell in its order if it has made a final decision. We don't know that the justices have come to rest on this. If you watch the oral argument.
But Counselor, here's my question. That Supreme Court knew that we would be having this hearing, that the deadline for us to rule on challenges was by noon on the 29th. So they knew that, and they told us by giving this stay that we are to proceed under the law as it is written. And so how can we, I mean, they've told us that we're to proceed under the law as written, and we can't sit as a court. So how can we possibly?
I'm getting there.
And I apologize, Mr. Russ. I'd love to see you on the ballot, but.
So I'm going to explain how the timing here is kind of significant and unique. So the state defendants filed their motion for stay contemporaneously with their notice of appeal on December 8th. Okay, the trial court order, which you have a copy of, was December 7th, as you recall. So there's two things here. So first of all, under the appellate rules, they're supposed to file their motion to stay with the trial court unless there's extraordinary circumstances. They've alleged there's extraordinary circumstances because they thought the trial court judge would rule against them. That's not extraordinary. That's true when any trial court judge issues an order that he doesn't want to revisit it.
Just a quick question, is that what they actually alleged, or is that what you're assuming they alleged?
Or it's in their filings. You
Okay,
can read
all
those.
right,
Yeah.
just
So they said that was, part of the emergency, that the trial court judge was certainly not going to rule for them, which is interesting because the Attorney General's office had another case where there was the dollar law and a building was about to be sold and there was a 3-day window and they still filed in the trial court, and that wasn't extraordinary, but this is. So in any case, we had 2 months, okay, where the Indiana Supreme Court could have ruled that it granted the stay, and it didn't grant it until 23 hours before the challenge deadline. Why is this significant? Because from December 7th through February 13th at approximately 1 o'clock, Indiana Code 3827A4 was enjoined. The candidacy filing period here ran from January 10th to February 9th at noon. During the entirety of the candidate filing period, the statute was enjoined, okay? This is important. Rust and I both went to the Secretary of State's office together, where we confirmed that the form, even though it had an affiliation section, it's part 3 on the CAN 2, even though it was there, it's because they don't update the forms, but annually. And that at that period, it shouldn't have even been on the form for you to have to check a box because the statute was enjoined. And furthermore, they confirmed that Mr. Rust did not have to check a box. This was true the entire candidacy period. So,
Counselor, but let's say that your argument is correct, and that box shouldn't have been on there, but while that stay is pending, and if it had held, the fact that they say, okay, disregard this because you don't have to worry about it because you voted in one primary instead of 2, that's the same equivalent, isn't it? You see what I'm saying?
It's unique because here, Rust, had he known that had the statute been in effect at any point during that candidacy filing period from January 10th to February 9th, if he had known, he could have done one of 2 things that is very important here. First, he could have went back to his party chair and asked again for certification. This commission, through its counsel, and it's in the materials I provided, wrote in a brief that Mr. Rust's assertion that he would not be certified was speculative and that there was no way to know if she would change her mind.
First, I would just tell you that there were 2 members of this commission who expressed no opinion regarding the position that was taken by the Attorney General. We felt it was not.
Oh, I'm not privy to that, so, yeah.
That aside, the court, Indiana Supreme Court knew all of this. The fact that Mr. Rust was able to go on, that's fine. I mean, I listened to the appellate arguments. I've read your briefs. I've read Judge Dietrich's opinion and all of that. And I certainly have sympathy for him because I think as applied to him, he could not have voted. Was it the 2022 were the municipal elections?
He can't vote in any municipal election because he lives outside the city limits.
And so as applied to him, he gets put into a special circumstance that is not applied to people who live within the town limits of Seymour, who all have the opportunity to be able to get to elections.
He could have just complied this past election cycle.
I didn't hear that argument made. It was very briefly touched upon. And so the Indiana Supreme Court we'll see if they address it. If they don't, then possibly it could be raised again in the future for something. But
it was briefed and we didn't, obviously the oral argument's 20 minutes. We don't get to touch everything, but there's a second part to this. So the commission, which is you guys through counsel, I understand you might not have agreed with counsel, asserted that he could have sought certification and maybe gotten it later, that the party chair could have changed her mind. What I'm saying is if the statute had not been in place during that candidate challenge hearing, he would have then had 2 options. He could have looked for her to certify him, which there's a judicial admission that was a possibility. And then secondly, he's running for state senate. He could live anywhere in Indiana, which means he could have relocated to a.
Counselor, I'm sorry, but he could have also, the stay was in place. He knew that the stay was not in place. The decision was there. The stay hadn't been decided. He knew there was a request for a stay. So if he knew that there was a request for a stay that could come any day, then he could have gone back and asked for the certification then. He'd had reason to, wouldn't he?
Well, no, not necessarily. When the stay remained in place, we were watching and waiting the entire candidate filing period. The appropriate time for the court to have done something would have been toward that, in that window, because after that window, he has the opportunity to do nothing. The other option was he could have relocated. In the materials I provided, we have the affidavit from LaPorte County attorney or party chair, Al Stevens, who would have certified Rust had he moved to LaPorte County. Relocating your residence when you grew up in Seymour is a big deal. You don't want to have to do that if you don't really have to. we got through the candidate filing period and it seemed like things were going well. We couldn't have anticipated that 23 hours before the close of the challenge hearing that there would be a stay, when for 2 months the Indiana Supreme Court sat on it. And just like they might have anticipated that you all would be hearing a challenge, they'd also had to anticipate that I would be making these equitable arguments about that window, and they didn't act in that window. They could have acted in December. They could have acted in January. They could have acted in the middle of the window. They could have acted 23 hours before the close of the candidate filing period, but they did not. We do not know how they're going to rule. And pending right now, also in the materials, is our motion for relief from the stay, at least as to Mr. Rust, which they haven't ruled on yet. So there's a lot of things at play here. He did not have an opportunity to reevaluate his position and seek certification or relocate. We have a pending motion. And the trial court order, you know, it's still out there factually about what happened. The other side has tendered a brief where it challenges Mr. Rust's statistics about the impact of the statute, but the court found them as a matter of fact. And those factual findings, as you attorneys know, are reviewed with a very deferential standard. So while the Supreme Court can take issue with their legal findings and review those de novo, the factual issues about the statistics and how this statute makes it so that the majority of Hoosiers cannot run for office for the party of their choosing, those remain and will likely be deferred to. So
Ms. Hart, I mean, so number one, your client could have done all kinds of things to protect his interests. Like he could have played by the rules in existence, hoping, you know, hope is not a strategy, hope's not a plan, whatever the phrase is. I mean, can always hope that the Supreme Court is going to find a state statute unconstitutional, but all of us in the legal profession, all of us in this state knows that that rarely happens. So putting all of his eggs, to draw the point for your basket, in one basket seems a little risky, right? So he could have relocated. Yeah, because it's one of those things when you're wanting to do something like run for US Senate, which is a really big deal, you might decide, if you want it that badly, that you make the big decision to move somewhere else, or you might get certified. Now it brings into mind carpetbaggers and all that kind of stuff. But anyway, that is something that could be done, right? He could have done that. He could have said,
he started the process.
But it didn't happen, right? It didn't happen. And I mean, I agree with what my colleague was saying. I mean, the Supreme Court stayed Judge Dietrich's order without any comment, which to most of us is a signal that his order, as well written as it might have been, or is probably going to go down the tubes, right? I mean, the Supreme Court is probably not going to be upholding that order. And it just, I mean, so the theme of the day has been playing by the rules, and that's the issue. We've got the same issue here that all these other folks have had, which is that, you know, if you want to run as a candidate in this state, there are rules that you have to follow. And I think too, you know, it's part of because there are other court cases that talk about the fact that the parties have the political parties themselves have the constitutional right to determine who gets to associate with them. There's a Seventh Circuit decision that talks about that. And so this concept of, well, you either have to have the 2 primary votes for the party, which is something you can do, and you don't even have to know who your party chair is, as long as you vote with that party 2 times the most recent 2 primaries, you're good to go. Or you need to be friendlier with the party chair of your county, right? Or find a friendly, you know, you forum shop and I guess find someone who is friendly to you. But I mean, those are just the rules, and the political parties the courts have recognized that they have the constitutional right to control who, to a certain extent, who gets to be affiliated with them in terms of being a nominee for the primary. And that's, I mean, none of these arguments overcome that. They just don't overcome it.
Well, I completely agree. And I think to the point made, the option being a U.S. Senate candidate to relocate was an option not afforded some of these others that have come before. I mean, you had great latitude to remedy your own situation potentially, albeit not a decision that could have been made lightly, but there were past success there, and you failed to take advantage of it.
Well, he was in the process of it, but because the entire candidate challenge period or filing period, we had an injunction in place, it just wasn't necessary. There's nothing we can do to undo.
Clearly, that's not right. At this point, it clearly wouldn't be necessary.
Right,
Well,
Ms.
at
Harder,
the
I
t-
think you need to, let's move on from that point, because obviously we don't agree with your position saying that he couldn't do anything because
He could have.
he could have.
But he didn't have
But
to.
well, it doesn't matter. He could
Well-
have. You protect your interests as a lawyer. So let's just move on from that. I still don't see how we can get around the Indiana Supreme Court. Previously, when I was talking about with the Trump challenge and everything, there was no direction from the US Supreme Court. Still hasn't happened. Indiana Supreme Court has spoken to us and they've told us to enforce the law as it was originally written. And Mr. Russ, I'm serious when I say I would love to see you on the ballot. But as far as I'm concerned, our hands are tied. So you tell me how we untie them.
The practical reality is the Indiana Supreme Court is the last word on the Indiana constitutional issues that we've raised, and we did raise those. But we also raised several federal constitution issues. And for those issues, not only is the Indiana Supreme Court not the last word, SCOTUS is, but we're not writing on a clean slate. We have lots of case law that has never upheld a ballot access restriction for longer than 12 months. This statute is up to 4 years, maybe more, depending on if you live.
Argument to the Indiana
I
Supreme
did,
Court,
and
right?
I'm just trying to answer your question here. We do have some guidance from SCOTUS, regardless of what our Indiana Supreme Court does. We hope they follow that guidance, but if they don't, they're not the last word. A Seventh Circuit case doesn't overrule US Supreme Court precedent. And that's really what the other side kind of hinges their whole argument on, is that that case from the Seventh Circuit, sorry, it slipped my mind for a minute. So we do have case law that supports our position from the US Supreme Court, regardless of what our Indiana Supreme Court does. I mean, they haven't issued a ruling yet, but if they don't, we're obviously gonna take it up. So we do have some guidance. The guidance is pretty clear. There's never been a ballot access restriction for as long as what we have presented by this statute here. And the the rights of voters and the rights of candidates are corollary to each other. So here we have a situation where John Rust has tendered over 11,000 petitions and has a lot of support in Indiana. We're going to disenfranchise all of those voters if he can't be on the ballot. And we're going to have a US Senate race with one candidate. And it's fine that the party leadership has endorsed him, but the party is made of not just the leadership, but all of the party members. So the party leadership has some rights, but they don't supersede the rights of the individuals that comprise the entire party. Is that me? Oh. So there's that issue as well. There's a great voter disenfranchisement issue. It's very unfortunate that they issued the stay 23 hours. He's already campaigned. He already has a following. If this challenge is upheld, we have no choices on the ballot. We have to just adopt Jim Banks, who interestingly was endorsed by the party even before Mr. Rust entered the race, which is sort of an unprecedented move. And it's sort of scary. It moves us towards sort of Soviet-style elections where here's the candidate, take them or leave them, right? We have no choices. So this is a big deal, and I understand that we don't have a final ruling from the Indiana Supreme Court, but they haven't spoken. It seems like they're split, if I had to guess, based on their behavior, because they didn't put in an order. Here's how they could have, and they do often, if you follow them. They will put, we're going to do it this way with reasons to follow. They did grant the stay, but they didn't ultimately indicate an outcome. And we know it was a split ruling because it says a majority of the court, which could be 3-2 or 4-1. So I don't think we can assume what the Indiana Supreme Court's going to do. And I understand and appreciate that they lifted the stay, and they might have done so for any number of reasons, perhaps to not tip their hand about what way they were going to come out. Because if they had denied it, then it would seem to be a pretty strong signal that they would go for Mr. Rust. I think they're still figuring it out. They seem very split in oral arguments. So I don't think we have clear guidance from the Indiana Supreme Court. We do have some US Supreme Court guidance on this issue. There's lots of things at play. I attached the trial court's order, which I'm sure you're familiar with, as well as some briefing. I don't know if there's any other questions you have.
Well, we did eat some of it with some
Well,
engagement.
no, I've been pausing.
Okay, oh, yeah, okay.
Yeah, it's been a while.
Would you like to cross-examine? Does that apply to you, Mr. Babcock? Would you like to cross-examine? No. Thank you. Appreciate it. Okay, is there a motion?
Just as a comment, I guess, I know we're talking about all these federal cases here and you seem to think that they're very clear to establish things and that they take precedence over the Indiana Supreme Court. And I guess my opinion there is if it was that clear, they would have made a final opinion for you. So I guess that's where I stand on that. I'm going to move to uphold the challenge.
Is there a second? I'll second it. So we have a motion to uphold the challenges in the 6 consolidated causes and a second. Any further discussion? Any questions, comments? Hearing none, moving to a vote. All those in favor signify by saying aye.
Aye.
The ayes have it. The motion's carried. Challenges are upheld. The election division is directed not to include John Rust in the certified list of primary candidates sent to county election boards that indicate the name of this candidate not be printed on the ballot. Thank you. The next matter, Biniak, is that correct? Biniak v. Lester, cause 2024-20. In the matter of the challenge, Trent A. Lester, candidate for Republican Party nomination for United States Representative District 4.
In your binder, you have the Can One challenge, and the challenge is also based off the 2 most recent primary votes are not Republican, and there's no chairman certification for Indiana Code 3827A4. You also, on that second page, have the vote record as well as the candidate's declaration of candidacy and the notice that was served on both parties.
Thank you.
Thank you. And then I've just been given copies for each member of, we'll call it Exhibit A. Did you give one to? Oh, thank you. Bless you.
I recognize, am I pronouncing it right, Mr. Biniak?
With my name, I've never been.
I got the same problem. Biniak, okay. And if you would, please spell that.
Absolutely. Thank you, Chairman, members of the commission. Scott Phoenix, that's Bravo, India, Echo, November, India, Echo, Kilo. I'm a registered voter in Greencastle North, Putnam County, which is in the 4th Congressional District. I filed a challenge against Mr. Lester, as was indicated, because he does not have the chairman certification, nor does he have a primary vote record showing that he's cast a Republican ballot in the 2 most recent primaries that he has voted in. In support of that, I think I attached to my candidate challenge, should be in your packet today, a copy of the vote record that I acquired from the Tippecanoe County clerk, wherein Mr. Lester resides, showing his vote history back to 2000. In fact, I don't think there's a single primary ballot cast by Mr. Lester. As one of the able commissioners noted, the First Amendment right against, or right to speech and association applies not only to a candidate and his supporters, but also to other members of a party, a political party, I myself being one of those. And I have a right to not associate with individuals that have not expressed a affiliation with the party to which I subscribe. And that's why I stand before you today. The Exhibit A that was handed to you today was something that was posted onto his Facebook page, basically confirming that the earliest that he could comply with this statute would be 2028, essentially saying that, look, I haven't voted in a primary. Again, I heard somebody earlier to say one of the hardest things in the law, and Ms. Horstman, I'm honored as well, as somebody else said, to appear before you today, but it's almost impossible to prove a negative. That's about as close as we can get. An admission by a candidate saying, look, I'm aware of this law, there was a law change, and the earliest I could could comply with it is 2028. So without the candidate or the chairman's certificate, I just don't think he can comply with the statute. And to address, because depending on what happens with SCOTUS, I may seek to intervene in that case as a registered voter. I want to make it very clear that the trial court's decision was an injunction. It was not a ruling on merits. And you want to rely on an injunction, you do so at your own risk, knowing full well that it is not a ruling on the merits and that the court may ultimately rule against you. In this case, our state Supreme Court has said, we're going to stay that injunction. They may seek emergency relief to the court, but I will intervene on that case if it happens, because I think I have a right as a voter as well. And I want to make sure it's in the record today so that I have something to show, my interest in that case. Thank you.
Mr. Lester, would you like to cross-examine?
No, there's no point. I do want to point out.
Go ahead and take the podium, and please.
Trent Lester, TRENT-LESTER. I do want to point out he was nice enough to put the date. That's when I went back and looked at the way that this whole ballot and primary selection is used. I have concerns, basically because I don't think I'm the only one that didn't check the checkbox that's not in here today. Maybe we pick and choose who we bring in here because we don't fit their narrative. Maybe we don't fit, or we're running against somebody that they particularly like. I don't know. I don't know why, but I don't think I'm the only one that doesn't have the 2 checkbox, 2 primaries, or the backing of my Republican chair. With that being said, I know the law is the law, and I accept whatever you guys obviously say. So thank you.
Would you like any cross-examination of those statements?
No, thank you.
Anyone want to provide a motion? Any questions?
To uphold the challenge.
So have a motion to uphold the challenge. Is there a second?
Second.
We have a second. Any further discussion? Giving your statements of admission, and I think we kind of are where we are. So we have a motion to uphold the challenge in a second and cause 2024-20. All those in favor signify by saying aye. Aye. The ayes have it. Motion to uphold is approved. The division is directed not to include Trent Lester in the certified list of primary candidates sent to the county election boards, and indicate the name of this candidate not be printed on the ballot.
Mr. Chair, I would move for a stay for 5 minutes so we can discuss the recent opinion, recess so we can discuss a recent opinion, court opinion that just came down.
We need to,
Okay, thank you.
did you move for?
Yeah, I'm asking for a recess.
Okay, is there a second?
Second.
All those in favor signify by saying aye. Aye. We'll recess for 10 minutes and appear back here at 2:10.
Yes.
And what's it say?
I'm sending it to you. Did you just do it? Okay. Yeah, he's sending it to you. Basically.
All right. I think so.
Roomy bug.
Valerie.
Good point.
Yeah, we got it, yeah.
Thanks, Paul.
Right, ladies and gentlemen, we were on another break there because apparently these people forgot that maybe they shouldn't have watered themselves like plants. Maybe next year they can start, wearing Depends or something. Like, good Lord. Where are we through on the challenge? Let's see. Okay, we're pretty Okay, so we are Rust. Lester. Looks like we're right here. I'll show you where we're at. Give me 1 second here and I'll pop it up. Looks like we have this much more to go. Here on the everything in blue, they might have already taken care of that Lester, that top one. I can't recall. Maybe they did. If so, then we're at Dole versus Fox. We're either at here, we're either here, or we're here. One or the other. So we've got 1, 2, 3, 4, 5, 6, 7. Oh no! Hold on, no, we're farther down than that because here's Babcock versus Rust. I am sorry. We are way farther down than that. So, ladies and gentlemen, I am sorry. We are here. So we don't have that much further to go then. While we were doing this, okay, so we should be at Camp V, Bonahum, I guess that's the name. And then Hathaway versus, hey, Alva, what's that name right there? Breaux. That sounds like an Alva name. And then Roy and Dossett, Eldridge versus Scheidel. And Weingarten versus Banks. And I'm hungry. I'm ready to get this show on the road. I can't leave until we get this solved. I do have some sad news to tell everybody. This is definitely some sad news to inform everyone. Oh my God, they killed the feed. Those idiots. Hold on. I'm going to have to go. I hate when they do that. I'm going to have to go and make sure that we're following it the proper way to make sure we don't miss anything. Okay. Well, anyway, we will be Bro. BRO is the pronunciation, Bro. So it's Hathaway versus Bro. Well, thank you, Alva. Thank you for that. I'm gonna have to start having Alva on the speed dial. They're listening to me. That's a very good possibility. If they're listening to me, I got a thing to tell them. Hey, y'all. So I do want to say to you guys, we got some sad news, and I'm going to get ready to show you this here. This looks like it's rather sad news here. Give me a second. What is this? What's merged? Give me a second. I'm reading. before, during governing body discussion, consideration of a topic, and before the governing body takes final action. Topic, the amount of time allotted for attendees to speak. Governing body may adopt reasonable rules or policies. Okay. Um, Dude, I don't even understand what this has to do. This is horrible. Okay, so I'm looking over. Let me get back here to show you guys what I found here, so I can show you this officially. The Senate Corrections and Criminal Law, they met today at 11:30. I thought they were supposed to meet at 1:30. They met at 11:30 a.m., room 130, and they heard House Bill 1338, and it passed 5 yeas, 2 nays. So out of the 7 members that heard it, 5 of them voted in favor and 2 voted against. It's now going to a 3rd reading. It will go to a 3rd reading, and then, ladies and gentlemen, it will become law. Now, we can still kill it at the 3rd reading, but it's going to take people calling and texting and emailing and talking in person to the state representatives and to the Senate, because now it goes to the full House, so everyone gets it, and they'll vote on both sides. And this is a full court press, all hands on deck. We need to be calling and emailing and whatever else we can do, and telling these people to not vote for this mayhem. This, I'm letting you know, folks, we'll talk about this more tonight, but this has probably been one of the most gut-wrenching years so far. From November 2023 till now, we've been dealing with some of the most ignorant, backwards bullcrap in town, city, county, township, state, and federal government. We are taking a pounding, folks. So it makes me sad. It's really rough. It's really rough. Okay, they're not back yet. They're still at the potty. They're still at the potty. So we can cut that down. So yeah, very, very disheartening. Very, very disheartening. It is what it is. We will be live tonight. I want to let everybody know we will be live tonight at 9 p.m. Tune in tonight. Whoops. Tuesday. 2, 27, 4 at 9 p.m. Eastern. It's going to be a big episode, folks. It's going to be episode 150. 150, folks. Can you believe it? We're going to be hitting the big daddy 150 episodes under the new political spotlight moniker. I'm really happy with the name. Really happy with the growth that we're having. Slowly but surely, we're getting there. I'm really happy with all of you guys that watch and comment and interact. And we've got the absolute best audience going. There is no better people. And one of these days when we have millions of viewers and we are going crazy, really making a difference, spreading the word and making sure that people are educated and we are living in a free society. Those of you that are here now, you guys will be like the original. You'll be the OGs. And I can't thank you guys enough. Honestly, some of you, I mean, all of you, but some of you people, it's really, Joe Tompkins, Alva, Joey, Karen O. I mean, all of you. I'm not leaving anybody out, but you know, you all are here. I love your interaction on any given night. The way that you guys tune in and the way just the I guess love that you guys show to us, and share with us is awesome. And the back and the forth and Jack and Lenny, hell, can't forget Lenny. But all of you do your part, and that's what's very cool. It's a to me it's like a family, I guess, like a grouping of people that I respect. And oh, here we go. We are live. We are going live. I was getting all sentimental. And here we go, folks.
That she stated incorrectly there was that he did check the two vote challenge on there, and you stated that he did not check the two vote challenge on there, and you stated that he did not check it, but he did check it. And I think that he was given some bad advice, and I'd never met the young man until after the challenge was filed, and I explained it to him, and he understands it. So I think that that being said, he was also challenged as a precinct committeeman along with 11 other people from our county. The challenges were all upheld at the county level. And prior to the February 9th filing deadline, none of the challenges that were upheld had contacted the county chair for certification. And that also holds true for Mr. Fox on the precinct committee level and also the state rep.
Is Mr. Fox here? Probably should have started with that. anyone want to make a motion?
I would move to uphold the challenge.
Is there a second? I'll second it. So we have a motion to uphold the challenge and cause 2024-21 in a second. Any further discussion? Hearing none. All those in favor signify by saying aye. Aye. The ayes have it. The motion carries. The challenge is upheld. The elected division is directed not to include Brett Fox in the certified list of primary candidates sent to the county election board and indicate that the name of this candidate not be printed on the ballot. Thank you.
Thank you all for your time and effort.
Baker v. Thompson, cause 2024-22, in the matter of the challenge to Deirdre M. Thompson, candidate for the Democratic Party nomination for State Representative, District 96. Mr. Co-Chief.
Mr. Chairman, members of the commission, in your meeting binder for this cause, you will find the Can 1 candidate challenge filed by the challenger, along with attached documents, as well as a copy of the candidate's declaration of candidacy, their Can 2 that was filed with the state, with attached receipt showing a statement of economic interest has been filed, a notice of hearing that was sent to both the challenger and challenge candidate, as well as documentation showing the election division did send that notice of hearing.
Thank you.
And there's also, just so I'm clear, there has been an appearance notice filed on behalf of the challenged candidate. There's also part of your record. I think we just got it, which is why it's not three-hole punched in my binder, and I missed that. But that has also been made part of the record.
Okay. With that, I recognize Mr. Baker. Mr. Baker.
Thank you. Thank you. Thank you for being here. It's been a long day. My name is Raymond Baker, RAYMOND BAKER. I filed the challenge on February the 16th at 9:47. I believe the document speaks for itself.
Looks like in cross-examination. Okay. You have the floor.
So I want to move to dismiss this challenge. My client, Deandra Thompson, just received late yesterday a copy. It was, I believe she told me it was thrown on her yard, right? I'll have her testify here in a minute. It was thrown on her yard. So she didn't have time to even look into, or neither did I got this last night. I didn't have time to look into the allegations against her or pull up contrary voting records that would contradict the assertions here, because she did in fact vote in 2 Democratic primaries, and she used to be under a different last name. So those aren't present, but we object to her not receiving proper notice. So that's, I guess, the threshold matter.
Are you saying that she didn't receive the notice regarding the hearing?
She received it less than 24 hours from the start of this hearing, and that's not appropriate time for her to be able to pull up any of her voting records and obtain, meaningful legal advice. I just found out about this late yesterday.
I can provide some information in this regard. The notice of the challenge was sent by our office to the candidate. It was shipped to the address that we had on for declaration of candidacy. That was 3233 Broadway, Indianapolis, Indiana, 46205. In your record, you will find that UPS indicated that they delivered that notice of hearing on Saturday, February 17th. The delivery time was 3:47 p.m. That's what it provides for the record and has been given to us by UPS, which we used.
That's not what my client is saying happened with the receipt of the document. I don't know. Well, let's have her speak to that.
My stepdad is also here. They brought it to me after picking it up from my yard on Sunday. So Sunday or excuse me, Monday.
On Monday.
Correct.
That's yesterday.
Correct.
And so how were you able to find an attorney so fast?
Well, Michelle and I have talked before about other things.
Was it about this particular challenge?
No, about, someone had called me.
Oh, I don't,
Yeah, you don't want
Okay.
to, you don't want to violate attorney
No,
client
okay,
stuff. Yeah, no.
okay.
She was acquainted with me and asked me like last night if I would jump in and help. So.
Yes.
Okay, well, I'm sure you can understand that we have a document from UPS saying that it was delivered to 3233 Broadway. And in the date and time that Mr. Kochever stated, and you're saying it didn't appear till what? How many weeks? A week later?
Yes, I have the Ring doorbell, so if anything, I would have been able to receive it in my hand, if nothing else. I work from home quite a bit.
Are you at 3233 Broadway?
Yes, that is my address.
And well, left at, it says other release. What's that mean?
I don't know. I'd have to ask my colleague,
Is this
Kimmy
the
Hollowell
signature?
Williams, who sent this out.
Okay, where's that person?
Kimmy? It
She's
is.
in our office.
She's
I
in
see,
our.
I see two
office.
different UPS stamps.
Can I jump in here, Mr. Chairman?
Yeah.
One of them is to the challenger, one is to the challenge.
okay.
But to go back to Commissioner Karen Celestino Horstman's question, I believe, because I did some of the notices on the Republican side of the House, when you mark that, it means that they can leave it in the person's mailbox or on their door, is my understanding, instead of having to be there to
Sign for it,
accept.
I do have one more matter in this regard. This has to do with statute. The statute is Indiana Code 3-8-2-18, subsection B. If you don't mind, I'm going to read the entire subsection to you all, just so that it could be understood. This particular subsection states, the notice requirements set forth in IC 4-21.5 do not apply to the meeting conducted by the commission under subsection A. This has to do with candidate challenge hearings. The election division is required to give the best possible notice of the meeting to a person that the election division identifies as an interested party. Unless a written objection is filed with the election division before the end of the meeting, appearance in person or by counsel at the commission's meeting to act under subsection A constitutes an admission that adequate notice of the meeting has been given. I just provide that to you for reference in regards to this particular part of the hearing.
What's this assertion about voting in two previous primaries?
So if we're not going to address the, the notice issue, we can move on to that. And so Deandra has, and she'll testify in a minute, she has voted in prior Democratic primaries. And it's my understanding that she did so under a different last name and maybe in a different county than what she currently lives in. And she didn't have time to hunt down records. It's hard as a candidate to get records. We don't have access to the same system that party chairs and other folks do. So Deandra, you want to talk about your primary voting record in the past?
Yes, I definitely voted in the 2008 election under my former last name Grady. And I have asked.
In the Democratic primary.
Correct.
Do you know who you voted for?
Yes, I did.
Who'd you vote for?
She didn't have to.
Shouldn't have to disclose that.
Yeah.
And so, yes, the other thing is I have asked the commission for those records, and for some reason they only stop at 2016, and I've been voting since definitely by 20, since I've been 21, so, and I'm 40.
And then that was one of your primary. Do you remember voting in another primary besides the 20, whatever one you said?
Yeah, 2008 and definitely 2010.
And they're both Democratic.
Correct.
What county were you living in?
I was living in Johnson County and then Marion County.
And which clerk did you go to get that information?
For both of them, I didn't have time to go to the Johnson County clerk, but I definitely have been asking the Marion County clerk. I didn't know if I thought they were all digitized, so I thought they would have it as well.
Did you call them?
Yes, I've called them.
It's Johnson County?
Yes, correct. I have called, yes.
I mean, she had limited time, but she did what she could and was trying to chase it down and has still gotten no response.
Can I make a suggestion that we?
We can wait.
Okay. Then she can decide if she wants to share, right?
Yep.
Table.
Just move it.
Well, we've already opened the cause.
Let's take it. If everybody's okay with it. Yeah, that's
We can take a recess for 5 minutes.
Yeah.
How much time?
Oh, assuming I can talk with the challenge candidates to get that accurate information, just for our record, should take no more than 5 minutes.
Ms.
There's only
Harder,
certain ways you can search it.
he can access the voting record of your client.
Okay.
However, he can't share that with us. He can only share it with her and you as her attorney. And then if she decides she wants to share it with us, then he can, and authorizes him to, then he can share it with the rest of us. Okay?
Mr. Co-Chief,er do you have it up? Are you good? Okay, just making sure.
Oh, you guys are good. I wish I had access to that. It'd make things easier.
Ms. Thompson, do you mind coming over and talking? And our mics are. All these times because everything was no, we can't show anybody else. Once she decides that she wants to. I think when she decides that she wants to place her record in there, then she decides not to place it in
Wow, that's different. Yeah. How we coming along over there? The scene in the movie where he's diffusing a.
Yeah. Is it the red? Blue fire.
Right. You are looking it up. Right.
Been a long time. I don't blame you. Yeah. Current representative of this district. Your current representative of this district.
Making any headway? Ready to continue? Is there any new evidence to bring to light?
No, it doesn't appear that her records prior to 2016 are available on the system, but again, I'm going to take 2013. I'm going to take my client's word for it when she tells me she voted in what years and in what primary, but we don't have any evidence of the same because it's not available on the
Is there
system.
any other evidence that you have to contradict Mr. Baker's testimony?
I would say, the evidence I got from the Marion Council stuff, when I got the voter record, it didn't even show the 2013. That was the first time I've actually seen 2013 in my married name. So I know it's gotta be somewhere. I just need the time to get it.
Okay.
Did you get your county chairs, any certification from them?
When you're saying the county.
It's the county chair.
If you don't vote, you can get your party chair to sign off.
Oh,
for you.
yeah.
Okay.
Okay. Does anybody?
How far back does the system go?
The system was implemented in 2005, 2006, depending on which county. There could be voter registration records going back into most of the 20th century. As an example, my great-grandmother, who died in 2005, her voter registration information in Lake County going back into the 1940s was entered into that voter registration system.
But the counties, they can destroy it after 10 years, right? The statute says that after 10 years, they do not have to retain the records.
That would be the paper copies, I think is what you're thinking about, not the
No,
digital records in the state.
I thought you could destroy after 10.
That's not, there's no statute that says
Yeah.
10 years though.
Okay. Given that there's no additional information to be provided, does anybody want to make a motion?
Well, remember, it's the challenger's burden, and I don't know that he even looked into her other last names or other counties.
The challenger has filled out the required paperwork and stated his case.
I move to uphold the challenge.
Is there a second?
I'll second.
Any discussion? We have a motion to uphold the challenge on case 2024-22 in a second. Hearing none, all those in favor signify by saying aye.
Aye.
The ayes have it. The challenge is upheld. The election division is directed not to include Deandra M. Thompson in the certified list of primary candidates sent to the county election boards that indicate the name of this candidate not be printed on the ballot. Thank you. Next, we have Boyce v. Mahant.
And just since we last recessed, I got a notice of appearance for Sid Mahant from a Mitchell v. Harper. It won't be in your binder. Council Co-Cheever has one as well, but I do have one here for our record.
Okay.
And then in the binder, you will have the Can 1.
And this is cause number 2024-23 and the challenge to Sid Mahant, candidate for Republican Party nomination for United States Representative District 6. Sorry, go ahead.
Yes, no problem. And on here, we have the Can 1 from Beth Boyce, and she is challenging his candidacy for the 6th district. He did not answer question number 3, which is the 2 primary rule that we have been discussing, or have a letter from the party chairman. And there is a copy of the vote history as well as the service to both the challenger and the challenged, and an appearance for Mr. Young again, who is appearing on behalf of Ms. Boyce.
Thank you, Mr. Chairman. Again, Will Young, Willyoung, with Lewis and Wilkins, appearing on behalf of Chair Beth Boyce, who is the chair, GOP chair for Johnson County. Again, she is, as was mentioned, filing a affiliation statute challenge to the candidacy of Mr. Sid Mahant. And with that, I will turn things over to Chair Boyce for the factual allegations of the case.
Thank you very much. Good afternoon. Thanks to each of you for your work and for having us here today. Mr. Sid Mahant has filed
state your
Oh,
name.
I'm sorry.
Yeah.
I am Beth Boyce, Beth, last name Boyce. Sorry about that.
Nope, go ahead.
Mr. Sid Mahant has filed a declaration of candidacy seeking to be the Republican nominee for the office of 6th District Representative, U.S. House of Representatives. The Can 2 he filed, a copy of which, as Valerie mentioned, is in your packet, is incomplete. Specifically, he did not answer question number 3. It is not only the failure to check one of the 2 boxes under question 3 by which he claims affiliation with the Republican Party, however, that matters. It is his substantive failure to qualify under either of the affiliation options presented in those 2 boxes. I am the Johnson County Republican Party chair. Under Indiana Code Section 3-8-2-7A4, to claim affiliation as a Republican to be eligible to run for office in a Republican primary, a candidate must either have cast a Republican ballot in the last 2 primary elections in which the candidate has voted, or receive the certification of the county Republican chairman in the county in which the candidate claims residence. Mr. Mahant fails on both counts. His attached voting record, which is in your packet, demonstrates that he has only voted in 1 Indiana primary election, not the requisite 2 primary elections. Second, he claims residence in Johnson County, where I serve as the Republican Party chair. Neither Mr. Mahant nor anyone acting on his behalf has ever asked me to certify that Mr. Mahant is a member of the Republican Party, and I have never made any such certification. Indeed, as Mr. Mahant's attached voter registration record demonstrates, he was a registered voter in Steuben County until February 1st, 2024, the same day upon which he filed his Can 2 claiming residency in Johnson County, and has therefore only had a brief period of time in which he could have even sought my certification. Therefore, for these reasons, Mr. Mahant is ineligible to run in the 2024 Republican primary to seek the office of 6th District Representative. Indiana's 6th Congressional District includes all or portions of 11 Indiana counties. In addition to my representation of Johnson County, the Republican Party county chairs in each of the other 10 counties have joined me in this challenge. So on the paperwork included, you'll see their names and counties that they represent. So thank you.
Would you like 2 minutes to cross-examine any of the statements made?
Yes,
Boyce? Will you state your name for the record? Thanks.
Mitch Harper, Fort Wayne, Indiana. Chairman Boyce, had you had a chance to talk with Mr. Mahant anytime during January?
We had one phone conversation.
All right, thank you. And I'd like, well, never mind. I'll save that for later.
Okay, and if you'd like your 5 minutes for a presentation, you may begin.
Thank you, Mr. Chairman and commission members. I've served with Chairman Boyce on the state committee. I've been a district chairman myself. And I've had a long record of involvement with the Republican Party and as an attorney on a wide variety of election matters. I was elected a precinct committeeman when I was 18, something that would be prevented by this statute that we're talking about today. I'm going to give you something novel. It's been a long day. I mean, it's all wonderful you've been here, but a little bit of a novel thing to think about. Mr. Mahat was indeed a resident of Steuben County until January 31st. He was appointed as a vice precinct committeeman in Steuben County by the Steuben County Republican chairman, Rick Michael, and I have that appointment documentation here to present to you. Thank you. You're recognizing it. A little bit of a challenge. You did. Yeah, well, I'll let you distribute those. Thank you. So he was appointed by Rick Michael as a vice precinct committeeman, and Mr. Michael, in preparation for appointment as precinct committeeman, also indicated that he was accepting of Mr. Mahat as a Republican. So the question for this commission, it's not really contemplated in the statute, is when did Mr. Mahat stop being Republican? When did his Republicanness go away? Once he's appointed a vice precinct committeeman, which requires you to be Republican and requires the appointment of vice precinct committee certificate to go to the state committee, when did he cease being a Republican? Does someone go in and out? Does someone fish one day and foul the next?
Counselor, you know, I watched the arguments on this regarding Mr. Rust. And
This has nothing to do with Mr. Rust's case.
no, but one of the questions that it does very much have to do with it because it's the chairman's certification. And one of the questions and the point that came up was that the chairman has discretion to refuse to certify anybody for whatever reason. And that was one of the things that was being argued and discussed. There is no framework, and I'm sure Ms. Harchick can tell you that. There is no framework that says to them, here's what you need to look at to make the determination whether you want to certify somebody.
Correct.
It's not
It's their discretion.
It's at their discretion.
It's
So
at Chairman Michael's discretion.
let me finish, sir. So if Steuben County decided that they found him to be a Republican in good standing, this chair, for whatever reason, declined to make the same findings. So it's kind of like apples to oranges, because she's a different county and she has the same discretion.
But you're saying he gets thrown out of the Republican Party somehow?
I'm not
He
saying-
ended his Republican Party status. That's what you're saying. It has nothing to do with Mr. Rust. Perhaps if Mr. Rust had been a county auditor or county coroner or held precinct committee slot, it might have something to do with it. But
Well,
this
the
really does
statute-
not have anything factually to do with Mr. Rust at all, and frankly, should not be raised in comparison.
Well, regardless of what the statute says is it's the county chair for the political party with which the candidate claims affiliation and the county in which the candidate resides. And on his CAN 2, his residency, he gives as Greenwood. He doesn't give his residency as Fremont, it's Greenwood. So so the fact that the county chair and the Steuben County chair certified him because he changed his residency to Greenwood means that he had to get the Johnson County chair's approval. I mean, that's what the statute
Well, and
says.
I would offer that what I'm reading is the county chair only certified him for vice precinct committeeman during the year 2023 only.
No,
It was not for purposes of any other contest, correct?
Well, once you're precinct committeeman, you retain being precinct committeeman until the end of the term. Precinct
I
committeemen are
understand,
up
but
for election this year.
What I'm saying is this same certification would have to be executed by Johnson County, is that what we're talking about?
Yeah.
Johnson County in order for him to have ballot access, correct?
He's running for Congress. He's not running for trustee. He's not running for a county office. You know, the British standard was that you could run from anywhere. Winston Churchill was appointed to run in writings that he did not reside in. Similarly, running for Congress, you have residency in the state, run for Congress. There's no residency requirement for a year as there is for the General Assembly. That's noted on the candidate declaration form.
But there is no letter from any county GOP chair that authorizes his access to the ballot or previous voting records for 2 previous primaries, correct?
No, it authorized him to be precinct committeeman. He's a Republican. How does one-
I'm not sure, council, that anybody is arguing that, even, our
Right.
challenger here.
Arguing the status of him as a member of the party. It's about his own.
It's about the mechanical process of the code.
It's about the code. That's kind of where it lays down at.
That can cause all sorts of odd situations for people who move across county lines. For example, I was a state representative for 12 years, and so you're telling me if that was my status today and I moved to, I don't know, Grant County, I would have to get the Grant County chair to declare that I'm a Republican?
Unless you had voted in the previous primaries, yes.
Well, I'm going to end my discussion here because I think the commission's not entertaining what is clearly obvious to me. You're saying people can be a Republican one day and somehow change that status.
No, I don't think we're saying that at all. We're looking at the elements of what qualifies someone for ballot access, and that is either the 2 standards, which, unless you're offering something different, haven't been met here.
Entirely mechanical. All right, I close.
Do you have any cross-examination or questions?
I just want to say thank you for the consistency and the comments.
Yes. Sorry.
Would move to uphold the challenge.
We have a motion to uphold the challenge. Is there a second?
Second.
We have a second. Any further discussion? So a motion to uphold the challenge and cause 2024-23 in a second. All those in favor signify by saying aye. Aye. The ayes have it. The motion carries. The challenge is upheld. The election division is directed not to include Sid Mahant in the certified list of primary candidates sent to county election boards and indicate the name of this candidate not be printed on the ballot. Thank you. I did not. Should we? We're gonna keep moving. Next, I have Anderson v. Graves, cause number 2024-24 in the matter of the challenge to Chunia L. Graves, candidate for the Democratic Party, nomination for State Senate District 34. Mr. Kochever.
Yes, thank you, Mr. Chairman, members of the commission. In your meeting binders under this cause, you'll find a copy of the Can 1 Candidate Challenge that was filed by the challenger, a copy of the candidate's declaration of candidacy, their Can 2, with accompanying receipts showing a statement of economic interest was filed, a notice of hearing that was sent to both the challenger and challenge candidate, documentation showing that the election division sent those notices, and an appearance form filed on behalf of the challenged candidates. I've also been handed other documents that are getting passed down your way and for the to be entered into the record.
Okay.
One, there you go.
The other side.
That's what he's giving them.
We'll recognize Ms. Anderson. You have 5 minutes.
I look like a talker. Hello, everyone. My name is Stella Anderson, Stella Anderson, Anderson. And I am a longtime constituent of Senator Jean Breaux, Senator District 34, Senate District 34. I am here to challenge Ms. Graves. Senator Breaux has been in district since 2008, I want to say. I love her work. She fights for the community. She's a great constituent for the community, and I want to see her to continue as our senator. I am challenging Mrs. Graves, who has registered to run against Senator Breaux in the upcoming primary election as a Democrat. But according to Graves' voting record, I would like to submit this to the committee, Exhibit A. I only had 8, but you can do some. Okay, according to Mrs. Gray's voting record, I submitted that providing by the Marion County Board of Voters Registration, she has not voted in 2 primary elections as a Democrat. She has voted once, as you would notice, in the primary election in her whole life. So I feel a candidate for a Democratic state senator representing over 120,000 voters should have a long history of voting and voting as a Democrat. So I request you to rule her nomination for Democrat candidate for State Senate District 34 invalid because there is no supporting document showing Mrs. Graves have voted in 2 primary elections or a letter of certification. So due to the non-compliance of a party affiliation requirement on the Can 2 declaration of candidacy for primary nomination form. Thank you.
You have 2 minutes to cross-examine anything. Okay. 5 minutes to present.
Mr. Chairman, Madam Vice Chairman, Commissioners, thank you for the time. Tom John with Ice Miller here on behalf of Chunia Graves, who most assuredly is a Democrat, and we'll have a brief bit of testimony I'd like to have from both Ms. Graves and her father, who's an elected Democrat city county councilor in Indianapolis. But before we do that, I want to get through just the base of this. I would raise many of the same challenges that you saw in the Rust versus Morales case with regard to the statute at large, but you don't have to get that to here. The fact is, you could argue over whether this is an extra requirement with respect to the 2-year residency with respect to running for the Indiana House. You could argue about virtually anything in there except for the 17th Amendment arguments. You could argue about full faith and credit. We don't need to do that. We just need to look at the actual statute. And if you look at the statute, it says, and I've included it for ease of use in the documents I went there. I see 3827 4A. The 2 most recent, or a statement of the candidate's party affiliation for purposes of subdivision, a candidate is considered to be affiliated with a political party only if the following applies. The 2 most recent primary elections in Indiana in which the candidate voted were primary elections held by the party with which the candidate claims affiliation. That does not require the last 2, as in somebody had to vote in 23 and 22. It doesn't even include any temporal element other than you didn't vote Republican in between there. And so in the case of Ms. Graves, you'll find in your packet a document from SmartVan, which is a Democrat Party voter registration system. And the fact is that you'll also get testimony that Ms. Graves did in fact testify or did in fact vote in Democrat primaries. So the problem we have here is frankly SVRS, one way or another, this isn't the issue, but does not apparently reflect the accurate voting record. And nothing in this statute says that has to be validated by SVRS. It simply needs the factual support in order for the person to be proven as having voted in the primaries. So in this case, we have somebody that we also included in our materials. She is a sitting official in the Democrat Club. She is somebody who has been appointed by a Democrat mayor to the Community Corrections Board as a Democrat. She has a variety of bona fides as a Democrat. And now I'd like just briefly to, Mr. Graves, can you introduce yourself?
Good afternoon, Chairman and Commissioners. Thank you for this opportunity to speak.
Have you been aware of your daughter's involvement in politics?
Yeah, state your name real quick.
Thank you so much. Keith Graves, Keithgraves.
Thank you. Sorry.
And what is your role in the Democrat Party?
So I'm an elected official, originally elected in 2019 to serve District 9 on the Indianapolis City County Council, Eastside Community.
And has your daughter been involved in politics at all?
Absolutely. She's been right lockstep with me. We've had one of the more transformative communities in the entire city of Indianapolis on the east side. And largely it's because of my relationships across the county, across our district, and the work of my team. And she is an absolute important part of our team. She's been right there with me the entire way.
To your knowledge, has she voted in Democrat primaries in the past?
She has.
Do you specifically of evidence, are you able, or specifically of your own awareness, are you able to say which ones she has voted in?
16, 18, 20 primaries. So those are the three primaries that I'm very familiar with.
Okay, thank you.
Thank you.
Ms. Graves. Could you introduce yourself?
Hello, my name is Shania Graves. First of all, thank you so much for your presence today.
And so,
Sorry, your name, can you spell it?
Shania, Chunia, Graves, Graves.
Thank you.
so initially, let's just start and get to the point, which is, have you voted in Democrat primaries in India?
Yes.
And what years did you vote in those?
Most recent, dating back,
If you can go backwards.
2012, 2016, 2018, 2023.
And so we saw the record that was placed in the evidence that only showed us Democrat primaries.
So we're at our 5-minute limit. So anyone want to vote for 4 more times?
I do. I'd like to get it done in 2.
I can get it done.
Great. I'd move for 2 minutes. I'll second.
Second, all those in favor signify by saying aye.
Aye.
Please continue.
So why might your voting record only show 1 vote when SVRS comes up? Could this be your college career and student? Tell us a little bit about what's happening quickly.
Yes, sir. I was a Division I athlete. I went to Jacksonville University in Jacksonville, Florida to study. I continued my education onto Pepperdine University out in California and then returned to Indiana back home.
But the primaries, sorry, and this won't take away from your time. The primaries that you're discussing, though, those are all Indiana primaries in which she.
Yeah, they are.
Okay.
Yes, but she was voting absentee at different times, and she did then in your materials define register as a Democrat in California, and then move back to Indiana. That is more than likely, we think, why maybe it didn't get picked up in SVRS. It's a data system, and data systems don't always pick things up correctly. But the fact is that you have testimony from 2 people she did vote in primaries. You have materials that show she is without a doubt a Democrat, and a likely scenario why it's just not showing up on SVRS is simply the fact that she did move her registration as she was a student in Pepperdine, and then it moved back, and so it's only picking up what she did after she came back.
And again, this doesn't, I'm asking a question here, so it doesn't take away from your time. This smart van system, we just explain that.
System utilized, I imagine, the Democrat members of the commission might.
Are you familiar with it?
Yes, I am familiar with it. I'm kind of surprised to see it here, but I am familiar with it.
Do you know what these, so in the general election under these years, it has different letters?
Well,
The
that's.
primary, does
that's
anybody
the
know what that
problem.
means?
We don't know. I mean, I don't know what this report was printed off of.
There's an
Search
email
over.
right on Raymond that attests to reflecting the history of that performance.
As they're looking, who maintains Smart Van? Like who keeps these records? Is it the party?
It's the vendor.
Okay,
Or their data vendor.
got
It's
it.
similar to on the Republican
It's the
side.
data center.
It's possible.
And so the reality is, when we're looking at this, SVRS is not just positive. I mean, at one point, I've seen my own voting record problematic inside of it. The fact is, we have testimony that supports it. Yes, the challenger may have met the burden of at least supporting the idea of a challenge, but obviously the challenge has the ability to provide evidence, which we provided evidence, I would argue, outweighs the simple fact that a data set that could be flawed claims that she isn't. When she said she's voted multiple times, and you look at SVRS, it could suggest to you that she's only voted for the last 3 years.
Okay, so could I ask staff if they are aware of whether her tenure and changing her residency and such would have caused them to somehow get rid of her voting record?
That's not how I understand SVRS. I mean, my knowledge is that once you get registered in SVRS, your record is there forever. Even if you move out of state, you cancel that registration, you register somewhere else, it stays there. And that's just my general knowledge of the system, what I understand from voter registration officials in the county, and how we maintain that particular system.
So I would have like a follow-up to that. So let's presume for a minute there is some level of fallibility, right? To his other point, which is not one I had contemplated till he brought it up, is SVRS, when we look at whether someone's voted in a is that the standard? Is that the record that the law or the statute?
SVRS is the state system of record, and the co-directors administer it with the direction of the Secretary of State. And if there was an error in the issue in the system,
But I guess what I'm
county
asking
voter
is,
registration.
when the statute says you have to have voted in 2 primaries or have how SVRS, is it layered into that statute as this is what you refer to? That's what I'm asking.
SVRS, I would say, is the system of record. Yes. Well, it calls it the computer list.
Where does it say?
Hang on, let me go into 3.7.
It doesn't say that that's where the proof has to come from.
I guess while you're looking at that, the thing is that, I think what Smart Van, it's showing that she voted in those years. I then look at what you provided about, I think this is from you, the California voter registration. It seems like she was registered to vote in California for 2 of the years where she just said she voted in primaries. And so I could see that maybe she voted in and I don't think you're not supposed to vote in 2 places at once. I mean, it seems to me, it looks like it's possible perhaps that Ms. Graves, you voted perhaps in California when you were out there, at least in 2018 and 2020, it looks like.
She's unequivocally said she voted for Obama in 2012. And she voted, nobody disputes, in 2023 in the primary. That is 2 primary votes. It hasn't been interrupted by any vote in between. And the statute clearly says just the last 2 votes.
So we don't have a record.
Separated by
But her record doesn't show that 2012.
I understand it also doesn't show any of the previous votes in SVRS.
Mr. Chairman, if I might, if you go to the Indiana Code 3726.35, purposes of the list, and it references the federal code that requires us to have a statewide voter registration, and it specifically says that the computerized list is the official voter registration list for the conduction of all elections. So to me, that's definitive that SVRS, not any other system, is the system of record.
That's definitive as to who gets to come vote. But that's quite different than the level of proof that it takes as to whether or not somebody is a Democrat. which is whether they voted in the primary. I'll give you an example. Back when Dorsey and Sadler was the clerk in Indiana, or clerk in Marion County, there was an election. The smirching of Dorsey. But there was an election where they forgot, the staffing at many of the election places forgot to actually mark down partisan. And so if you look back on many of us that voted in that election, there is not a partisan vote indicated for the primary, even though people did vote for the primary.
So how do you reconcile that?
Well, there's a statute that says that there's a mistake by, I don't know it off the top of my head, I can find it here, that says that there was a mistake by a staff that wouldn't count against the voter, but I don't know of any mistake.
So in this case.
Can you prove us?
If I could though, but beyond what the co-general counsel is stating, the counties are the official record keeper, and they use the statewide voter registration system not only to update and merge voter registration records in the voter registration offices, identifying vote history, but if a person voted absentee, we have an absentee module that's been part of the system, and Mr. King can confirm, I think since the beginning, since 2005, 2006, that would show if an absentee ballot was sent to an individual and if it was returned. If you requested that absentee in a primary election, what political party, and all of that would be captured in the person's entire playbook, if you will, within the registration system. So anytime your registration is canceled or updated, that information is stored within the system, and you can go through that hierarchy and look at that level of registration detail if necessary.
Mr. Chairman, I can confirm the statement that my counterpart has made regarding the absentee module and its presence in SVRS since it was established in December 2005.
I guess I have a question for the staff. Haven't in previous years we have found evidence that there's been not listed things on the SVRS, and we've ruled in that what manner? I'm just asking for a precedent here.
I personally can't come up with something, but I see Matthew Kochiver raising his hand.
I know it has been alleged. I believe it was alleged in a challenge hearing in 2022, but I don't know. I do not recall. Just my memory here of if the commission ever got to the bottom of that, the person who made that allegation as part of their defense, what happened with that. But it's come up before. It's come up before in these challenge settings. It's come up before voters complaining to their county voter registration officials, which is why we have, the section of law I know that Valerie's referring to. I forget the section myself as well.
I found it.
About how to fix it.
381. I knew it wasn't, I think it's like 381.
And while Valerie's looking that up, my recollection to that case too is I think it was a female candidate who went to the county and looked at the old paper poll books that the county still had maintained, even though they could have destroyed them. We have electronic poll books now that create reports and information that you could pull to gather that information. And I think she actually went and found one vote, if I'm remembering correctly, found one vote history or one election where it wasn't properly recorded but didn't have the second. But I could be misremembering, but I do distinctly remember her talking about going to the Hendricks or Hancock County, it's one of the H counties, and looking through the poll list to see if she could identify whether or not she had voted in those past elections.
Matthew, the code that I was looking for earlier was 381.1.1. That's the filing errors, but I think that's really more, I don't know that that really covers VR now that I look at it again.
Well, what's unique, at least amongst what we've heard thus far today, is there's competing information here, right? So you have, and I admittedly, I don't know anything about SmartMate. I don't know what it is. But at least there's some documentation that, and what I wonder is what level of, in full disclosure, I worked at the Secretary of State's office during the implementation of SVRS. And so I'm curious about the fallibility, the vulnerability of data in and data out. I'm just curious if there's anything that any other type of search criteria, anything that could be entered that might produce different results. We haven't had anyone produce anything, to my knowledge, that we've heard these cases where some other system says, oh yeah, they voted.
In recent years, the counties have been using electronic poll books, and an electronic poll book, they just do a data poll straight into SVRS. So you really, since we've moved to moved away from paper, I think less likely to have mistakes with the electronic poll book. So I think you could go back and ask the county to put electronic poll book records that they use to put into the statewide voter registration system. Would be the only thing I could think of.
I just want to clarify, this says P here on their primaries. Does that just mean she pulled a Democrat ballot?
Yeah, that's what I was asking her. I don't know what the,
It's to my understanding that P signifies primary.
Okay, so it doesn't indicate Democrat or Republican? Or is this only reporting
well,
Democrat
this, so this
status?
ledger over here, what I think the A means is this precinct designation over here, if I'm guessing.
No, I don't think there's a relationship.
Shit between this
Yeah, I was
and
just
this.
looking at that. I don't think that's a ledger. And that just is what districts she's in. She's in, I think. I don't, that's why I was trying to make this mean something over here and I don't.
Because there's a P up in the general category.
Could it be in person, an in-person vote versus absentee? I'm
Oh,
sorry.
okay.
And I don't know what E is.
Yeah, what would E stand for?
So you wouldn't know necessarily what the political
Early.
party was.
E is early.
If it says P.
Early vote, okay. Okay.
I'll be honest, I haven't been
Is there anything, well, that's a good question, whoever just said, good point, whoever just said that. How, is there anything on here that discerns party affiliation?
And that, I think this speaks to co-counsel's point, and that is Marion County has been using e-poll books for a number of years now, as I understand, when they moved to vote centers.
Yeah.
And so you could go back to the county and ask them perhaps to pull the report to identify if you did, if that's what the P means. I'll be honest with you, I'm about 13, 14 years removed from the van. The last time I used it, it was an Access database. So it looks a lot different than when I would have used it a million moons ago. But that would be a place to start with the Marion County Clerk's office to see if they have anything on those e-poll book reports that would show that Ms. Graves voted in the primary election in person and what party ballot she pulled. At least for those, I don't know about 2016, but at least for 2020 and 2018. I don't remember the year they went to vote centers.
So you're saying that she voted Democratic in the municipal primary in 2023. And when did she vote in another Indiana, pull a Democratic ballot in an Indiana primary? What year was it?
For sure, 2020 and 12, when you said you voted in person. She's tried to reconstruct the others. She thinks that she had voted absentee and
Okay, because on the report you gave us, the van report, it doesn't reflect anything in 2012.
Yeah. That's right.
so 2016, 2018.
The other years that I voted absentee were 2016 and then again in 2018.
Well, what we're looking for though is when you voted in an Indiana primary.
Those were for Indiana.
And if you look at.
But you were registered to vote in California in 20.
Correct. If you look in the.
And I have to say, I don't dispute that you're a Democrat. I mean, that's not really.
That's not an issue, yeah.
That, if you've been sitting here most of the day, which I think you've heard, but it's either the two most recent primaries in Indiana or the certification.
Well, no, it's not the two most recent primaries. It's the two.
Well, sorry, the two here, I was paraphrasing. I know what Mr. It's
been a long day.
It's been a long day. Don't start talking about what the statute says. Anyway, so yes, the two most recent primary votes two most recent primaries in which she voted in Indiana, so other states wouldn't count. or the certification from the party chair. I mean, that's the said. I'm not disputing you're being a loyal Democrat at all. That's looking at what the statute.
There's right cancellation.
I see that.
And the
Yeah.
question, and the only
You need
thing
to go to
that
the
really
microphone.
reflects-
So
Yeah.
You look at the SVRS printout, it reflects 3 cancellations of her voting record. And I would suggest that potentially that in the course of it, it shows 2012. It would be, she says that she voted in 2012, yet there's no evidence of 2012. So is she lying right now that she voted in 2012? I highly doubt that.
Well,
And so the question is, what if it wasn't there? I might suggest that if in fact it really, if you can't take if we're going to engraft, that it has to, well, I don't think we should engraft into the system that SVRS is the sole and final arbiter, because data systems are fallible. And the idea is to make sure that somebody's truly a Democrat, not that they're switching parties to vote to run as a Democrat or switching parties to run as a Republican. But I would suggest that if you can't rule for her now, perhaps you table this and we seek from the Marion County Voter Registration Board, Election Board, the actual 2012 record.
We got a deadline tomorrow.
2 days.
No, 2 days.
2 days.
Oh, okay.
But I would argue we've given plenty of evidence to support a ruling in behalf of Ms. Graves.
Counselor, Ms. Graves, I have done some reading about you online on some things. I find you to be a very impressive young lady. And I hope no matter what happens here today, that you will go forward, because our community needs more young women like you to serve as role models and leaders. Unfortunately, we have been saddled with this law that changed recently. And as a result of it, I'd be home already right now if it wasn't for this law. You have most capable counselor who's done the best that he can. But the evidence that we have here today is just, it's incomplete. We're going back to looking at 2012 for a primary. And we have a deadline in 2 days by noon. We have to decide all these challenges. So it gets to be a real challenge to try and do all of this.
Let me delve into that a little bit further. You made a comment about going to the Marion County Clerk's office.
I mean, if in fact, I mean, we haven't checked, I don't know whether those, frankly, because that would have been paper poll books, by the way, that you would have been dealing with, although she said she voted absentee, so I'm not sure where that record. Maybe the code director, remember, were you there back then?
I'd like to, if you look at in this packet you gave us with California voter registration form, there is an Indiana voter registration for 2012. And I think maybe you were confused or something's here, because it says you registered to vote in Indiana in June 19th of 2012, which would have been after the primary. You want to take a look at it? See what I'm talking about? I mean, it's a long time ago. Memory is not always the best. So I'm not in any way saying you're intentionally. Maybe you got things confused. Yeah, you voted in November of 2012, and maybe that's what you're thinking about.
Well, but so take 2012 and throw it in the corner for a second. You're saying 16, 18, and 20 as well, correct? And
Yes, sir.
what SVRS shows is 23, right? Just the one.
Yes, sir.
So the two of those others, I mean, piecing this together, it looks, I mean, it just seems like those 18 and 20 votes were California votes. But I mean, because that's she was registered in California in 2018. And that's what it looks like. I think the problem here is that I know what you're saying about the system. I mean, we go, because otherwise, I mean, we could be looking at all kinds of stuff. And the van system, my understanding is, I mean, that's something the Democratic Party pulls together to figure out who they should really try to get out the vote, right? I mean, that's what it's used for. Well, maybe, but I mean, it's used for get out the vote efforts, in part, I believe. And so the SVRS is what, we look at, or, if people go to the county, they think there's been an error, they go to the county clerk's offices, get their, don't trust the system and go to that system and see what it shows. And we don't have that. So it really, what we've got before us is one clear Indiana primary. The other one you've talked about, 2012, isn't even reflected on this ban thing. So and then we've got voter registrations for California for 2 of the years you're talking about. And 2016 might be when you were in college, so maybe you're registered in Florida. I mean, I don't know, but I think the issue we've got here is that there's not really anything supporting that we've got a vote in 2 Indiana primaries.
If they would have arrived with information from the Marion County Clerk's office that contradicted SVRS, what would we do then?
Well, then I think we'd definitely consider that.
I'd like to point out that during 2020, though I was technically in school, I was displaced, living back in Indiana. So that might be due to the pandemic. Due to the pandemic. So I was, displaced at that time, and want to highlight that.
Did you ever vote in California in a primary?
Yes,
So which one of these was that vote?
2018.
2018, okay.
Okay. I think.
Right. These are things that should be in person. She voted absentee in November. If he really doesn't in person, then she voted in person.
Is the clerk's office still open?
Probably for another 30 minutes.
Well, the voter registration office records voter history,
So it'd be the voter registration.
unless you wanted to look at the absentee information, and then the election board would be able to identify if anything were entered into the system for an absentee.
So let me ask this question. And I don't know the answer, so I'm looking to our staff to advise. Let's say we gave them additional time to go and get what
That's kind of where I'm curious.
to go and see what there is. And because they seem to think that it's there. So if they go and get it, if we take, how would we handle that? Would we
Under AOPA, we could recess, if that's what you're asking, and we just would have to announce the time and the dates that we're coming back.
Okay.
The 29th deadline.
Well,
Yeah, that's a good point.
We can't
Yeah,
suspend
and
the rest of the call.
the other thing that Brad was just pointing out is we also could do a motion to reconsider at a later date and time, obviously before the 29th, so not a lot of later date and time.
Personally, I
but,
would
you know.
rather table it if we're doing that and not make any
Yeah.
sort of judgment on it. That way it's not of record precedent wise.
I mean, I would be very curious if they did come back with stuff from Marion County. I mean, that opens a lot of stuff. But this is the only case we've heard, even including the last time we went through this, where someone had some competing data that said they did vote in some primaries. And if they go to the clerk's office, like, nope, this is what we got. It's the same as SVRS. That's what we have. Then we have to go on that, I think, is what the consensus is. But if there is some data that the clerk says, oh, there it is.
So if
That
we
would
don't,
create an interesting.
if we don't vote on this, take no action, the challenge fails, right? So if we get evidence,
That's what I was saying, you could table.
if we get evidence that you
Table it
distributed.
in recess.
Yeah, if we table it, yeah. If we table it and we don't reconvene by noon on the 29th, then the challenge is denied. Dead, I'm sorry, dead. So, so we could give them a date, a time, whatever, deadline to get us that information, which they can send into staff. Staff could disseminate it to us via email.
But we have to meet to take action.
Well,
So
we
would-
just
So the
did.
easier, I mean,
And be careful about ex parte talking when we're not in.
Let me
meeting.
ask you this.
Yeah.
So if there were record at the Marion County Clerk's office that these primary votes did occur, could you do any type of contingent motion that says, should those records be produced prior to the 29th at noon?
I didn't see anything about that in
Okay, so
AOPA.
we would have to come back and vote on it as a matter.
I believe that's correct, yes.
Reconsider the
Mhm.
matter.
Okay, I'm gonna move that we table this, that I guess this is a question for staff. Can we order that evidence be served upon the parties? That if there's no evidence, that they let us know so that we don't have to come back?
I don't think that's how, I
Okay,
don't
we
think
can't
that's
do that?
under AOPA. As, I will be honest with you, Matthew and I have said, this is pretty much the only time that we're doing AOPA here, but I haven't seen anything that would authorize that, so to speak, in AOPA. I would say that we still have a couple more matters and they're down the street, so if you wanted to give them the grace to go down there and see what they could find out, and come back within the hour, that would be another option.
Move to table this
Right.
matter.
Go ahead.
We have a member of the Marion County Board of Voter Registration in attendance, staffer in attendance today. What time, and I'm looking over here at Rick Sutton, who's like glaring at
Can you
me.
go over and facilitate this?
What time?
The office closes at 4.
Okay,
Okay.
can
so
we
that-
move to table this matter for right now?
Could someone call over there to see what they can pull together so that the parties could pick
That would
up what
be-
they need and bring it back to the
That would be
office?
appreciated. All right, so how do we do this? A motion to table for 30 minutes?
The table for, well,
I think that would be appropriate if you want to say that we'll move this to the end of the business of the day.
Just move it to the end of the
Yes, that's how I would
final
handle
agenda
it.
item.
I move to table this until, or to move it to the end of the agenda.
Yes.
second.
All those in favor signify by saying aye.
Aye.
Okay, you got 30 minutes.
Go
Can
Ryan.
Make the best of it.
Can they-
email the records over?
That's actually a question for the commission and I guess for the attorneys and both
I'm sorry, I didn't hear
parties.
the question.
If you hold one moment.
Are you comfortable with receiving email from their office to
Oh.
print and consider?
Yes, there's nothing in AOPA that would prevent us from doing that, so I am
I'm certainly
comfortable.
fine with that.
Okay. And I think, I mean, besides Mr. Sutton, Mr. John, or Ms. Anderson could call over to the Marion County Voter Registration Office and speak to the Democratic and Republican co-directors to pull together the records. No, just, yeah, they could make a copy of, out of SVRS and
They're there or
email
they're
it.
not, right? I
email
mean,
it to
so,
us.
Yeah.
I would say that
That
Mr. Co-Cheever and I both have our computers, so if you could, if they do find something, if they could email it to Matthew and I both, that way we could each share it with our respective members.
Okay.
Is there any vote history?
Next, we have Camp versus Bonahum, case 2024-27, in the matter challenge to Zachary Otto Bonahum, candidate for Republican Party nomination for State Representative District 82.
And just for the matter of the record, during our last recess, we got a notice of appearance on behalf of Mr. Bonahum from a Mitchell Harper.
Mr. Harper,
He is here in the audience, and this won't appear in your binders, but both Council Co-Cheever and I both have a copy of it for the
Okay.
record.
So noted.
And then let me switch.
And I believe you also have a notice of appearance for Christine Bohm in
Yeah, I
lieu of
probably
Derek
will. Give
Camp.
me just a second. Sorry, this one wasn't in the binder, so I'm kind of out of order here. And so
Oh,
what
here.
yeah, actually, this is, Matthew, is this a you challenge?
No, this is a
This is
Republican candidate.
Okay. Yes, it
Got
is.
that off there.
Okay. Oh, here we go. Sorry. The challenge is right here. It's in the binder. It's a Can 1 challenge that he does not have the 2 primary vote history, as his most recent primary was Democratic. He also doesn't have his county chair certification to run. You have printouts from the statewide voter registration system with his voter history. And then let me see here. And then an appearance from Mrs. Baum as well. And then notice to both of the representatives and the Can 2.
Okay. Well, on behalf of Mr. Camp, Mrs. Bone, go ahead.
Christine Bohm, Christine Bohm. Mr. Camp originally filed the challenge against Zachary Bonahum for State Rep District 82 to primary rule, and he voted in 2020 as a Democrat. So, and no county certification. I think this one really is easy. So.
Okay. Okay. Do you have any cross-examination, anything she had? Okay, please proceed.
We just had a friendly conversation. We would both like to get back to Fort Wayne before Central Indiana gets pummeled, because I think it's supposed to not. Mitchell Harper, Fort Wayne, Indiana. Representing Zachary Bonahum, who is can be available on telephonically, but I don't think that's necessary. As I can see from the commission, it's pretty strictly ministerial when it comes to these complaints. Mr. Bonahum's entire voting record prior to this, except I think in 2008, where there was a hot Democrat primary, is all Republican. And in 2011, he was the Republican candidate for city clerk. I ran on the same ticket with him. He and his family did yeoman's work doing telephone calls. His dad is currently the Republican city council attorney and himself a former candidate for city council. And Zachary Otto Bonahum's grandfather, Otto Bonahum, well-respected attorney in Fort Wayne, was a Republican state representative elected in 1962. His oral history is available online through the State History Museum and is very interesting for anyone to listen to. And Otto is very, very sharp. The Bonahums are a well-known and longtime Republican family, well-known because they're from the Middle East, from Lebanon, along with Syrian immigrant families that came to Fort Wayne in shortly after the turn of the last century, and part of a large number of contributors to our community. I would just say, I wanted to refer to, and this may be a Pyrrhic victory for the challenge too, but I want to refer back to something that was said during Martin versus Nicholson, where it was said that it's instructed that challenges have to be filed, that it is not the election boards or the clerks who automatically check voting records on primaries and throw out people trying to file for election. That certainly was not true in Allen County in 2014 when Joe Kelsey, the current Republican mayor of Woodburn, attempted to run for delegate, and his candidacy for delegate was thrown out because he didn't meet the 2 primary rule. 2 years later, I understand the county clerks of Indiana were instructed at their annual meeting that that wasn't to occur. Challenges needed to happen. The whole process of election law changes since the mid-1980s, from 2-year to 4-year precinct committeemen, staggered elections, 2-year to 4-year elections for county chairs, free appointment across the county for anyone to be a precinct committeeman when it used to be restricted to the precinct and then was expanded to the ward or township. It's been a long, long course to where we are today, where all sorts of folks are not being listened to. And I think the young lady that came before, she should be taken at her word, or you're going to end up disenfranchising not only young people who are 18 or 19, and it's a legal impossibility to vote, or young persons like her who follow their athletic pursuits out of the state. Having said that, I'll close and let the commission make their motion.
Do you have any cross-examination? So, Mr. Harper, one quick question. You don't dispute that in the 2020 primary election, you voted Democratic?
He voted Democrat. I think we probably know why, because it was a little more interesting over there at that time.
Okay. Anybody else?
No county chair certificate.
No.
Here? Okay.
Does anybody want to make a motion?
I would move to uphold the challenge.
Is there a second? Hearing none, I'll offer a second to that motion. So we have a motion and a second to uphold the challenge in cause number 2024-27. Any questions, discussion? Hearing none, all those in favor signify by saying aye. Aye. The ayes have it. The motion carries. To uphold the challenge, the election division is directed not to include Zachary Otto Bonahum in the certified list of primary candidates sent to the county election boards and indicate the name of this candidate not be printed on the ballot. Hathaway versus Bro, cause number 2024-28. The matter of the challenge to Gene Bro, candidate for the Democratic Party nomination for State Senate District 34. Mr. Coach. Matthew.
Yes, I'm sorry. The hours are getting to me. Mr. Chairman and members of the commission, you will find in your meeting binder under this cause a Can One candidate challenge filed by the challenger. In addition, it's just part of the record, but we did receive an email from the challenger asking to essentially dismiss their challenge. But then hours after receiving that email, we received another email from the challenger saying that they were rescinding, I'm going to use the word rescinding that request. Beyond that is the other standards items that have been in this binder, a copy of the candidate's declaration of candidacy and the receipt showing they filed their statement of economic interest, notice of hearing, and the documents from the division showing that the notice of hearing was sent to the parties.
Okay, are all the parties here? And is the challenger who ping-ponged back and forth on email here? Mr.
Andrew
Hathaway?
Hathaway.
I move to dismiss the challenge.
Second.
I have a motion to dismiss and a second on cause number 2024-28. Any discussion, any questions? Hearing none, all those in favor signify by saying aye. Aye. The ayes have it. The motion to challenge is dismissed. The election division is directed to include the name of Gene Bro in the certified list of candidates to be printed on the ballot. Roy v. Dossett, cause number 2024-29, in the matter of the challenge to B. Nicholas Dossett, candidate for the Republican Party nomination for Warwick County Superior Court 2.
In your binder, you will find the Can One challenge. The challenge to Mr. Dossett's candidacy is that he does not meet the requirements to run for the Republican Party. It says see attached. They're challenging off of primary vote history or lack of chairman certification. There is a printout of his SVRS record. We've got the Can Two Statement of Economic Interest notice served to the parties as well.
Okay. I recognize Mr. Roy, the challenger, for your 5-minute presentation.
Thank you, Chairman and Commission. My name is Brett Roy, B-R-E-T-T. Last name is Roy, R-O-Y. As indicated in my filing, I'm challenging Mr. Dossett that he has not voted in the last 2 primaries as a Republican, nor has he ever voted as a Republican, according to his SVRS, and I don't believe he has the qualifications of the certificate from the Republican chairman, Mike Griffin. So with that, I would ask that you remove him from the ballot.
Would you like to cross-examine any of the statements that were just made? Okay, you have 5 minutes.
I appreciate it, Chairman, Commissioners.
Do you dispute any of the evidence that's been provided? Yeah, sorry, state your name.
Sure. Bronson Nicholas Dossett, B-R-O-N-S-O-N. NICHOLASDOSSETT. I do not dispute what was put in front of the commission, though I do have an argument as to what was it? The election code that's been at issue in the Rust case, and that I think most of the cases put forth in front of the commission today. I did actually vote as a Republican, contrary to what was just said. I actually voted in the 22 primary as a Republican. I pulled the Republican ticket.
It's not reflected in this.
That's it. I didn't mean to interrupt. I apologize. I do have evidence as to that vote that I would like to present.
Sure. I'd like to see it.
I'm marking first as Exhibit 1, the certificate of error.
But even that being the case, it's only one, right?
Yes.
In the previous primary, you would agree with the state voter
Correct.
system.
I agree, and I do not contest the fact that even if this vote is counted, it still is only one. I do not meet that prong of the code. Okay. But what I would like to do is, if I can, address that vote specifically, because when I originally spoke to the party chairperson in Warwick County, what I was told was, as long as my most recent vote was on the Republican ticket, then he would write me in. That's what I was told.
Did he write you in?
He did not, because it is not reflected in my voting history. And so the first thing I would like to do is see if I can address that first. That is the certificate of error that I've provided, showing that there was an issue with my vote on that day. Secondarily, I'm marking on exhibit number 2.
All Exhibit 1 says is that you were not on the poll list.
Correct. So exhibit number 2 shows why I was not on the poll list. It's the reason for me not being there. And in fact, at the time I lived in Vanderburgh County, and about halfway down the page, it says pulled in error by Warwick County. Meaning that when I went to vote at the place that I had voted for the previous 4 probably elections, Warwick County had erroneously pulled me as a registered Warwick County voter when I had not lived there for 6 years or longer. Actually, what I'm marking as exhibit number 3 is the acknowledgement notice given to me of my registration in Vanderburgh County, which again just shows that Warwick County pulled my vote, pulled my status as a voter in error. And the last exhibit that I will provide, marking as exhibit number 4, is a copy of the certified minutes from the Vanderburgh County Election Board, where they address my vote, and I would point you to page number 4. And I apologize for clearing my throat. I'm still getting over an illness. Page number 4, I have highlighted where they actually specifically address my vote at the election meeting. And it says in that paragraph that the 2 counties essentially talked to each other, that they had fixed the issue with my vote, and that, quote unquote, I was able to vote normally. Now, I cast that vote. I went to the same poll I always did. I pulled the Republican ticket because on that ticket was a primary race between 2 prosecutors. And at the time, I was a major felony public defender in Vanderburgh County. It directly affected my position. So I voted in that primary because it directly affected me. Now, I never knew until I met with the party chair and until he pulled my voting record that that vote was never counted. And I have given you everything to show that I went, I was there, I cast my vote, I was registered to vote. They pulled my, Warwick County pulled me in error. I cast my vote on the Republican ticket, and you have the minutes in front of you where they talk about it and say that I was able to vote normally, and they did not count it. If that vote was counted, I would have been written in by the chair.
Okay, so that's the end of your time. Does anybody want to vote to afford more?
I would appreciate at least a couple of minutes.
Seconded. All those in favor? Aye.
Aye.
2 more minutes.
A couple of things. I would like to incorporate the arguments made earlier on behalf of John Russ. And obviously, there's been a lot of discussion about that. I would also move to incorporate pleadings from the underlying case if the commission would do that. I do think that my position is a little bit different. I filed for candidacy to run for judge in Warwick County. I'm not afforded the opportunity to move to a different county and try to get some other party chair to write me in or otherwise. Also, I do think that the statute, as it pertains to somebody running for judge, the statute requires 2 votes, as we know, on a particular primary, except for judges, the judicial canons control and the judicial code of ethics control that you are not to be political. And in fact, it is unethical for you to do so. So the statute is directly contrary to the nature of the position itself. And so when I have a party chair that tells me that he'll write me in as long as my vote is there, I know I cast the vote. You have in front of you everything that says I cast the vote, and I was put under oath earlier. I have an affidavit that I can sign in open court saying it was on the Republican ticket. I would have been written in if that vote was counted. It was not. That error is not my fault.
Did you go back to the county chair and ask him to write you in?
I did. I provided all this information to him.
And what did the county chair do?
He did not write me in. And the sequence of events is I went, when he ran my record.
You wouldn't deny that that's his prerogative, though, in that position, right? To decide whether to write you in or not.
He decided not to write me in when it got closer to the time for the filing. And so when we had this conversation, this was back in September, what I was told was it's not a no, but let's see how you do over the next few months. So what I did was I went to all the events. I went to the breakfast with the Republican Party. I really like another 60 seconds or so to finish this up.
That was 2 minutes.
Fair enough. He did answer a question. You got 30 more seconds.
Okay, sure. I can wrap it up.
There you go.
I went to every single event. I walked in the parade with the party. I did everything. And then at the end, I was still told no, even though I provided the documents. Now, all I'm asking for is for the commission to take a look at this and actually count that vote, or at least find that I voted, and I under oath and telling you I voted on the Republican ticket. And if that is the case, and if that vote, if the commission can make a finding that I did actually cast a Republican vote, then I know that there's a deadline in 2 days, but I would ask for at least some time to talk to the chair and say, I have a finding from the Indiana Election Commission.
I don't think that there's anything here that states that you voted in the Republican primary, just that there was a voter registration error that was rectified, and according to the meeting minutes, stated the voter should be able to vote about it. Mark Tooney informed the board that the issue had been addressed and the voter was able to vote normally on election day, and a certificate of error had been generated to address the registration issue. I don't see anything that suggests which party in that primary vote that you voted for.
Correct. And that's why I am here, and I have provided, or I have an affidavit that I can sign in open court today, and I am under oath right now, and I am telling you that is where I voted on.
Even considering that to be the case, it's the previous 2 primary votes, of which the previous one was Democrat.
Correct.
And the county chair, for whatever reason, that's up to the county chair, failed to write you in as a candidate.
Right. And I think.
So I'm not sure what would be left for us to do.
Well, what I'm asking is, I can have that rectified if the commission is willing to make a determination as to my vote in 22. That was not counted.
I don't know that we can do that. I mean,
What you're asking is that you be allowed to amend your filing, which, as I've been told, was deadline was February 9th.
Right.
So we can't, as I don't think we have the authority to go back and say, okay, you can come in and amend now that you have this. So, we just don't have the authority to be able to do that.
Okay. And I understand. And so I guess my only question then, if the commission can't or is unwilling to do that, is to make a finding as to my 22 vote, because it will affect me come the next election in 2 years.
You've introduced all this information into the record, of which it is available for public consumption. But what's before us is a challenge. We're hearing a challenge as to your ability or qualification to be on the ballot.
Right.
And that's what we're voting on. So there's nothing really more we can do to make the record than what we've already done.
I understand. This is the only avenue in which I can take to have that vote counted in some way, or at least make a record as to the vote.
Can you go back to the election board and ask, they gave you the error, they said your vote should have been cast that way.
I did ask them to do that.
Okay.
And they said they
you
did
go
not.
back to the poll book. The poll book should indicate.
Still only got one.
I know, but for his future.
Oh, yeah.
Because
did-
of Vanderbilt County's e-poll book, there's no way to push a certificate of error to the e-poll book, which is why they likely did not record or recorded it on other documentation other than the poll list, because it's all electronic.
seems
There's
like
no way to
something that should be
push
addressed.
that information.
And then-
That
and
you,
then-
I mean, you raise a very interesting issue and an as applied challenge. But we're doing con law on this one.
Well, and when I went to vote, obviously I was there. And I did vote that day, but I pulled the Republican ticket, but even on the log, because they went back and looked at the log, there was nothing written because I was pulled in error by Warwick County. So then there's nothing showing.
No, I understand that. Unfortunately, the burden's on you to secure
I
that letter
understand.
from the county chair, and you did not do that. And
I understand.
so anybody want to make a motion?
I would move to uphold the challenge.
Second it. Any further conversation? Any questions? All those in favor signify by saying aye. Aye. The ayes have it. The motion to challenge is upheld. The election division is directed not to include B. Nicholas Dossett in the certified list of primary candidates sent to the county election boards, and to indicate the name of this candidate not to be printed on the ballot. Thank you.
Thank you.
Weingarten v. Banks, cause 2024-31, in the matter of the challenge of Jim Banks, candidate for the Republican Party nomination, United States Senate.
And in your binder, you will see the very first document on this is a wish to withdraw the complaint by Mr. Weingarten. And I do not believe he is here today.
So
Between that, I think based on previous precedent, we just.
motion to
withdrawing.
dismiss it.
Mhm.
Is there a motion to dismiss? Would anyone make a motion to dismiss?
I would move to dismiss.
Is there a second?
Second.
Having a motion and a second to dismiss, all those in favor signify by saying aye.
Aye.
The motion is dismissed. Cause number 2024-31 is dismissed. The election division is directed to include the name of Jim Banks in the certified list of candidates to be printed on the ballot. Do we want to go through the advisory opinion, or do we want to pick back up on that cause first?
I think that we tabled them till the end, so I would go ahead and do the advisory opinion and then bring them back in.
Is that what we said? Okay. Next on the agenda is the advisory opinion request from the Honorable Victoria Garcia Williams, Indiana State Representative, and the Honorable Andrea Hunley, Indiana State Senator. Commission members have received a request for an advisory opinion to be issued to this body regarding a campaign finance matter, which is described further in the material in our binders. Wilbur. Oh, my apologies.
All right, well, thank you.
Hold on just a second. No, I don't think this is a matter that follows hearing procedures, so there's no testimony to be given. I'll make a motion to afford each of you 2 minutes to make a presentation. Is there a second?
Second.
All those in favor? Aye.
Thank you so much. And I know that you all have been doing a lot of really important work today, and we really appreciate
Will
it.
you, for the record, please?
Yes.
Yeah.
I'm Andrea Hunley, State Senator for District 46. And I'm in my second session here. And we have brought before you today a request for an advisory opinion. We know that advisory opinions are granted by this commission from time to time. And we are looking for an advisory opinion on whether or not we can use campaign finances
to provide childcare support or dependent care support. We know that in the past that the Federal Election Commission has approved for federal candidates to use their campaign finances in this way on a unanimous bipartisan vote. And so we are hoping that we can get an advisory opinion in this way. We have talked with the Secretary of State's office. They recommended that this is the route that we take. We don't think that it needs to be done legislatively since you all have the power. And right now, our election campaign finance laws are written purposely ambiguously, I think, to make sure that candidates have opportunities to spend funds as needed. We know that in 2001, it was determined to allow reimbursement here in Indiana for lost wages and salaries of a candidate or their household member resulting directly from campaign activity. And so we feel like this kind of falls in that same vein. And that was done through an advisory opinion at that time. And so we're hoping that this will follow the same suit. We know that having diverse candidates on the ballot is really important. It helps represent our entire state. And we think that caregivers are especially worthy of being on the ballot, and we wouldn't want to do anything to preclude them. And so having this access to campaign finance funds in this way will help make candidacy a little bit easier. So we would appreciate your consideration of this. Thank you.
Thank you, Senator.
Thank you again, Victoria Garcia Wilburn. Thank you for your time today and the ability to give some brief remarks. And I just want to state, I really appreciate the work done by this committee. I appreciate how broad our election finance laws are so that we can capture anyone that has the desire to run for state office. We're finding ourselves in a bit of a quandary. There's a sandwich generation rising. Many of us are still rearing children while taking care of older adult parents. And so because of that, we feel like it would be necessary to, at this time, join over 30 other states in explicitly allowing dependent care expenses to be used through our campaign finance funds. We know that people that come to Indiana, come to this great Hoosier state, many of them might not have family to assist with childcare expenses. Many of them might be first generation Hoosiers and forming a pathway for others. And so we believe, because we have such a strong commitment to freedoms and constitutional abilities and rights, that this falls right in line with that part of our democracy, allowing more people to get on the ballot. So we thank you for your time and your consideration, and thank you again for allowing for some remarks.
Thank you. And apologies for mispronouncing your name. What was included?
In the binder,
Yeah.
you have the email from the representative and the senator requesting to be put on the agenda today, as well as a letter from them explaining what they just summarized and what they're asking the commission to do, as well as a draft advisory opinion that my Democratic counterparts have worked on and put in the binder as well.
Where, I don't know that I have that.
Go to the very back under advisory opinion. It should have been the very last
Yep,
tab.
sorry. Yep, I got it.
If I might make
Sure.
comment. So after this request came through, I looked at the federal, I thought this was a really interesting question and it's a really important question. And I looked at the opinions from the Federal Election Commission and found them quite interesting as well. And, you know, I support issuing an opinion. I think it is, I can see how childcare, well, being a mom myself, not running for office, I can only imagine how difficult that would be. But anyway, I think it would be, and in looking at our statutes, and I think it is supportable, definitely, without any kind of change in the law or anything like that, that to conclude that the statutes would support allowing campaign funds to be used for child and other, I guess, caregiving, dependent care expenditures. So I would encourage the commission to consider this.
I'm curious as to why this wouldn't have taken form of an amendment or a bill over in the General Assembly during this recent legislative session. Would either of you care to comment on that? I'm asking you questions. Yeah, please.
I believe that pursuing this administrative route is, quite frankly, the best route to go. This is a short session. This is something that does not need to be done legislatively. These are changes within your authority and your power that you're able to grant. And not every single issue that comes up needs to be before the legislature. We can be a litigious society, and we know that not everything requires legislation in order to be enacted. And so we believe this is well within your purview to create this report and opinion.
I mean, to me, it feels like lawmaking, and we're an appointed body and we're not lawmakers. In fact, I would refer to co-counsel, but I believe the last advisory opinion we issued had the caveat that it be considered by the General Assembly for affirmation of some sort. Is that not correct?
Yes, the last advisory opinion did, yes.
But the General Assembly, to my knowledge, has not affirmed the commission's request and any of the advisory opinions, quite frankly, that we've as a body have adopted.
That's up to them.
I appreciate that. But the question was if it
I'm not,
happened.
and for the record, I'm sympathetic to the request. I just, it doesn't feel like it's parked in the right parking spot.
We've given advisory opinions before, and I don't know, this one is particularly worthwhile because this deals with families. And why we would hesitate to give an advisory opinion on an issue like this one. When I was sitting on the city council, working full-time, doing my council job, I had no children. But I sat there and I thought, oh my God, what if I had to come home, clean house, get dinner ready, take care of the kids, go to do my council meetings, all of that. And particularly if I was a single mother and I didn't have that disposable income to be able to do all of that. Now, this doesn't cover them for once they get into the job. But during campaigning, which most oftentimes is at night and on the weekends and all of that when the children are home. So I don't think it's unreasonable to do this. We have some of the worst and broadest campaign finance laws in the country, and the legislature still hasn't done anything to change those. So if we can provide clarification, and if the federal government can do it, and if 30 other states can do it, then I think that we should step into the fray. Now, if you're concerned, I know that Susanna's done a great draft here, and she has looked at the federal campaign, and that was an advisory opinion. So I think that if we really want to do something for families, then I think that we need to step up and provide this assistance.
I'm going to give credit to Matthew. Matthew did the actual draft, did some heavy revisions. I shouldn't say heavy revisions, but.
Just as far as this goes, I have major support of the concept here. That I do a lot of guardianships. I have a 6-month-old. I mean, I'm here with you on this. You're sitting here as 2 members of our legislature, and I don't know that adding a caveat that the legislature should consider this is going to be an issue. One of you can bring it next. We can pass this. One of you can bring it next session. I mean, I don't think that that's an issue to amend it in that way if that's what we want to do.
Well, the only other thing too, I think if I read this right, this goes a little bit beyond what the Federal Election Commission did. I think the FEC, correct me if I'm wrong, in my brief Google search, was limited to child care, and I believe what this is caregiving, which goes beyond that. So to Litany's point, I suppose I could get comfortable given that we include that, amend that language to have this affirmed at the General Assembly, but I would also want to more strictly or closely model what the FEC has done in that light. I suppose any of the can be changed around once over on the 3rd floor, but those are just my thoughts.
Having thought that you might have that thought, behind door number 2, oh wait, which version 2 is? Version 2. Yeah, version 2 is door number 2. Yeah, it's like a cooking show where, no, let me get it out of the oven because it's already here. We've got copies for everyone right here. Here's. So this is an alternative version of the advisory opinion that would limit it to child care.
It's like it's written the same.
Well, you have to keep going. Like, yeah, I know, that's why I had
Defined
to
as
ask
care
the
and protection,
question.
supervision of a child or other person with a disability.
It's, page 2, section 1. Well, it's actually section 2. Because we limit it then to childcare, and then in section 3 limits it to childcare. So the first is the intro talking about what they're requesting, what the FEC did. So that's the same. But then when you get to what we actually do, section 2 and 3 limit it to child. Well,
It's not limited And then section 6, the commission respectfully recommends to the Indiana General Assembly the policy supplement copied by enacting appropriate.
which is what we did with prior advisory opinions.
And I would just note, advisory opinion 2001 does state that we're going to issue this advisory opinion to clarify campaign finance expenditures pending legislative action to address Indiana code. And that pending means that here we provide you with guidance until such time as the legislature decides to take action. And we have precedent that that is what we have done. I'm not aware of any other advisory opinion that says, here's an advisory opinion, and by the way, it doesn't take effect until the legislature ratifies.
I believe that our last advisory opinion about the voting machines and tabulation said that we wouldn't take any action on voting machines until the General Assembly did.
That we wouldn't take any action, but
Yeah.
that's different than saying that setting forth an advisory opinion that says, oh, but this doesn't take effect.
So
we just basically said that we weren't going to certify those equipment.
Yeah.
legally, from your interpretation, what does section 6 do? I mean, this looks like a respectfully recommend, doesn't.
It's consistent if you look at advisory opinion 2001-01, when we, as a commission, interpreted 3934, the very statute that's at question here, about whether or not it was appropriate to use campaign contributions for a salary. That's not been codified, and the commission gave candidates the ability to collect a salary because the commission interpreted the statute. And so the language in section 6 is commensurate with the language in 2001-01, where the commission interpreted the statute to allow for salaries, and then asked that the legislature consider this in the future.
And if the legislature doesn't like our advisory opinion, that may spur them to take action faster.
Oh, wait, so now that I read this, so this means that this looks like this wouldn't be saying that they could use campaign funds for these expenses right away.
Yeah.
We're saying.
Yeah.
That's what I'm trying to figure out.
Hey,
Now I'm
Mr.
confused.
Chairman.
Yes.
Mr. King and I were discussing, and I believe our interpretation is that this would allow the election division to send out to the counties that we interpret that using campaign contributions for child care expenses is permissible, and respectfully ask that if the General Assembly go forward and make a policy. So I wouldn't say it's making a policy. I'd say it's our rulemaking either. It's not rulemaking or policy making as much as saying that as we read the statute, that's our understanding.
Yeah. So if somebody challenged it, they can say, here's this opinion is persuasive.
Correct.
Right?
I'm sure, yes.
Correct. It gives the candidates, from my understanding, it would give the candidates that if they needed childcare to attend a campaign event and they did not have access, or they did not have someone to watch their child and had to pay for a babysitter, that they could use campaign finance funds, their contributions, to pay for that caregiving expense. And it provides those candidates some cover that the commission has said that's an appropriate way to spend dollars that have been contributed to your campaign.
Well, it's not just this, and I mean, the FEC opinions and the way this is written too. So it's your own campaign activities for your own campaign, other participating in other campaigns, and then also related to service in an elected office.
Correct.
So
Is
it's not
that,
just-
well, that also, I'm sorry, Commissioner. So section 3 walks through how 3934 is written. So 3934, Mr., could you have it pulled up, Matthew? No. 3934 tells you how a candidate can use their money, and it can be in furtherance of political activity for service in elected office. And so 1, 2, and 3 mirror subsection A, which says money received by a candidate or committee as a contribution may be used only to defray any expense reasonably related to the persons or committees campaign for federal, state, legislative, or local office, continuing political activity, or activity related to service in an elected office. And so section 3 just mirrors that language to say that for those types of activities, you could use your campaign contributions for childcare expenses and furtherance of those events that are permitted under state law.
I'm still hung up on section 6.
Mr. Chairman, section 6 is really, that section was pulled when I was updating these drafts. I pulled that from the advisory opinion in 2022.
Yeah, I saw that. No, this is section 8 of that same advisory opinion.
In the section 8, 2001. My best guess, and obviously I will defer to any other staff, but that has been in parts, some advisory opinions where it's like, you essentially are providing, interpretation. We read this law in this particular subject matter, we find this. We advise folks who have a question about this, that this is how the law reads. But of course, the Indiana General Assembly is the one that crafted this law. It is a statute. And so this section usually just compels, the election division, since we serve you all, to send a copy of this advisory opinion to the General Assembly for them to consider. I will just go back to what happened in 2022 in regard to the voting systems. That's the last advisory opinion where this particular section was located. As I recall, because the General Assembly had already adjourned sine die, the co-directors had sent this a copy of this advisory opinion and this matter to Legislative Council, both to the party leaderships as well, because they sit on the Legislative Council. And to my knowledge, I know they have it, and since it's a separate branch of government, we wait for them to see what they want to do on that particular matter. Conceivably, if this advisory opinion was adopted today, the co-directors may do the same thing and sending this over to party leadership, the Speaker, the President Pro Tem, and the minority leaders of the House and Senate, for them to consider probably in the future, in a future legislative session, if they want to amend the campaign finance at all in regards to this advisory opinion, or possibly do nothing, which I would assume has been the case from that 2001 about salaries, since we have nothing about using campaign finance dollars to cover salary or lost wages written into the actual code itself. We still use the advisory opinion.
As far as this being rulemaking or anything, it's not, because it clearly states it's an advisory opinion. So we send it out to the counties and we say, here for your consideration is how we would interpret this provision if a challenge was made to us regarding this expenditure. Now, it's not part of the law, so we're inviting the legislature to address it. But it's an advisory opinion. That's all it is, providing some guidance. And it lets these folks here sitting in front of us go ahead and make that expenditure for childcare. And they've got a little bit of cover because they can say they acted in good faith. They weren't.
No, I understand that, but the point you're making is that lawmakers ultimately should deal with, and that's where I'm starting with.
No, I'm not saying that. I'm saying that lawmakers should
How many
deal with
different
a lot of
doors
things.
will open for advisory opinions on campaign finance where they're perfectly suited and capable. They're ones that made the laws in the first place. We're a
Well,
construct
but
of
we,
that same
but we
legislative body.
interpret the laws all the time. Now, the ones we've been interpreting today are kind of, they're black and white, and so it's a lot of.
I don't know that this is necessarily an interpretation other than a judgment as to what we think is allowed.
But that's exact authority that we have been given. We have been given the authority to issue advisory opinions. If we were setting forth the law and we were telling the
I don't
counties.
debate the authority to issue an advisory opinion. I'm
Okay.
talking about what's in this advisory.
Okay, well, but this is an advisory opinion. What about this is not an advisory opinion?
My point is, it feels like this should be a legislative matter and codified in law by lawmakers.
Well, if you could identify what part of this do you think exceeds our authority to issue an advisory opinion?
I think we'll also mostly, sorry, can I take a crack?
Yeah,
at it?
sure.
Sorry. So I think when it comes to election law in a way, I mean, for the administrative law judges who have the authority to deal with election law, we are in other types of statutory interpretation. It's, if you have a question about a statute, that goes to the courts. But we're the ones tasked with election law. And right now, I mean, so the way the code is written, it says that right now it says that the money received by a candidate, and this is in the fourth whereas clause talking about 3-9-3-4A, and it says they can use the money to defray any expense reasonably related to the person's or committee's campaign, continuing political activity, the language Angie read before. Well, what's being asked of us is to interpret what any expenses. And that's what a court would be asked to do. I mean, a court, because you wouldn't, so it's not adding language, it's we're being asked to interpret what that language as written means, which is what a court would be asked to do and is often asked to do about any other statute. So we are being asked to determine whether any expense, whether a childcare expense can count as any expense that's reasonably related. So this is asking us to provide an interpretation of what the existing statute says, which is what courts do all the time.
Right, and I guess my point today is, it doesn't say that you can't. We're issuing an advisory opinion to create some level of cover. To me, that is ripe for legislative clarity.
Which they could then do, because like what the court, so if the I don't want to talk about the Russ decision again. But if a court decision came out saying, so if someone challenged, let's say someone were to challenge the two primary rule. Let's say one of us were to challenge it because we decided that it makes our lives too difficult.
Right.
So they go to court, get a court to issue an opinion about, saying, oh, well, that two primary rule really means X, Y, and Z. It doesn't mean A, B, C, it means X, Y, and Z. Well, then it's up to the legislature can then say, no, court, we don't like what you said. We're going to change our statutes to make it more clear. Just like the Attorney General issues advisory opinions about what.
Well, and I guess that's where I keep coming back to how we've worded Section 6. Commission respectfully recommends the Indiana General Assembly.
Would you be more comfortable if we struck it?
No. No, I would not.
Would you?
How did we write it in the voting system? What was our caveat to the General Assembly there?
Pending, right?
Just a second.
Something along those lines would make me far more comfortable with this. Oh, sorry.
Did you find it?
Yeah.
What does it say? Matthew.
Yeah, if you've got it, go ahead and read it,
I have the commission, I have that one pulled out. So I could read you Section 8 of Advisory Opinion 2022-8, that's the voting system.
Yeah, what did we say?
And I'm pretty sure I copied this verbatim, but Section 8 in the voting system one, it said, Section 8, the commission respectfully recommends to the Indiana General Assembly that the policy set forth in this advisory opinion be codified by enacting appropriate remedial legislation.
So that is how we work.
Same thing.
Does this require a unanimous vote or majority? Okay.
No.
Well, I've raised my concerns. If somebody wants to put together a motion, I'll entertain it.
Well, do we need to say, move it and see how it goes and then we read it in if it's approved, or do we have to read the advisory opinion in?
We don't have to read it. Right? Can we do a consent to just adopt it, the written copy?
Well, I'm just wondering
Larry,
why.
what do you think about that?
I'm sorry.
Does this,
I
does this,
believe we could do a consent to
does
adopt.
this opinion need to be read into the
Okay.
record?
Okay, so we don't have to read it. Okay, so then I would move to adopt or issue proposed advisory opinion 2024-1 that I distributed to the commission members during the meeting. Well, no, it's the one in the binder said X, so this is
okay.
2024-1.
Oh,
Yeah. no,
I second.
We have a second. Sorry, we have a motion to approve advisory opinion 2024-1 from the Election Commission. We have a second. All those in favor signify by saying aye.
Aye.
Aye. The motion or the advisory opinion passes. Refer to the general.
Oh, and
I
then-
would
Do you
move
want
that
to
we,
consent by stamp?
I would move that we consent to allowing the hard copy to be put into the record rather than sitting here reading it.
Second.
Second.
All those in favor? Aye.
Aye.
So in the record by
And Mr. Chairman, earlier, the commission voted to authorize the use of your signature stamps, and we assume that applies in this case as well.
Yes.
Yes.
All in agreement?
Yes, we agree.
Consent, yeah.
Okay.
Thank you. Thank you both. Appreciate your time. Almost went there. Mr. John, are you ready? What was our, did we table it?
Yeah.
We
How do you
did.
pick it up off the table?
Make a motion.
Okay, is there a
Lift it up.
motion?
We're gonna lift it
What-
up.
what- I don't even remember what the cause was.
I think
What's
it's,
the name?
is it a, I just found it. I think it's 2024-24.
I believe that's correct.
It's at Anderson versus Graves, right?
Graves, that's what it was.
So, Mr. Gray.
Hold
for
on a
council-
second. Give us a second.
A lot of papers.
Sorry.
Is there a motion to pick up cause 2024-24 off the table?
So moved.
Second.
Second.
All those in favor signify by saying aye.
Aye.
Aye, the ayes have it. We're back in business.
So,
What did you learn?
Councilor Graves went over to the election board and just have him report back.
Sure. Please. Just one more time for the record.
Keith Graves, Indianapolis City Council, KEITHGRAVES. Mr. Commissioner, I want to say thank you for being gracious today. We really appreciate this opportunity.
Yeah.
We
We're
found
anxious.
some, yeah, we did find some things out that were more alarming than for additional proof. Primarily, we understand that what we saw on that June date in 2012, that is in today's world, there is about a 7-day delay in getting things registered. So when we see something that says June in 2012, back in 2012, there was an influx of a huge influx of new voters because of the Obama timeframe.
A lot of
So
registrations, yeah.
that delay, because today we're more technologically enhanced, so we may be at a 7-day delay, but then it could be 30, 60 days to get registrations. So what you see is absolutely not giving us a clear path to proof. And so that was one of the more alarming things. So we said, hey, can we find the paper documentation and where is that held? And they said, yeah, we do not destroy anything, but we don't know where things are. So we really can't help you. So I stand here just to say that we have more than proven that she's voted many times, possibly in Indiana many times in primaries. We do see the 16, the 18, and the 20. The question is where those were. We do know that 12 per her testimony. So we did do the effort. They were unable to give us a paper document. So
So
unfortunately,
you didn't find anything that would contradict what was on the SVRS
yeah,
voter
right.
record? Okay.
Absolutely. And SVRS is a 2018 future item. Prior to that, it was something that in 2012, we were looking for the paperwork. So what I understand is that 2018 is when the reliance on SDRS. Well, it goes back to, I think, 05 or whatever, but it was a 2018 date that was kind of a stamp in time. So I think what we really learned, Mr. Chair, is there's a lot of conflicting information and it really can't pinpoint. I want to say that there was a delay in getting registrations registered for documentation and timestamp purposes. There is also the COVID year where she did have 2 residences. I'm her dad and she came home and I definitely was happy about that. We saved a lot of money. She was pursuing her master's degree at Pepperdine in California. So we wanted her home where we can make sure she was safe from the pandemic. So that threw a little monkey wrench in her registration because our family votes Democrat. I am an elected Democratic leader in this city. I've been voting Democrat since the 80s. So I'm extremely proud of my record. I know where my family's record is. There's no question. We have demonstrated proof that she's voted Democrat. She's voted. That's all on the documentation that we provided.
Okay.
Thank you, guys. I really appreciate it, everybody.
Would
Any
you like to
questions?
cross-examine based on their testimony? You have 2 minutes. Well, I think you've already had your opening allotment of 5 minutes. correct?
Yeah, I think. No. She gets 2 minutes to cross. I'm sorry, what were you saying?
We'd only been doing 2 minutes of cross-examination with the final rebuttal by
Right, 2-minute rebuttal. This was the cross.
the cross-examination, which would limit her comments to questions relative to the testimony provided by Ms. Graves. Yeah. Well, it would be a cross-examination, so you have 2 minutes to ask any questions to Mr. Graves or Ms. Graves relative to their testimony.
The other side gets.
No, they get the rebuttal.
No.
That's a rebuttal to anything you raise in your cross-examination.
Okay, question, okay, Stellance, I have a question. You said that,
I'm just trying to be
they had no
consistent. Sorry.
documentation of her, registration in 2012.
They could not provide us with that paper documentation, which indicates what you see in your hands is an indication of when it was timestamped. But there's a date that was received. And there's a delay. Even today, there's a delay, 7 days.
Right.
But back then, it was an influx of registrations, and then there was also not as advanced as we are today in technology. So there could have been a 30 or 60 day delay.
Okay, what I have here in my hand is dated 6/19/2012. That's dated. That's after the primary.
Ma'am, I can barely hear you.
Okay, so what I have here, documentation showing that it was dated with her signature on 6/19/2012. Okay, and evidently it was posted on 6/27, which is approximately so many days after that. Doesn't say the date received, yeah, not received, yeah.
So let me interrupt here. So I think there's the 2 standards we're trying to get to is, do we have proof that you voted in 2 primary elections as a Democrat here in Indiana? Or did you secure written permission to qualify you on the ballot from the county chair? We don't have the latter, correct? And I think what we did was afford you time to go over to the Marion County Clerk's office and see if we could produce any evidence contrary to what we see on the statewide voter system. And what I've heard you say is you were unable to do that for whatever reason, correct?
Yeah, because they could not produce.
Yeah.
And I would like to explain something too. The June 19th, which is my birthday, 2012 registration was done online. So that's the date that you actually submitted. This is an online registration form. So, and the 7-day period that they were telling you about is a period of pending. So anybody who files new voter registration, it pends for 7 days, but that's not the day that you submitted it. And because that day you put on there what date it was. And the deadline to register to vote was actually in April. So they weren't running that far behind. But that's
Well, it's almost not relevant though, right? Because
Yeah.
one's about registration, the other's about proof of voting. in
right.
the
But
primaries
I
for the
wanted them
Democrats.
to
So,
understand because
Yeah.
this is the whole problem with our whole, it's so complicated now. We keep talking about voter integrity, and this is what we've come to. It's a hard thing to understand, as your attorney can tell you, I'm sure. So, yeah, but Mr. Chair is right. Chair is right. You have to be able to show that you voted.
Yeah, for the record, I find absolutely no fault. I believe everything that you're saying, but we need to have some level of evidence that says, hey, we made a mistake. You did vote in these 2 primaries. Here's documentation.
Chair,
right? That would have been
members of
compelling
the
beyond.
board, if I may,
Yeah.
I am uncertain as to why the documents there do not reflect my honest voting record. But if the premise of the law is to determine my party affiliation, then as you can see, and based on the numerous amount of boards I serve, community engagement, activities I'm in, and just my civic duties alone, you'd be able to see which party I'm aligned with.
That's absolutely correct, but that's not the premise of the law. The premise of the law is your ballot eligibility is predicated on one of 2 factors. One, that you can prove that you voted in 2 primaries under the party affiliation of which you describe, or you've got a letter from the chair that says, hey, don't worry about it, you're good to go.
And it seems as though then the data itself, as well as the paper records, it seems as though there hasn't been a good record keeping. And so if we're relying on the record keeping and to show you all that evidence today, it seems as though there's been an issue there, as you can see.
I'm not in a position to disagree with you. That might be the case.
And so
but we have to go on what consistently we've applied all day long, which is the ability to prove one of those 2 factors. And your challenger has filled out the proper challenge form and stated that you did not vote in 2 prior primaries under the party affiliation. And near as we can tell, that's a correct assertion.
Ms. Graves, I think what gets confused in all of this, and again, I'd be home if it weren't for this law, but what gets confusing in all of this is that people come in here and think that we get to determine if you are affiliated with a particular party, and that's not what we are allowed to do. All we can do is apply the law, which says you have to have voted in 2, the last 2 primaries you voted in as a member, pulled a ballot for that party, or that you got the signature of the chair. You could sit here and show us that you've given millions and millions of dollars to a party, that you've given your child, your life, your dog, everything else to the party, and we still can't say that you are a member of that party. The only thing that the law allows us to do is to make a determination as to whether you satisfy the party affiliation requirement is by whether you voted in those 2 primaries or you have the signature of the chair. That's all. You can show us all kinds of things, and certainly the stuff you've shown us, you are very active. But we can't take that into account. We're very limited. Our vision is like this when it comes to that.
By no means do I dispute your party affiliation. Right. That's not what's at issue. Yeah.
Thank you for your time.
Thank you. I appreciate you taking the extra time to go see if what you could find. With that in mind, does anyone want to make a motion?
I would move to uphold the challenge.
Is there a second?
And I will second it, and I hope that you will keep trying.
We have a motion and a second on cause number 2024-24. Any other comments? Discussion? Hearing none. All those in favor signify by saying aye. Aye. The ayes have it. The motion carries. The challenge is upheld. The election division is directed not to include Junie L. Graves in the certified list of primary candidates sent to the county election boards and indicate that the name of this candidate not be printed on the ballot. Thank you all for your time. think with that, safely say we've completed our business for the day. And I will accept a motion to adjourn.
I would move to adjourn.
Is there a second?
Second.
All those in favor signify by saying aye.
Aye.
The ayes have it. We are adjourned. Thank you all for your time,
My favorite.
patience, and commitment.
And with that, ladies and gentlemen, we've conducted another long Indiana State Election Commission broadcast. Coming in at just 2 hours under last election, under the 2022 Election Commission meeting. Last year's wasn't that long. Last year they did not have. Last year the state did not meet because it was municipal. So 2 years ago, which would have been the last meeting, was just about 8 hours. So we suffered through a long day, but we came in about 2 hours short. Thank you for those of you that have stuck around and watched and came back and went out and came back. Thank you all very much. Remember, ladies and gentlemen, we will be live tonight. We will have live commentary at 9 p.m. this evening. Do not forget to tune in because we will have a lot of content. A little bit about this, a little bit about Randolph County, but we're going to have a lot to do getting back to what we do here. We're going to be giving commentary about the Delaware County Council meeting that occurred today. And ladies and gentlemen, it's a show for sure. So you're going to want to tune in right back here at 9 p.m. Eastern tonight. And we'll be doing that. And then tomorrow, do not forget, at 1 p.m., that will be the part 2 of the Delaware County, Indiana Election Board meeting at 1 p.m. in the old Delaware County building. So stay tuned for all of those wonderful programs that we have coming your way. Thank you all very much. God bless each and every one of you. Stay safe until we see you tonight. And thank you for being here and viewing with us. And we'll look forward to seeing you all this evening. Good afternoon, and we will see you tonight. Goodbye.